Hey, good morning, good afternoon, good evening, everybody. It's me, Legal Vices. We are now in day 4 afternoon session of phase 2 of the Taylor SCHABUSINESS trial. This is the insane or not phase. That's what we're looking at right now. Right now, they're in the process of determining whether she was insane at the time of committing these murders. She's a convicted murderer now. She's been convicted of murder, but are we going to forgive her? Are we going to say she should not be held responsible for the killings because at the time the killings were committed, she was legally insane? That's what we're deciding now. We've heard the defense's arguments as to why they should find her not guilty by reason of insanity, and it wasn't good. It wasn't good at all. It was all kinds of bad. The defense lawyer was just absolute garbage, which is sad. He was good, he was decent, he was competent, he was okay up until the closing argument. Then he's just been competent-ish. Bad arguments, bad witnesses, bad things, all kinds of bad things happened. Yeah, questions were terrible. His emotion level was just drained. He was just done. His first witness was Taylor SCHABUSINESS's dad. The idea was to say that she's been traumatized since the death of her mother in, I think it was 2012, but he didn't really testify to that. It was just kind of, yeah, she acted up as a teenager. She stole someone's musical instrument in high school. Yeah, and she got into some drugs at some point, but other than that, she's not a bad kid. But also her father has the problem. The jury doesn't know, but they did bring him in prison orange, all chained up. They brought him in all chained up. So the jury knows that he's in prison for something. What they don't know probably is that he was sentenced today. Basically sentenced today. Or yesterday, I guess it was yesterday or today, for second degree sexual SA of a child. Yeah, SCHABUSINESS's dad is in prison as of today, sentenced for doing really, really bad things to a really, really young child. So that was the defense's first witness. Their second witness, if you watched my competency hearing we did last Friday, I believe it was, the hearing where they were determining whether or not she was competent to stand trial. The crazy old cat lady psychologist that believed everything Taylor SCHABUSINESS said and testified that she was incompetent to stand trial. Well, that was their star witness. That was the defense's star witness to testify that she was legally insane at the time she committed the murders, and that what she did, she didn't know it was bad. Yeah, and it went predictably badly. She's nuts. I think it even went worse than the competency hearing. So yeah. That's a bad thing. But whatevs. That's all we've got. That's where we are. Yes, as we said, let us know her father is in jail for doing very, very, very bad things to a very, very young person. Yeah, he was sentenced yesterday or today, depending on, I guess, which side of the international date line you're on. The court has not come back yet from lunch. They're still showing the seal. We'll bring that up when it's time to go. And let's see. We're ready to go. I think we're just kind of waiting for the jury to show up. Xcomer Triple Z bringing the fitty North Korean krona. Jeffrey Dahmer, Jeff Vices. I think I'm onto something here. Dun, dun, dun. Could be, but probably not. And way back in the day, Iris in Texas sent a $5 super chat. We had Law Talk with Mike on the earlier stream. She sent a super chat, said, Mike, she's single. Take her to Cuba. You can fix her. And Christina M. Quiroz, who has been a member of the Clean and Sober crew for 4 months, said, wanted to say how much I enjoy your videos. Love you, Vices, and good luck this afternoon/morning for you. Yeah, we're a little bit tired. A little bit little bit tired. So I didn't take a nap because if I took a nap, I wouldn't wake up. I got 2 hours of sleep yesterday. I figured out that since Monday morning, I've had, I think I said 6 or 7 hours sleep. We're just doing it for this 1 week, and I am going to do nothing but sleep all weekend. So we'll be good. We'll be good after the weekend. This is just a once-off thing, and we're not going to do another trial for a very long time. Yeah, I hung out on Nick's stream for a bit during lunch because I knew that if I went to sleep, I wouldn't wake up. But I knew if I just sat here, I would fall asleep, and then I wouldn't wake up. So I had to keep myself a little bit busy. Right. The court is supposed to start right now. So the judge keeps it tight. So should be here in a bit. Porcelain Thunder, no drinking. I don't always drink. About the only time I was ever here on stream and on maybe on the weekends, but nope. Got me some. Oh, well, I have some coffee in the other room. I don't have any coffee here. I actually make in the summer. I love making cold brew coffee. I make my own cold brew coffee in the summer. I made some last weekend, so it's been sitting in the fridge, kind of opening up and doing a little of the fermentation process for the past week, and it is fantastic. And I left it in the other room. So once we get underway, I'll go fetch my coffee. Yeah. Let's see. Legal vices. I know they don't do PTO in South Korea, but what about sick days? I'm trying to think. I've worked here. I've worked for the same firm since, I guess it's 28 years. Yeah, 28 years. Started working for the firm. There's only been one day in that I've taken the entire day off for being sick. I mean, this is a hobby. This is an extra. If this starts to interfere with my actual real job, then, this is the one that's going to go. There's no way I can take a personal day off or a sick day for this and miss my real job. I mean, especially not right now. I mean, I'm in the middle of closing a deal on like was about a $2.3 million deal that, I cannot miss the office, but we'll be good. No, I just don't, I figure if I'm not dead, it's just kind of the work ethic. Hey, Katie, speaking of peeps in Korea, what's up, Katie P? Yeah, and it's just a thing. It's just a work ethic thing. I figure if I'm not dead, if I'm above ground, then I should probably be taking care of my responsibilities. I mean, there have been a few mornings where I was sick in the morning and then I went back to work in the afternoon, or I was feeling okay and then I started feeling later. I've taken a few half days, but I think only one full day off work for illness in 28 years. But that's just me. All right, got 598 people here, 254 likes. Hit the like button. Hit the subscribe button. I haven't checked the subscribe button in a while. Where are we? We're pushing towards 60,000. 59,000 for, oh my God. Wow. Wait, let me check my math here, my bad lawyer math. Yeah, we picked up almost 300 subscribers since this morning. Wow. I released a bunch of videos today, a bunch of Taylor Shabusiness short videos. We picked up almost 300 people since this morning. We're currently at, what was the number again? 59,509. So 491 more people to get to 60,000. That's way cool. Thank you so much, everybody, for the support you give. You guys are awesome. Just so you think I'm not malingering like Shabusiness here. Let's bring up the court feed so you can see exactly what it is that I'm looking at. Because that's always the one. I don't want to click on that one because I know that's one I always click on. That's the one I wanted to do. All right, here we are. This is what we're looking at. This is the court. We're all ready to go as soon as they're back in. I'd love to get to 60,000. That means we're only 40,000 away from 100,000 subscribers after only a year and a couple of months of doing this. That's insane. Okay, we'll tell a backstory here. If anybody's interested, listen, we got 600 people here waiting for court. We'll tell there's an entire video way back somewhere in my video collection, the Lorax origin story, how I got here. In a nutshell, I was born and raised in Utah. Good little Mormon boy. I was raised, and I came here when I was 19 years old. to be a missionary for 2 years. They said, "Do you want to go to South Korea and be a missionary?" I said, "Man, okay, let's find out where South Korea is on a map." So I came here, and I started my
back on the record.
Relationship with Busan National University here in Busan, and they made me the exchange student, and then I just kept coming back, and finally I went to law school and got a job here.
Okay, and then
that's the best we can do for now. We're out of time, but that's the abbreviated version.
Her testimony at this phase of the trial.
Yes, Your Honor. I spent extra time with my client, Ms. SCHABUSINESS. We talked about her right to testify at phase 2 of this proceeding, the NGI phase of the proceeding. She understands what that means. She understands that she could take the witness stand and answer questions and testify about various topics. I've also explained to her that she has a right not to testify, that she doesn't have to get up on the witness stand, that she can stay at counsel table and remain silent. That's her right. That's her choice. I gave her time to think about it, to reflect on it. She had questions. I answered those questions. We had a good dialogue and conversation on this particular topic. She's advised me that she wishes to waive her right to testify. She's not going to take the witness stand.
Again, the best decision for her, the worst decision for me.
Not to testify at this phase. Is that correct?
That is correct.
Okay. You understand that you have a right to testify, and you also have a right not to testify. And if you don't testify, your choosing not to testify can't be used against you. Do you understand that?
Yes, I do.
Okay. You understand those rights belong not to Mr. Freilich. They don't belong to me. They don't belong to the state. Those rights are yours and yours alone. Do you understand that?
I do.
Do you feel you need any more time to talk to Mr. Freilich about this decision?
No, I don't.
And it's your decision not to testify here today. Is that correct?
Correct.
Okay. Any further inquiry the state would like me to make regarding that?
No, thank you.
Mr. Freilich, any further inquiry you'd like me to make regarding that issue?
Only if the court would inquire as to whether she felt any pressure or coercion in order to make this decision.
Ms. SCHABUSINESS, do you feel you've had any pressure by anybody or coercion to make this choice?
No.
Okay.
Thank you, Judge.
That's so she can't later come back and say my lawyer tried to force me to do this.
Opportunity to speak with her attorney about
He's covering his ass there.
And she's made a choice here today, freely and voluntarily, not to testify at this phase of the trial. And I'm going to accept that, and we are going to move forward. So I think how the matter would unfold then is when the jury comes back in, I'll ask Mr. Freilich if he has any further witnesses to call. Based upon what I've heard, the answer will be no, the defense rests, and then we would move to the state. And as I'm presuming the state is ready to call its first witness.
Yeah.
Okay. And then I did want to place on the record, because I was advised that when we excused Dr. Layton, we weren't on the record, but there was no objection to Dr. Layton. It's too late now. Both parties indicated there was no objection to her being excused, and that's what I did. Is that correct, Mr. Freilich?
That's accurate.
And Mr. Saunders?
Yes.
Okay, and then I just want to confirm, we don't need to go over these now. The jury has already been waiting a little longer than I told them they'd have to, but I did place on the on counsel table copies of proposed jury instructions, and then also just recently.
Oh, this is live. Live, Gruff.
It comes in the form of jury instruction 605B, but it's not a jury instruction. It's a proposed verdict form. Did both parties get a copy of those, Mr. Freilich?
Yes.
It won't matter.
Saunders?
Yes.
Okay, we can discuss those at the conclusion of evidence, but at this time then I'm going to bring the jury in.
All right.
The jury.
It looks like the defense is going to rest their case for the insanity part. I don't think the prosecution is going to call anybody. They're going to go straight into the jury instructions and the closing arguments. We could have a final resolution to this matter within today. If the prosecution doesn't call anybody, it's going to go closing statements, jury instructions, done, or jury instructions, closing statements, done, whichever way. So, yeah, it's supposed to go through tomorrow, but it looks like we're not going to get there. We could be done with this by today. Well, there you go. Yeah, if she showed her bobs, it would mean the end of my channel due to YouTube.
Right.
But yeah.
We are back on the record this afternoon. The case is still with the defense. Mr. Freilich, do you have any other witnesses to call?
Your Honor, the defense rests at this time. No other witnesses.
All right.
All right.
The matter turns to the state. I don't know, Mr. Lizet or Mr. Saunders, who's going to be questioning the first witness. So, Mr. Lizet, your first witness.
Your Honor, the state calls Dr. Matthew Seipel.
Okay. They're going to call, I guess, one or two witnesses to go, yep, she's not crazy. She fakes it. She was perfectly fine at the time she committed the murders.
Truth and nothing but the truth in the matter now before the court, so help you God.
I do.
Please have a seat and state your name for the record.
Matthew Seipel. My last name is spelled Seipel.
Okay, then the witness is yours, Mr. Lizet.
Okay, he is the
Afternoon, Dr.
psychologist
Seipel.
that's questioned her
afternoon.
twice before.
How are you currently employed?
I am employed as a licensed psychologist with Behavioral Consultants Incorporated and the Wisconsin Forensic Unit, where I perform forensic mental health assessments on a full-time basis.
How long have you been with the Wisconsin Forensic Unit?
I began with the Behavioral Consultants and the Forensic Unit in September of 2020 as a postdoctoral forensic psychology fellow, and I've continued with those organizations since February 2022 when I obtained psychology licensure in the state of Wisconsin.
And he's loud as hell.
And you indicated
Let's turn him
that
down.
your full-time duties is to perform forensic evaluations. Is that right?
Yes.
What types of evaluations do you typically perform?
I complete competency to proceed examinations, mental responsibility or NGI evaluations, evaluations of people who are petitioning for conditional release from the state mental health institutes, as well as legal guardianship, and several types of juvenile evaluations.
You indicated that is your full-time employment. Do you know about how many of each of those evaluations you might perform in a calendar year?
And so I would say in total, I've completed over the past 3 years, roughly 1,000 across those types of evaluations. So in a calendar year, it would break down to typically at least 300 evaluations. About 3/4 of those would be competency evaluations. And then roughly, I would say another 10 to 20% would be NGI evaluations.
You indicated that you are a licensed psychologist in the state of Wisconsin.
Yes.
What does that process entail?
And so to become a licensed psychologist, one needs to complete a doctorate in psychology from an institution that is either accredited by the American Psychological Association or determined to meet equivalency of those accreditation standards. And then at the time that I obtained licensure, 1 year of full-time postdoctoral supervised practice was required. I believe that standard has changed, but that was the standard for licensure at the time that I gained my license.
And you indicated that you must have that doctoral degree. Where did you obtain that degree?
I was from Iowa State University.
And do you have, can you just go through briefly your education prior to that degree?
I completed a bachelor's degree in psychology from Cardinal Stritch University, as well as a Master of Science in Clinical Mental Health Counseling from Marquette University before completing my doctorate at Iowa State.
And doctor, through your professional work at the Wisconsin Forensic Unit, did you have an opportunity to work on the present case, State of Wisconsin versus Taylor SCHABUSINESS?
Yes, I did.
How did you become involved in that case?
And so I was requested to complete 2 court-ordered competency evaluations in this matter.
When you say court-ordered, does that mean that the court is the party that retained you rather than either the state or the defense?
Correct.
Yeah, and when was that first evaluation? When was the first report filed?
That was in November of 2022.
And when was the second report filed?
That was earlier this month in July of 2023.
Yes. Yeah, this is the guy that found her competent to stand trial.
You
twice.
mentioned that you were retained by the court to do a competency evaluation, and earlier you also mentioned that you do NGI evaluations. Can you explain for the jury the difference between those two types of evaluations?
Yeah, so those are 2 entirely different types of evaluations that are guided by 2 different state statutes. And so competency pertains to a defendant's current mental status. It is independent of the mental state at the time of the alleged offenses, and it pertains to whether or not the defendant presently has substantial mental capacity to understand the pending proceedings or to meaningfully assist in their defense. Whereas the state statute for NGI dictates it is about the defendant's mental state at the time of the alleged offenses. And specifically, Was there a qualifying mental disease or defect that contributed to a substantial lack of capacity to appreciate wrongfulness of conduct or to conform conduct to the standards of the law?
And you indicate that you have substantial present experience in both of those types of evaluations. Is that correct?
Yes.
Now, they are different evaluations with different standards. However, are the materials used to evaluate those often similar?
I would say that collateral records are critical in both evaluations, although in competency, those records would focus most heavily on the present time and present functioning, whereas for NGI, it would be focused upon functioning at the time of the alleged offenses.
And can you talk about the records that you reviewed regarding Ms. SCHABUSINESS for each of the two competency evaluations that you performed?
Yes, and so I reviewed the criminal complaint for the underlying matter. I reviewed all previous psychological evaluations that were completed in reference to this case, including competency and NGI reports from multiple examiners. At both times, I reviewed her contemporary treatment records from the Brown County Jail. And during the most recent evaluation, I also had the opportunity to review a discharge summary from a treatment episode at the Nicolay Psychiatric Center in 2021.
Did you, subsequent to the evaluation, were you also provided with copies of materials from an inpatient stay at Bellin Psychiatric or two different inpatient stays at Bellin Psychiatric?
Yes, after submitting my most recent report, defense counsel provided me discharge summaries pertaining to those two episodes of inpatient care.
And were all of those records taken into consideration when you either rendered your opinion or provided testimony at competency hearings in this case?
I would say that all of the sources that I mentioned initially were considered in reaching my opinion in my report. And then those Bellin records I did consider in preparing for testimony, but they did not alter any of the opinions offered in my report.
And in addition to reviewing collateral records, did you conduct personal interviews with Ms. SCHABUSINESS?
Yes, I did.
And what were the dates of those interviews?
And so the most recent interview, I'm just referencing my report here, was on July 12th of 2023. And for the initial interview, I would reference to refresh my memory that report.
Hey, Joe, you got the link. Jump on in here, buddy.
The date of the interview was November 17th, 2022.
And were both of those in-person interviews?
Yes.
And can you estimate approximately how long you met with Ms. SCHABUSINESS?
I need to get my copy.
On both occasions, it was roughly 90 minutes, perhaps give or take a few minutes.
Doctor, when you were reviewing the records and ultimately when you had to come to an opinion in this case, had you encountered prior diagnoses that had been assigned to Ms. SCHABUSINESS at various points in time?
Yes.
Were you aware that at some point in time she had received a bipolar diagnosis?
Yes.
And do you recall where that came from?
That was during her inpatient treatment at the Nicolay Psychiatric Center in 2021.
And Doctor, what did you note with respect to that particular diagnosis? Were there any concerns when you saw that?
Yes, a concern I had with that diagnosis is that for one to be diagnosed with bipolar disorder, it's specifically within the diagnostic criteria for that condition that the symptoms cannot occur exclusively in the course of substance intoxication. And I noted that there's multiple collateral sources suggesting that she was abusing methamphetamine very extensively leading up to that treatment episode. So I was unable to really see how the treatment providers could have parsed out to what extent any psychiatric instability derived from the methamphetamine use versus an actual underlying mental illness.
And did you have an opportunity to review the discharge summary from Nicolay Psychiatric?
Yes.
And in that discharge summary, is there a discussion of how she presented upon arrival compared to how she presented upon her release 21 days later?
Yes, it was noted that there was a remarkable difference and that psychotic symptoms were evident upon admission, including hallucinations and very disorganized behavior, although those symptoms were determined to be largely resolved by the end of that treatment episode.
Does that suggest anything to you with respect to the substance abuse that was indicated at the outset?
So it's again difficult to disentangle to what extent that improved mental status resulted from any medication she received in the facility versus her mere forced abstinence from intoxicants.
Based on your professional education and experience, or the types of symptoms that were noted upon arrival at Nicolay Psychiatric, can those symptoms also be associated with the methamphetamine use solely?
Yes.
So it's possible for someone to manifest those symptoms solely based on meth use without having any underlying mental health illness.
Grandma's
Objection
Yes.
calls for speculation.
Overruled.
Yes.
You indicated that you had the opportunity to review reports from other evaluators who met with Ms. Schabusiness and provided opinions in this case. Is that correct?
Yes.
Did you note whether or not any of the other evaluators shared similar concerns about the bipolar diagnosis assigned to her by Nicolay Psychiatric?
Yes, I noted that in Dr. Engen's mental responsibility evaluation, she took most specific and direct issue with the basis for that diagnosis. And she ultimately, in her report, offered that she did not see sufficient support to assign a diagnosis of bipolar disorder. I also noted that, for example, in Dr. Lucetta's competency report, while she did not necessarily completely rule out bipolar disorder, she also noted again that the substance abuse was a significant factor leading up to that diagnosis, and she merely essentially sought to rule out that diagnosis, but did not.
Self-induced substance abuse is
I
a
want to
big
just sort
problem.
of speak generally about bipolar. Can you describe for the jury what bipolar is and what is required to diagnose such a disorder?
Yes, and so there are two different types of bipolar disorder. There's bipolar 1 disorder, which is a more severe condition, and that is the diagnosis that has appeared in some of the records in this case. Bipolar 1 disorder is characterized predominantly by manic episodes, which are periods of it lasting at least a week, where more often than not, the individual has a significantly elevated mood. They may behave impulsively, erratically, have a decreased need for sleep. And in some instances with bipolar 1, that is alternated by depressive episodes, which typically last at least 2 weeks and are largely the opposite of mania. That means there's a persistently low mood, low energy, feelings of worthlessness, guilt, or hopelessness, things of that like. Whereas bipolar 2 disorder has hypomanic episodes, which are not as prolonged or severe as a manic episode. And by diagnostic criteria, someone must also experience depression in order to qualify for bipolar 2 disorder.
So is it fair to say that to diagnose someone with bipolar 1, we would have that expectation of seeing those prolonged manic episodes, at least one instance of a prolonged manic episode?
Yes, and it would need to occur outside voluntary substance intoxication.
Is it possible for a person who has been diagnosed with a bipolar disorder, is that the type of condition that could occasionally wax and wane over the course of someone's lifetime?
To the extent that someone does indeed meet diagnostic criteria for bipolar disorder, yes, there certainly can be a waxing or waning or a cyclical pattern of symptoms.
I also want to harken back to the fact that you have done NGI evaluations. Is that correct?
Yes.
And is bipolar a condition that can sometimes contribute to an opinion that someone does meet NGI criteria?
Yes, it certainly can.
And under what
Muted, Jeff.
circumstances might you expect to see that?
Yes, and so in order to reach an opinion of supporting an
Everybody,
NGI plea in the
Tank Rack
context of
just gifted
bipolar
50 legal
disorder,
license
one, there would
memberships.
need to be
Make
a
sure you
firmly
give them a special
established
thanks if you're one of those
diagnosis of
people. And
bipolar
Ozzy
disorder,
Overlord, hi.
again, in the absence of substance intoxication. And there would need to be a very direct linkage between the symptoms of that mental illness at the time of the alleged offenses and the substantial lack of capacity to either appreciate wrongfulness or to conform conduct to the requirements of the law. It's not enough for the defendant to simply be symptomatic, but that linkage needs to be established with the lack of capacity.
When you talk about establishing that linkage between the crimes alleged and
God
the
damn, Tank Rat.
mental illness that's been assigned
Thank
to an
you, brother.
individual, what sorts
Yep,
of
hold-
facts or
Hold the gift
circumstances
trigger
do you
again.
consider when
Glad the
you do
prosecution
NGI
brought their witness to this
evaluations?
ruckus. Thank
And so
you
there
so
would need
much.
to be
Cheers to you.
converging data sources indicating that indeed the defendant was symptomatic of that legitimate mental illness at the time, and there would need to be, conceptually, it would need to make sense for the alleged misconduct. There would need to be some sort of reason that mania, for instance, would have caused that behavior. There would need to be evidence to suggest that the person was fundamentally unable to control their behavior. And so again, that would typically comprise a pattern that extends beyond that one momentary act, but it would need to be a broader pattern encompassing that time frame.
So if you are evaluating whether someone's bipolar disorder might be causal of the criminal offenses, would it be significant to you to evaluate the defendant's symptoms or how someone presents immediately before and immediately after the alleged offenses.
Yes, those would be critical time frames in which to gather as much data as possible.
Is that because one would expect that someone with bipolar wouldn't manifest those symptoms solely for a short period of time, but typically over a much longer period?
Yes, that is
Objection
correct.
calls for speculation.
I think it calls for his professional opinion.
Overruled.
Yes, it would be expected to see, again, a symptom duration longer than just the mere moments of committing a criminal offense.
Doctor, I want to quickly return back to some of the other records that had been mentioned. You indicated that you did have an opportunity to review
not weeks, not
the medical records from
commits
Bell
a
and
murder.
Mm-hmm.
Health from two different stays that Ms. Schabusiness had, one in 2012 and one in 2014.
Yes.
And I'll first call your attention to the 2012 records. If you recall those, do you remember if Ms. Schabusiness was assigned a diagnosis by the treatment providers at Bell and Health at the outset of her stay in 2012?
She was assigned a diagnosis of mood disorder not otherwise specified.
So she was not assigned a bipolar diagnosis at that time. Is that correct?
Correct.
And then in 2014, did she likewise have some sort of diagnosis following her 3-day stay in Bellin?
She was again assigned a diagnosis of mood disorder not otherwise specified, and they did add, which is not a diagnosis per se, but they noted alongside the diagnosis a history of psychosis. But in looking closer at the records, that history of psychosis derived squarely from an adverse medication reaction, which prompted the initial inpatient stay. So she was prescribed sertraline, and then only after that did she begin to have psychotic symptoms, and those symptoms resolved as soon as that medication was discontinued.
Again, she was not assigned a bipolar diagnosis in 2014 either.
Correct.
Dr. Seipel, you indicated that you did have an opportunity to review Dr. Litton's report from July 3rd of 2023.
Yes, I did.
And what type of report from a forensic standpoint was Dr. Litton's report?
It appeared to be a combined competency and NGI report.
In your experience and training, is it best practice for someone to engage in a combined report of both competency and NGI?
Typically, a separate report would be submitted to address each issue independently.
What are some of the reasons why you might not combine those two reports?
For one, there can be information introduced in the issue of criminal responsibility that might be inappropriate to be contained within a competency report. A competency report is not supposed to contain incriminating information with regard to the alleged offenses. But also, and from a psychological standpoint, it makes it difficult to parse out which data and which arguments are directed at each respective issue if they're addressed alongside each other in the same report.
Is it particularly concerning if you come to a conclusion that a person is not presently competent, that you would also rely on that information to form an NGI opinion?
I would say that it's not inappropriate if that's a data point that is considered, but that there should not be a strong linkage in that reasoning, as again, it's two different legal issues pertaining to two different time points.
Doctor, when you looked at that report as it relates to NGI and Dr. Litton's report, I'm just going to ask you generally, did you have any concerns with the methodology that was shown in that particular report?
I found that it seemed appropriate data sources were consulted, at least that's what the methods section suggested in that report, although there was essentially no discussion or review of the discovery materials that were reviewed, and really no account from a defendant's perspective of the alleged misconduct, which are very critical pieces of information that would always be included in an NGI report.
So those pieces of information that you just discussed, like the account of the offense and the specific discovery materials outlining the offense, why is it important to include that type of information in the report?
Because again, the statute for NGI pertains squarely to the moments of the alleged offense, and that is the data that most directly captures those moments. And so it becomes somewhat of a black box issue if those moments are not discussed in the report and inferences instead are appearing to be made based upon presentation at other time points. That's not sound professional reasoning with regard to the issue of NGI.
And I want to talk about information being based on other time points. Did it appear to you that Dr. Litton relied very strongly on her personal observations of Ms. Schabusiness in the interview?
I would say it seemed that the symptoms that were portrayed during the moments of that interview seemed to weigh heavily, as well as the mere fact of a bipolar diagnosis being assigned roughly a year before the alleged offenses.
Yeah, you missed it all.
Were you able to determine whether or not
she
Dr.
came back
Litton
to
actually
testify for the
assigned a
defense?
diagnosis herself?
And
it seemed
she said
implicit
that,
in the
Taylor
report that
Schabusiness
she
was suffering
concurred
from,
with the
quote,
bipolar
super-duper
diagnosis, although it was not
depression.
explicitly stated. For instance, I am assigning the defendant a diagnosis of bipolar disorder.
Is that
super duper suicidal depression.
typical in your experience to not assign a diagnosis during such an evaluation?
In an MGI evaluation, as the identification of a qualifying mental disease or defect is critical and necessary to support an NGI plea, it would be essential for the diagnosis to be very explicitly indicated.
And that was not done here.
I would say, again, it was not explicit, rather it was more so inferred, being embedded in text.
And Doctor, the report from Dr. Litton, does that include a relatively lengthy or specific discussion of the observations of Dr. Litton from the interview that occurred in June of 2023?
Dr. Litton's a
yes, the
retard.
greatest detail seemed to pertain to that which would have been her second contact with the defendant.
And you personally had contact with the defendant within about a month of that particular interview. Is that fair?
It would have been roughly like 3 or 4 weeks per my estimation.
A Fire Red podcast.
The observations that Dr. Litton is making of the defendant, her actions, her behaviors, her psychotic state, did you witness those same things when you met with Ms. Schabusiness?
I did not notice the evident distraction that was evidently apparent during the interview with Dr. Litton. The defendant easily maintained focus and was able to supply coherent, relevant responses to questioning. She remained behaviorally appropriate and was able to engage in detailed discussion of her legal situation. There was a brief moment in which she referenced claiming to see a supposed green train within the room, which is something that was evidently very distracting during the interview with Dr. Litton. I essentially ignored when that symptom was mentioned, and there was no further mention of it thereafter, and there was no evidence that she was in any way distracted by that or any similar psychotic symptom.
Did you form a conclusion with respect to the psychotic manifestations that Ms. Schabusiness was outwardly claiming to have?
I found that there was not sufficient support for assigning a diagnosis such as bipolar disorder or schizophrenia that could presumably underlie those symptoms.
Did you have any concerns about the validity of the claimed symptoms?
Yes, I did.
And what were those concerns?
And so my concerns were manifold. There has been a remarkable inconsistency in presentation over the pendency of this case in terms of the symptoms the defendant has claimed to forensic examiners versus to clinical providers within the jail. And even during very similar time frames, she's offered contradictory remarks. And apparently, only during the interview with Dr. Litton has anyone observed her during the pendency of this case to seem to be preoccupied with internal stimuli. That's not something that I have observed. And jail providers have noted that even in the isolated instances where the defendant has endorsed hallucinations, they have viewed no outward indication.
I would object only because that calls for hearsay. I apologize, but overruled.
I forgot where you were in your answer, but if you're
another question.
Sure. Had other doctors who evaluated the defendant shared concerns that you reported about the possibility of feigning or embellishing symptoms?
Yes.
And who was that?
I noted that first in Dr. Lucetta's competency report as part of a competency instrument that she administered to the defendant. Embedded within that were validity indices. That means there were testing items which sought to determine the credibility of the defendant's endorsement of psychiatric symptoms. And her responses to those items suggested an elevated probability of a non-credible response style with regard to endorsing psychiatric symptoms. And similarly, when Dr. Engen completed her NGI evaluation, she administered the Minnesota Multiphasic Personality Inventory, or MMPI as it's widely known. And the extent of her invalid responses on that instrument made it where her clinical profile could not be interpreted because the validity skills for that instrument suggested she was grossly exaggerating psychiatric symptoms in a manner that would be extreme and inconsistent even
That
for a
is
patient with
exactly what
legitimate
the Amber
schizophrenia.
Heard was called out for
And
doing.
did you note
Was
whether or not
faking so
Dr.
well,
Layton
she went off
performed
the
any
"you're
such
faking it"
psychological
scale?
testing to determine the validity of the symptoms that she was observing from Ms. SCHABUSINESS?
I found no mention of any type of instrument for symptom validity within her report.
Was that surprising to you?
I would say yes, in general, but especially specifically given that those psychotic symptoms really seem to be the crux of her opinion regarding the issues of both competency and criminal responsibility, and especially in light of prior testing data that cast significant doubt over the legitimacy of those symptoms. So under those circumstances, it would be extremely unusual for an examiner to not administer testing.
Now, did you administer testing of Ms. SCHABUSINESS when you met with her?
I was prepared to administer testing upon entering the evaluation, although her clinical presentation suggested such testing would not be necessary to reach an opinion regarding her adjudicated competency.
Can you explain that? maybe
Translated,
just in
she was
a little more
faking so
layman's
bad I
details?
didn't have to
Yes,
give
and
her
so
the
to the
fake it
extent
test.
that the defendant would have
my
presented similarly
God.
as she did with Dr. Layton, for instance, presenting herself as
That's
very
how bad
distracted by
SCHABUSINESS was faking it.
hallucinations,
He's like, I didn't even
unable
need
to
to give
supply
her the damn
linear or
test.
coherent responses, then I would have administered psychological testing to see where the validity lied with such symptoms. Although she did not portray those symptoms and with relative ease was able to discuss her legal situation in a rational manner, so the validity of symptoms became a moot point. That the results of that testing would have had no influence on my opinion regarding competency.
Essentially, you didn't need to test the validity of the symptoms because you didn't see the symptoms.
Correct.
Mm-hmm. Oh yeah, and the Grandma Spiegel, he said when she was asked if she administered the MMPI test, she said, "Well, I'm not. Well, you don't have to. You have to administer the test." And she like literally did that. She's
Now,
like, "No, I
Doctor,
didn't do
you
it."
also had an opportunity
It
to
was weird
review
as
the
fuck.
report of Dr.
Right.
Engen, which I believe you previously mentioned. Is that right?
Yes.
Now, Dr. Engen's report is a report on NGI and not competency. Is that right?
Yes, it is specifically and solely to
Rackets
the
and I
issue
have
of
synced our
NGI.
cycles now. What?
Now, some of the shortfalls of Dr. Layton's report that you already pointed out, did you see those same concerns in the report of Dr. Engen?
I did not.
Can you compare or contrast the methodology that Dr. Engen used to the methodology used by Dr. Layton?
And so in Dr. Engen's report, I found to be consistent with my training, experience, and my understanding of best practice in the field of forensic psychology, and that she engaged in a thorough review and detailed in her report the discovery materials. She supplied a detailed accounting of the defendant's personal account to her of the index offenses. She reviewed medical records from the Nicolay Psychiatric Treatment Center that, again, would have been in that time period leading up to this offense. And she administered psychological testing to aid in determining the validity of any of the psychiatric symptoms that the defendant claimed during the evaluation. And so that represented to me a full and comprehensive NGI evaluation.
And in contrast, did Dr. Engen's report specifically tie Ms. SCHABUSINESS's behavior at and around the time of the offense to any mental illness or lack thereof?
Dr. Engen supplied a detailed articulation of why she ultimately did not assign a qualifying mental disease or defect diagnosis to the defendant. And then she in turn articulated why she did not believe there was any support for the conclusion that outside of voluntary substance intoxication, the defendant would have substantially lacked capacity to appreciate wrongfulness or conform her conduct to the requirements of the law.
I think we touched on this earlier as it related
Wow.
to
So the other
general
the other
diagnoses of a mental health
psychologist said
condition.
the only
but
thing wrong with
can
her
you
is
talk
drug abuse.
briefly about the impact that acute substance intoxication has on attempting to determine whether or not someone would be NGI?
And so according to the Wisconsin jury instructions, mental disturbance brought on by voluntary substance intoxication is not considered to be a qualifying mental disease or defect. And so to the extent that an examiner
The one time that I
cannot
could have
rule out
objected
the sequelae
is
of
being
that
illegal
voluntary intoxication as being the primary contributing factor to behavior, then the reason would dictate that an NGI plea cannot be supported.
Thank you, Doctor. No further questions at this time.
Cross-examination, Mr. Freilich.
Thank you, Your Honor. Dr. Seipel, good afternoon.
Good afternoon.
You prepared two reports concerning Taylor SCHABUSINESS, correct?
Yes.
one in November of 2022 and then one in July of 2023, correct?
Yes.
And you received police reports, correct?
I did not review the police reports.
Did you review the criminal complaint?
Yes.
Did you have a chance to review any video footage from the incident on February 22nd or February 23rd of 2022?
I did not.
In this particular case, did you administer the two gold standard tests, the MMPI and the MCMI?
I did not administer either of those instruments.
Yet you criticize Dr. Lighton for not doing it, correct?
Yes.
Now, you've been a
What's it do?
licensed psychologist since February of 2022, correct?
Yes.
That's when you obtained your license to
Bit of a
practice
difference
and
between saying
do
she was faking that
evaluations
bad
and
episode not do the
reports and all of
test
that,
and
My
I didn't
license
test it
enabled me to
prove wrong.
practice independently, although I performed all of these evaluations under supervision from September 2020 up until that time.
in September of 2020, that's when you were a fellow.
That's when I began my postdoctoral fellowship in forensic psychology.
When
That's his
you've
approach.
had
You
a
don't
chance
have
to
32
review
years of
Dr.
insanity
Lighton's
behind you.
curriculum vitae,
You're just a
correct?
noob.
Yes.
You've had a chance to review her evaluation from July 3rd of 2023, correct?
Yes.
As far as experience level, she has more experience than you. Is that fair?
I would say she's been a practicing psychologist longer, although the extent to which she has conducted NGI evaluations, I don't know if she has more experience than me.
You understand that she worked at Mendota Mental Health in the past, correct?
Yes, and typically NGI evaluations are not performed for patients already within the State Mental Health Institute.
And with regards to Dr. Christina Engine, she works in the Wisconsin Forensic Unit as well.
Yes, she is employed by behavioral consultants in the Wisconsin Forensic Unit.
Would she be a colleague or a coworker of yours?
I would say we are similarly employed, although we practice typically in different areas of the state and have pretty minimal contact with each other.
And the two of you are aligned as far as opinions in this particular case. Is that fair?
Well, we opined on different issues, so I would not agree with that statement.
But the
This goes
ultimate
good.
recommendation is the same, correct?
Yep.
I guess I'm not sure what you're asking, sir.
That you and her both find insufficient evidence to support the special plea, the NGI plea.
I would say I did not offer an opinion with regard to NGI, so again, I can't agree with that statement.
Okay. You've had a chance to review Brown County jail records, correct?
Yes.
You reviewed Bell and Health records that I sent, correct?
Yes.
You had a chance to review the Nicolay Psychiatric Center records through Brown County, correct?
Yes.
You reviewed a lot of mental health records, correct?
Yes.
Fair to say that Taylor Denise SCHABUSINESS does have a mental health history. Would that be fair?
I would say in general terms, yes, she has had contact with mental health treatment.
And fair to say that she was the subject of a civil commitment in 2021, correct?
Yes, it is my understanding that she became subject to a 6-month civil commitment during the course of her inpatient treatment in 2021.
And she was found by a court of law to be mentally ill. At
Tunnel
least in
vision is stunning.
2021.
See you at the
that
next
fair?
trial.
According to
Probably
that
not
court
taking
order,
another
would
nibble.
suggest that, yes.
We have tunnel
And
vision.
then she was on
Who has tunnel
medication order in order to take
It's not tunnel vision when you've watched the
medications
entire trial.
for that same period of time, correct?
I don't know if
Yes,
he's
it is
talking
my
to us or
understanding she was court ordered to
I
medication
don't know if he's talking to us or the
compliance.
defense or who, but wonder.
A lot of different doctors evaluated and took a look at Ms. SCHABUSINESS, correct?
With respect to the pendency of this case or
If
more
it's all in
generally?
the comment
Just
again.
with respect to the pendency of this case.
Yes, I would say there have been a handful of us that have completed evaluations.
Dr. Deborah Collins, yes.
Yes.
Dr. Tracy Lucetta,
Yes.
Dr. Diane Lighton,
Yes.
yourself,
Yes.
Dr. Christina Engine.
Yes.
I'm actually excited to be going back to Utah. I'm going to a foreigner concert. Cool on you, Super Spud.
With regards to
Foreigner, double vision thing.
Ms. Shabuzis's treatment at Nicolay Psychiatric Center, was she diagnosed over there in May of 2021 with bipolar disorder, current episode manic severe with psychotic features?
Yes, that was the diagnosis those providers assigned.
She was prescribed medications, correct?
Yes, I believe it was an antipsychotic medication that was prescribed.
Do you know if that was Aristata?
I would have to consult the records to refresh my memory.
Was it your understanding that she was prescribed a medication that would be by injection?
To the extent that it is Abilify Aristata, yes, that is a long-acting injectable medication.
It's an antipsychotic medication, correct?
Yes, with mood stabilizing properties as well.
And fair to say that through Brown County, through Nicolay, that Ms. Shabuzines was given a diagnosis of bipolar disorder.
Yes.
She was at Nicolay for about a month, correct?
I believe it was roughly 3 weeks.
A couple weeks, and then she was discharged.
Yes.
She was discharged, after she had her baby.
What was the question, sir?
Do you know? I'm sorry. Do you know if she was discharged after she had her baby?
Yeah,
I do not believe she gave birth during the course of that hospitalization.
Subsequent to that, she gave birth, correct?
I would again have to consult the records for the dates on that.
When you looked at all these records, did you come to find that there were some references to Ms. Shabuzis suffering from paranoia?
That word was mentioned in the records on some occasions, yes.
And was it mentioned that she had experienced some delusional thoughts?
Again, that was a word that has been used in the records, yes.
And was it mentioned in some of these records that we're talking about that she did suffer from distractions, inability to focus or concentrate?
Yes, there were some notations of those concerns as well.
Was it such that, in gleaning through the records, analyzing them, that she had auditory or visual hallucinations on occasion?
Yes, and most specifically that first admission to Bellin, as well as the admission to the Nicolay Psychiatric Center, where I saw the hallucinations mentioned.
Yep.
Was that mentioned in 2021?
Yes, upon her admission to Nicolay, when she had heavily been abusing methamphetamine recently.
You've been a doctor for some time. You've got a PhD. You've got a lot of education. You've had experience with different kinds of patients, correct?
Yes, many, many different kinds.
With all different sorts of problems, correct?
Yes.
And you've dealt with people who have had drug addictions and things of that sort, correct?
Yes.
So you're really qualified,
You've
right?
gone to seminars with regards to how substances can affect the brain, correct?
Yes, and I taught an undergraduate course regarding the effect of substances on psychology as well.
And would it be fair to say that substances can impact the brain, can cause organic brain damage?
I would say there can certainly cause some functional abnormalities in the brain, although the notion that drug use permanently damages the brain really is not consistently bore out in the literature the way that it is in kind of the public conception of drug use.
Suck it. Oh, yeah, hey, Renee, we're synced too. Literally, so suck it.
Drug use can also exacerbate mental health problems, correct?
It can exacerbate them or cause them of their own accord, yes.
Now, if she goes in
what
this life
causes
without
memory
parole.
impairment?
There can be manifold causes for memory impairment.
Drug usage?
Certainly, if there has been recent and especially significant drug use, yes, that can affect various neurocognitive capacities, including memory functioning.
How about traumatic events like loss of a mother?
I would say that can cause some difficulties with concentration, though typically would not cause amnesia in and of itself.
Is PTSD, post-traumatic stress disorder, is that a mental health condition?
Yes, it is.
Can that get worse over time if untreated?
It can, yes.
If someone has a mood disorder, is that a mental health issue?
Yes.
It's a mental defect or a mental disease?
I would say it could meet criteria as a mental disease or defect according to Wisconsin state statutes, yes.
And can that get worse over time, the mood disorder, if it's left untreated?
It can, yes.
Where's the defense lawyer's passion? Where's his interest?
People are not subjected to a civil commitment order unless they have a mental health condition, correct? Is that fair?
It would require a clinician to opine that they have a mental illness, yes.
You think there's a reason she decided today not to brush her hair? Just try and make herself look that extra bit crazy.
I saw some records in Brown County. I believe it relates to the Nicolay Psychiatric Center records, that there was a problem addressed, risk for self-injury related to delusional thought process vague. Do you know what that references to?
I believe I recall seeing that verbiage in the records, but I wouldn't be able to supply context without reviewing those records.
Do you know if Ms. SCHABUSINESS had problems or issues with a delusional thought process?
At that time, it was noted that that was a symptom she was displaying upon admission to the facility, yes.
Did you have
This expert seems
occasion
fantastic.
to, when you met with her, to observe that she had
I
a
disagree.
tangential thought disorder?
During my meetings with the defendant,
Yes.
I did not note signs of a clinically significant thought disorder, no.
How about, was that bore out with Dr. Engine or Dr. Collins?
I would say there was, again, no indications of clinically significant impairment in maintaining linear thought during those evaluations.
In your review of the Brown County progress notes from Nicolay Psychiatric Center, did it have references to Ms. SCHABUSINESS identifying demons in her life?
In terms of the Nicolay psychiatric records,
Yes.
I do believe there was mention of some commentary of that sort, yes.
And was there commentary that her affect appeared to be labile and inappropriate throughout group, and that she
Labial? What?
had mood changes and inappropriate facial expressions or laughing?
Yes, I did see that bore out on those records.
Did you see that when you talked with her
Liable
in
to change or
November of
easily alter.
2022 or July of
I'm
this year?
sticking with labial.
I did note that there were some moments of some inappropriate grinning or perhaps very brief isolated instances of laughter. All those were short-lived and did not impair capacity for us to have a linear and meaningful discussion.
They're also fake as fuck.
Those that
In July, when you met with her, you said 90 minutes, give or take. Was it cut off for any reason? Was your interview cut off?
No, they were able to be completed on both occasions to their natural course.
Dude, stop using the phrase
Some of
cut
the records,
off, okay?
did you
Not
know,
during this trial.
it indicated her affect was flat when approached?
Yes, there were some indications of a relatively flat or diminished expression in her emotional presentation, yes.
What does that stem from? Do you know?
That's again something that can have manifold causes and could simply be someone's baseline emotional presentation as well.
Could it be related to a mental health defect or disease?
It is possible, although again, it could also be due to many other factors.
Also in these progress notes, did you indicate, or did you review, excuse me, that she was feeling as though different bodies were going in and out of her person?
I do believe I read that
Oh,
in the
Jesus
Nicolay notes
Christ.
as
Is
well.
he
Yes.
serious right now?
Did she talk about having pressure in her head or having her head hurt?
Yes, that is a complaint that she has made at different occasions across time. Yes.
And did she also indicate that she had problems with eye twitching and that her PTSD was triggered from loud noises?
I do believe I recall seeing those symptoms mentioned in the records as well.
Did you, at least in some of either the jail records or the Brown County records from Nicolay, that she talked about wanting to die and go to heaven to see her mom?
Yes, I do recall seeing such.
That's the way she's going.
And in reviewing these records, because there are a lot of them, did she indicate at least
Stop talking, dude.
in the records
You're
when she
making
was
it
at
worse.
Brown County at Nicolay that she was hearing voices that would get heavier at night?
I do believe, yes, there was a pattern of time of day seeming to impact symptoms at that time, yes.
And the time of day would be more at night. They'd be more pronounced at night than the daytime.
Per my recollection of the records, I do believe that was the pattern that was mentioned.
And she was encouraged to connect with a dual therapist to address mental health and her AODA issues. Is that fair?
Yeah, consistently over time, she has been referred for substance abuse treatment, yes.
And in those records from Nicolay, it also talked about that she would have racing thoughts that would get overwhelmed and that she'd hear voices in her head.
Yes, those are symptoms I do recall seeing in the records.
Her eyes twitching. I guess she can't be held liable.
It's true, right, that there were discussions about her getting this Aristata injection every 4 weeks to help her?
Yes, that is the typical course in which that medication is administered, and per my recollection, I do believe that's what was ultimately prescribed.
Then there was some discussion about whether she would take the pill or take the injection, correct?
Yes, I do believe that the means of administration was discussed amongst her clinical team.
Even in the notes, it talked about, in the notes from Brown County, from Nicolay Psychiatric Center, it talked about how Ms. Schabuzis would have agitation, anxiety, correct?
Yes.
And that there was a discussion about giving her Haldol, correct?
Yes, that would be another antipsychotic medication with pretty heavily sedative properties.
Do you know if that was ever given to her?
I would again have to refresh my recollection with the records.
And even in the Nicolay records, it talked about that it was a struggle to decipher what is a genuine psychiatric symptom and what is otherwise talked about as gaminess, correct?
Yes, I do believe that was a term that was employed in the records.
There were just a lot of records to review and you have a good memory. But it also talked about Zoloft, correct?
Yes, that was mentioned specifically in her adolescent treatment records.
And Ms. Schabuzis was given apparently at Nicolay, from what you reviewed in these notes.
She's been given all the drugs. Can we just stipulate to that? She's had every drug ever known to man.
And what does she want to do to make progress with mental health? Is that fair?
I don't recall that specific information.
Okay. With regards to Dr. Lighton, she says
She kind of
that
had every drug.
she
I mean,
believes
what's the name of the one that goes in the little needle that
my
goes in your
client,
arm?
Ms. Schabuzis, qualifies for the NGI plea based on a diagnosis of a serious mental disorder. You understand that?
Yes, that's what she wrote in her report.
And she opines that her serious mental disorder affected Ms. Schabuzis' ability to know right from wrong at the time of the offense, correct?
I would say it was relatively tersely worded, although that was what was suggested, yes.
And she also said that it affected her ability to control her behaviors. Is that fair?
Yes, that was the opinion that she reached.
You have a diabolically opposed.
God damn it! Stop
opinion
saying that.
compared to Dr. Litton?
Say,
Lighton,
correct him. Please correct
Again,
him.
I did not opine on the NGI issue.
Diabolically opposed.
Thank you, nothing
And
further.
what was the other one he does?
Redirect.
He means diametrically.
Just
What was it?
briefly, I think you were asked a
Duplicitous
great deal
instead of
again about
duplicative.
the records from Nicolay and the specific symptoms that were manifesting at that time at Nicolay. Yeah, do you know if Nicolay actually administered a blood test to determine whether or not there were substances in her system at the time she entered Nicolay?
There was either urine or blood screening performed for toxicology purposes, yes.
And she did test positive for methamphetamine?
It was methamphetamine and I believe also amphetamines and THC as well.
And did the Nicolay records show a marked improvement in her symptoms in the 3-week stay there?
Yes, there was a relatively linear trend over time towards psychiatric stability.
And while that might potentially be attributed to taking psychiatric medications, it might also be attributed to weaning off of the illicit substances.
I would say it's fundamentally impossible to disentangle to what extent precisely the improvement would have derived from those sources.
And you were asked questions about at points in time, did Ms. SCHABUSINESS have potentially paranoia or hallucinations or things that could potentially be associated with psychiatric conditions or psychosis? Did anyone in any of the records that you saw make such an opinion on or around February 22nd and 23rd of 2022?
In terms of those symptoms or diagnoses applying at the time of the alleged misconduct?
Correct.
Welcome
I would
home,
say
John
that
King.
from what I saw,
Welcome
Dr.
home.
Lighton was the only one that, and again, it wasn't really directly discussed, though at least seemed to imply that those symptoms were at play at the time of the incident.
Now, none of the mental health records that you saw were from February of 2022. Is that correct?
I did not see any indication of her being actively involved in psychiatric treatments, so there was no reliable collateral source to corroborate those symptoms at that time.
And again, just to clarify, I think you've done a good job of this, but you were not asked to opine on the issue of whether or not
No,
an NGI offense
it's not the
or
same.
an NGI defense is appropriate for Ms. SCHABUSINESS in this case.
That is correct. I was only ordered as a competency examiner.
Thank you. I have no further questions.
On those topics, Mr. Freilich?
No, Your Honor. Thank you, Dr.
Thank
Seid.
Doctor. You can step down.
Can you imagine the first meeting between this psychologist and her?
Oh, nice to meet you, Mrs. Hello, my kid's from a sperm bank.
Stay
Since I
sexually
can't keep a man because, in addition to my jillion
calls,
neuroses, I have a
Christina
weird-looking
Engine.
vagina.
You gotta wonder if she was sitting there in a straitjacket when he walked into the room, right?
Yeah. He's like, we won.
Poor guy. What a bald patch.
It's alopecia, probably. I don't know.
Yeah.
Or it could be like eczema or like my dogs have.
Mm.
Who knows?
It's just unfortunate. I feel sorry for
Yeah.
him. I really do. Just from that camera angle.
Yeah. This is the legendary court copy machine.
Old
If you
technology.
just
You
step
can fix it
forward
with a
here,
hammer and a brick.
Before you have a seat, if you could turn and face her and raise your right hand, she'll place you under oath.
She can place me under oath anytime.
The whole truth and nothing but the truth in the matter, now before the court, so help you God. Yes. Please have a seat and state your name for the record.
Boom.
Christina Engen, CHRISTINAENGEN.
Mr. Saunders,
There's
the
a
witness
strong
is yours.
jawline.
All right, doctor, how are you employed?
As a psychologist with behavioral consulting.
He's the one that
And,
issued the other
how long
report
have you
that
been
that the
employed,
last witness
with
was just
behavioral
talking about. They
12
brought
years.
both of the experts.
And do you have any degrees?
I do. I have a PhD in counseling psychology from UW-Madison, which I earned in 2010.
And I guess what do you do as a psychologist with behavioral consultants?
Ruth Buzzy.
I conduct
Oh, no.
almost exclusively criminal forensic evaluations.
And we've heard that term a few times. What is forensic evaluations? What does that mean?
The Court principals will approach a psychologist with a psycholegal question. So a psychological question that applies to the legal situation, and our job is to help answer that and to provide information to the trier of fact, the judge or the jury, to help them answer that question.
Are some of those evaluations that you're asked to conduct what are referred to as NGI evaluations?
Yes.
And I guess, what does NGI refer to?
It's for the plea of not guilty by reason of mental disease or defect. It's an evaluation of criminal responsibility.
And you have performed those evaluations in the past?
Yes.
Are you able to approximate how many NGI evaluations you've completed in your career?
Over the course of 12 years, approximately 250 NGI evaluations.
And are those typically done at the request of a court?
Yes.
Have you, in your career, in those 250 evaluations, reached an opinion that somebody would be appropriate for an NGI plea?
Yes.
And contrary, have you formed the opinion that they are not, they don't fit for the NGI plea?
Yes.
All right. And doctor, do you maintain a curriculum vitae with respect to your educational background and qualifications?
Yes.
All right.
Showing us the mark exhibit 12. Do you recognize that?
Yes.
And,
That's my resume.
It is my curriculum vitae.
And does that appear to be
Wait, what? Curriculum
up-to-date?
vitae?
Yes.
All right. That's a document that you prepared?
It is.
I'd move 12.
Shed.
Any objection? No objection. 12 will be received.
Do you maintain any licensures?
Yes, I'm licensed to practice psychology in the state of Wisconsin.
And are you also board certified?
I am.
What does that mean?
I'm board certified by the American Board of Professional Psychology.
We come from the land of Vore Dyer,
specialize
so I ain't
in,
criticizing her
several
pronunciation on
different
that.
areas of psychology. My area of specialty is forensic psychology.
And do you maintain any professional memberships?
Yes.
And what are some of those?
With the American Psychological Association and the Wisconsin Psychological Association.
In addition to your employment, do you also, or have you had any teaching experience in this role?
Yes.
All right. What are some of those?
I'm
so good at my job, I teach others how to do it.
For Marquette Law School, for trainees at Mendota Mental Health Institute, once for the Department of Corrections psychologists.
Doctor, then I want to ask you about this case. Did you become or asked to become involved in an NGI evaluation of Taylor SCHABUSINESS?
Yes.
And how did you become involved in that?
I was court ordered to conduct an NGI evaluation.
Were you retained by the state of Wisconsin?
Appointed by the court.
By the court, but not the district attorney's office?
Correct.
And you weren't retained by the defense either?
Correct.
And is it's the case that most of the evaluations you perform are at the request of the court?
That is correct.
And did you ultimately prepare a report with respect to your findings regarding that NGI evaluation?
Yes.
Margot, tweak your monitor. That's red.
Recognize that exhibit?
Yes.
And what is that?
It's a copy of my report.
Does that contain your, I guess, factual findings, and ultimately your opinions with respect to the NGI evaluation?
Yes.
I'd move 13.
Any objection?
Subject to cross, Your Honor, no objection.
13 will be received.
So I guess generally, can you describe the process that you undergo to conduct an NGI evaluation?
Yes, the evaluation consists of a clinical interview, so a meeting with Ms. SCHABUSINESS. I also conducted a full discovery review.
I love these
There's no
so review
SCHABUSINESS
of all
like
of the police
SCHABUSINESS like
reports,
no SCHABUSINESS I
videos,
know. Methyl Merman.
Documents of that. And then I also, in this case, reviewed her available medical records, which included a prior competency evaluation, records generated through Brown County, and then in this case, I did administer psychological testing.
So I want to first start with the clinical interview that you mentioned conducting.
If we don't inject a little razzle dazzle,
what date
you guys are going to get bored.
The date that you met with Ms. Business.
So I attempted to meet with her first on October 12, 2022. However, because of her security status in the jail, I was not able to meet with her confidentially. So I returned on October 21, 2022, and we met in a conference room. That's when I conducted the interview and the psychological testing.
October 21st, 2022, would that have been about 8 months after the offense that she was charged with?
Yes.
Okay. And you also mentioned you conducted a full discovery review, and that included reviewing videos. Is that right?
Correct.
Okay. Was one of those interviews that you reviewed an interview of Ms. Business from February 23rd of 2022?
Yes.
Was that a rather lengthy interview?
It was.
Did you review the entirety of it?
To the best of my recollection, I believe that I reviewed the vast majority of it. If I would say the majority of it.
All right. Were there a lot of dead parts in the middle of it?
There were, but I thought it was important to review that video footage to listen for comments that Ms. Business would have made in the room by herself to observe her behaviors and the like.
So it wasn't just the comments that were made to law enforcement that you were looking for, but also her independent behaviors?
Correct.
And you also mentioned you reviewed the police reports and other various attachments that were part of the case?
Yes.
The medical records that you reviewed, you mentioned there were prior competency evaluations, but also Brown County Health Services records. Is that right?
Correct.
Was that in reference to a stay at Nicolay Psychiatric?
Correct.
All right. And when was that?
Ted, make sure you get my good side.
That spanned March of 2021 to
he looks like the prosecution.
All right. And you then indicated you also conducted a, I guess, personality test, or what was the fourth collateral source you reviewed?
I can administered an objective personality test. It's called the Minnesota Multi.
Just a second. We're uneffing ourselves here. Hang on real quick, guys.
Do not adjust your screen. We're currently experiencing technical difficulties.
So
We'll be right back.
Go through your report if that's okay, Doc.
All right.
Apparently not.
We are currently experiencing technical difficulties. Hang on.
Okay. Well, this chick certainly seems to know what she's talking about, which is good.
The history is part of your NGI evaluation.
Problem solved.
When gathering history about a defendant, we are touching on topics that are potentially relevant to the issue of criminal responsibility. Things like early childhood events, history of mental health treatment, substance use, any learning difficulties, difficulty working, all of this can potentially inform the issue of criminal responsibility.
Okay. And as part of that, did you review Ms. Business's employment history?
Yes.
And I guess what did you note with respect to her employment history?
What I recall is that she has worked primarily in factory settings. Relevant to this evaluation was that she was working up until about a week before the underlying offenses.
Why is one's employment history relevant to an NGI evaluation?
It speaks to the prong of behavioral control. So later on, when we discuss the prongs of the NGI plea, one of them has to do with one's ability to conform their behavior with the requirements of the law. It's a capacity issue. So can a person do that under normal circumstances? And one's ability to work, maintain employment, show up, perform their job duties, that speaks to an individual's capacity to conform their behavior and meet the demands of daily living.
Okay. And you noted employment history fairly consistently up to about, I think you said a week before the offense?
Correct.
And you also reviewed Ms. Business's mental health history as well?
Yes.
As we talked about. And As well, did you review her during the course of your clinical interview with Ms. Shabusiness, her current presentation?
Yes.
And I guess what is the importance of kind of noting as you do the current clinical presentation of a patient?
So that's another piece of information that informs the diagnosis that is required of the evaluation.
Okay.
You muted, Jeff.
Then following in Joe's
As
footsteps,
part of the clinical interview,
our very own
with Ms.
Chandler.
Shabusiness, do you get a narrative from her about the alleged offense?
I'm glad I was muted because I accidentally called her Chandler
To the
Halverson.
extent that I was able, I did.
I did not.
Ms. Shabusiness recalled the time period leading up to the offenses, but then she reported that she had no memory for the offenses themselves, and she did not. She reported she did not regain memory until after her arrest.
Okay. With respect to Ms. Shabusiness recalling the time period leading up to the offense, what sort of information did she provide?
What I learned was that she had been living in Texas and returned to Wisconsin in early 2022 to tend to legal matters. She made a court appearance. I believe she was sentenced to 5 years probation. She was making arrangements to have her community supervision transferred to Texas so that she could resume caring for her newborn baby, who was in the care of her grandparents. She was working. She had started Suboxone treatment to maintain sobriety, and
drug treatment
I understand that
to maintain
she
sobriety. I like
struggled during this time period, was feeling what sounded like to me some alienation in the workplace, not feeling like she was connecting with her coworkers, and then began to, she reported to me she was hearing voices that were telling her to relapse on methamphetamine.
Okay. And some of those, you mentioned, employment, you mentioned some arrangements with respect to childcare. Why are some of those acts kind of relevant from an NGI evaluation standpoint?
Again, it speaks to the issue of one's capacity to conform their behavior. So all of those are very goal-directed tasks.
And those were all kind of leading up to the date of the offense.
Has the defense focused on inability to control
February
or
21st,
on not
2022,
being able to tell the difference
specifically,
between right and wrong?
did she have a narrative
focused
about
on nothing.
sort of the timeline of events?
That
leading
sounds
up
like they're
to
closing
the,
arguments.
offense?
Yeah.
Yes, on February 21st, 2022, she recalled that she was socializing with friends. They had come to the residence she
Can I
was
just
staying
point out that if you're
in.
going to change your
I
name
believe
to
they were
Shabusiness,
smoking marijuana.
there got to be a whole bunch of Z's in
She
that name.
expressed
If
an
that's what you're
interest in
changing it
finding
to.
methamphetamine, and so
She
said that
missed a
went
trick or
on
two on this, honestly.
quote, meth hunt, end quote.
Did she indicate whether she had ingested
I'd love to know the
methamphetamine
story
leading up
behind
to the homicide?
Yes, she told me that she took 52 hits.
Because
of
I got
methamphetamine.
her. Because I got her.
Did she also
Because
refer to
I
that
took
amount as,
52
quote,
hits of
a lot?
something.
Yes.
All right. And did she indicate at some point that night meeting up with the crime victim, Mr. Therian?
Yes.
Yes, Digger
And
Taylor
then
is
you
the mother.
indicated around
And the
the
father was
time
also in prison
of
at the time, so-
alleged offense, she reported having no memory of that time.
Correct.
Did she, and then you indicated she regained her memory sort of in speaking with law enforcement.
Yes.
Was that professed amnesia of a concern to you?
It was notable. As I indicated in my report, I found her self-reported amnesia to be inconsistent with my review of the discovery material. So specifically, I observed her describe in great detail to the detective the details of that evening. So that stands in contrast to her self-reported amnesia in the present or at the time of the October interview.
You also indicated during the interview with Ms. Shabusiness, you performed some psychological testing. Is that right?
Yes.
What testing did you administer?
No, she had
It was
52
the
hits of what?
MMPI-3.
I missed that.
What is the MMPI-3?
Not
It's
sure.
a very well-established psychological instrument dating back to the 1940s, very well researched and respected. So this test can provide indication of
52
different
hits
types
of
of
meth, okay.
psychopathology or different types of mental illness. It also contains a number of validity indices to help psychologists understand the response style of the test taker.
This cameraman is more
So
schizophrenic than she is.
The validity
They're the
indices,
worst.
I think I said that right, that you mentioned. I guess
I used to say as a
What
joke,
does
but
that
they've
mean?
gotten worse and worse.
What
They're
that
terrible.
means is that built into the test are
Oh,
several
they keep getting the
items
local
that,
high school AV tech
um,
to do it. It's,
when they're all combined.
I mean, they
at the
showed the
end,
damn jury yesterday for crying
they'll
out loud.
indicate if a person is
They should- and by the
answering
way, that whole
questions in a
incident with the
forthright
juror,
manner, if they're minimizing
someone
their
sent me in
symptoms,
my
or
locals
potentially
a
if
clip
they're
of when I called
exaggerating
it.
their symptoms.
I was like, "Why are you showing the
So
jury?" It was on day
is
one.
this test like
They
a
panned over the
true false
jury.
questions, or how does
Well,
this
that
test
was the
administer?
gallery. I watched
Correct,
that
it's
back.
a true false.
Was it the gallery?
Yeah.
And I guess what were some of your findings with respect
How do
to
you know?
It wasn't the
business's
gallery
performance
yesterday.
on the MMPI test?
Oh, yeah, they
Well,
they
first,
actually
let me
had
be clear
him
that
calling out the names of the
the
alternates.
test does not say anything
And they
about
showed it like the
Michigan
Price is
Business's
Right.
functioning.
John Bannister, come on
in
there.
February of 2022. It only provides information about her
All
function
right,
at
let's
the
get
time
back
of
to the
test.
testimony here.
So what was relevant from that was that there was indication of symptom exaggeration. She responded to items. She endorsed a number of symptoms that genuine individuals with genuine mental illness would not endorse. The frequency, number of unusual symptoms that she acknowledged was greater than those with genuine mental illness. And then there was also indication of non-credible memory impairment built into those, the results of those validity indices.
So I just want to go back a little bit. That was a good point. So this testing is sort of in the moment as you're meeting with Mission Business. Is that right?
Correct.
But why is it still something you administer in the course of an NGI evaluation?
So getting back to that term of response style, that's very important to understand if the individual is being forthright in their account of information that they provide to me. And what I found with these elevated indices indicating the exaggerated descriptions of mental illness, unusual descriptions of mental illness, is that the information that was being reported to me needed to be interpreted with caution. Mission Business's self-report could not be taken at face value.
And I think you state that anything that's not objectively observed should be closely scrutinized. Is that right?
Correct. So then it would be important to find other sources of information that would support what she's telling me versus relying just exclusively on her self-report.
Okay. And one of the phrases you used was endorsed symptoms. What does that mean?
For example, I'm just making this test example up, but I feel depressed. A true response would be an endorsement of that symptom.
So an endorsement is something somebody's telling you.
Yes.
All right. So based on the interview you had with Mission Business, your review of some of those collateral sources of information, were you able to offer an opinion with respect to whether Mission Business was suffering from a mental disease or defect?
Yes.
And what was, I guess, that opinion?
I reached the opinion that while she did have a mental health conditions, these did not appear to qualify as mental diseases and defects.
In your report, you outlined, I guess, 3 mental health conditions. Is that right?
Extreme close-up.
What are those?
The diagnoses that I offered were methamphetamine-related use disorder, and that was applied in acknowledgement of Ms. Business's general use of methamphetamine in that time period. The diagnosis of methamphetamine intoxication was applied because she was using methamphetamine at the time of the crime. And then the final diagnosis I gave was methamphetamine-induced psychotic disorder. And I offered that one because Ms. Schabusiness was describing, and the records contained indication of paranoia. I think she made a comment about muscle rebuilding during the homicide, and this
It's okay. You can call it murder
indicated
now.
to me the
She's been
presence of
convicted.
psychotic symptoms, which I attributed to the recent methamphetamine use.
So, and that's a question I have. So mental health conditions, in your opinion, are different from mental diseases or defect.
Correct.
And the three diagnoses you offered, you stated those are not mental diseases or defects.
That is my understanding.
And why is that?
Because, excuse me. So if one ingests an intoxicant voluntarily, so they took it of their own volition, and if they were not naive to its effects, that would mean it's my understanding, based on the case law, that the defendant would be subsequently responsible for all alterations of thinking, judgment, behavior related to that intoxication.
I guess, were you aware of any information in the materials you reviewed that Bishop Business's methamphetamine use was anything but voluntary?
No.
And that obviously she reported a history of using methamphetamine to you?
Yes.
So I guess, were you of the opinion that she was not naive to its effect?
Correct. Yes. And I'm also aware that she had psychotic symptoms in the context of methamphetamine use the year prior. So certainly she was aware of its effects, broadly speaking, to include psychosis.
So I want to pause just here. Methamphetamine use in general, I guess, in your
shots every time
experience
the
in your
lawyer
education training,
and
are
the
you aware
witness
of
say
some of the symptoms that may manifest as a result of that?
Yes.
And what are some of those?
So excessive energy, decreased need for sleep, and then oftentimes we see in the field of forensic psychology that it can induce psychotic symptoms. So misperceptions of reality and paranoia.
9 times.
You also mentioned a year prior there was a diagnosis of at the Nicolay Psychiatric Center. Is that right?
Yes.
And did you consider, I guess, the applicability or the appropriateness of a bipolar I disorder?
I did.
And what was your conclusion with respect to that propriety of that diagnosis?
After considering the diagnosis of bipolar I disorder, I did rule it out because I am aware that being intoxicated or having a methamphetamine-induced psychosis can look virtually similar or indistinguishable from a manic episode with psychosis. So the two look similar. And so what I would be looking for if I were to support a bipolar I disorder diagnosis is the presence of that psychosis and the mood elevation when there's no methamphetamine use present.
And are you aware of any of those symptoms absent in the context of methamphetamine use?
I am never, I'm not aware of a time ever that Ms. Schabusiness displayed psychotic symptoms or elevated mood outside of the methamphetamine use.
And I guess you are aware, though, that bipolar I diagnosis was applied to Ms. Schabusiness in April of 2021.
Yes.
Are you aware, though, that there was concerns about recent methamphetamine use around that same time?
Yes, I believe that she tested positive for several drugs, including methamphetamine at that time.
So that's why that's not a diagnosis you are willing to give to Ms. Schabusiness. Just clarifying the testimony. I'm just clarifying the testimony.
Overruled.
Thank you. So I guess in sum then, is there any mental disease or defect that you would diagnose Ms. Schabusiness with?
Yes, also offered at Nicolay or Nicolette, I'm not sure the pronunciation. There was a diagnosis of I believe it was polysubstance abuse or something to that effect, meaning multiple substances were being abused at that time. I believe that's an appropriate diagnosis for her. I do believe that I believe firmly in the diagnoses that I offered in my report.
Okay. But those are not diagnoses that I guess are mental diseases or defect.
Correct.
Okay. Did you also then reach an opinion with respect to the, I guess, second question or the second part of the NGI evaluation, whether she was responsible for the conduct?
Yes.
All right. And what was that opinion?
I found insufficient support for the conclusion that as a result of a mental disease or defect that she either A, was unable to conform her behavior to the requirements of the law, or B, was unable to appreciate the wrongfulness of her conduct.
What are some of the reasons you reached that conclusion?
Well, first, and most importantly, I was not able to find support for a diagnosis that would qualify as a mental disease or defect. So really at that point, then the analysis could end. That's a requirement of the plea. But I found in my report, I outlined various different factors, but focusing on the two issues, one's ability to conform their behavior to the requirements of the law and one's ability to appreciate wrongfulness. First of all, I did pull from her behavior outside of the moments of her known intoxication to observe that she was able to engage in very goal-directed behavior. So I assumed that any alterations in her behavioral control were directly related to the methamphetamine use. So that was the first issue. And the second issue having to do with wrongfulness, it was my opinion that she did demonstrate appreciation of wrongfulness. There were several comments that were made to law enforcement expressing apologies.
I'll take a million
the
over
victim's
3
sister,
likes. I hate when people say like. I'll
indication
take
that she
ums
was
any day of the week.
trying to conceal the
Ums are greater than likes.
the body
tend
was
to agree.
dismembered because she wanted to conceal it. These all speak to awareness of consequences, appreciation of wrongfulness, that she grasped wrongdoing had occurred.
And did you also consider, I guess, the validity of the professed amnesia for the time surrounding the offense?
Yes, I did not find the self-reported amnesia to be credible. First of all, there was that disconnect between what she was reporting to me in the interview as compared to the recollection she had during an interview with the detective immediately thereafter. And then I also found indication in the results of the MMPI-3 that she was not, she was reporting incredible memory impairment.
Damn, she got me.
That's pretty solid.
Jump cut.
Do you have just a few more questions, Doctor? Your report was done in November of 2022, is that right?
Yes.
And subsequent to that time, have you had the chance to review any other NGI evaluations conducted in this case?
Yes.
And who authored those reports?
Diane Litton.
Okay. And
she's
in your
batshit
review of
crazy,
Dr.
isn't
Litton's
she?
report, did any of her findings or conclusions alter your opinion from November of 2022?
No.
I guess the same opinions you're testifying here to today?
It did not alter my opinion.
Okay. And then all of the opinions that you're offering here today, are they to a reasonable degree of professional certainty?
Yes.
Thank you, Doctor. Nothing further, Your Honor.
Cross-examination, Mr. Freilich.
Would we be able to take a break right now or not?
Okay. Ladies and gentlemen, we'll take a 10-minute break and we'll resume. All rise for the jury.
All right. Well, we'll put the court out here for just a minute. Wow. So how's it going for the defense? Are they winning?
Oh yeah, amazing. They're doing so brilliantly.
It's textbook right here. Textbook.
Jack, can you uncuck
Hang
me,
on.
please?
I am. Just hang tight there. Never.
Thank
Never.
Oh,
Never.
That was good.
Know your role, woman. Sorry, it went all Andrew Tate there. Sorry.
How you doing? Are you holding up? You're awake still? I'm kind of shocked.
I'm just running on fumes at this point. I'm just
Yep.
running on silliness. That's all.
Yep.
Yeah. Just one more day. I doubt we'll make it the entire day tomorrow. I'm pretty much sure that if they don't actually come back with a verdict today, they're going to do it early tomorrow. So we're good. We do have a couple of super chats here, if y'all don't mind, before we get into the nitty gritty of it here. AA Ron says, objection, Tank Rat is overachieving here. Tank Rat is an overachiever.
Tank Rat is a straight up G. I mean, straight Tank Rat, like, well done. Awesome.
And Fiery Red Podcast. Hello, Jeff and Hayden. Well, now we've added Chandler and Joe. So how's the shit show going? It's as to be expected.
It's going.
Ella Cole, thank you so much for the 20-pound super chat. Going to share my psychosis story. Don't laugh. My bullies and puppies
You have to
and I
read
ended up...
in British accent.
Yeah, it's not going to happen.
I want the
I
British
ended up with-
affectation here. Going to share my
not-
psychosis story. Don't laugh. Don't laugh. No, that's not.
So when are you going to start the
do you
British
wanna read it, Joe?
affectation?
But
And I ended up with some sort of secondhand PND. Thought I'd vacuum them up so I didn't hoover for 6 weeks. Thought I was throwing them in the bin. Was wild. The brain is a brain is a wild thing. And again, one great book on the things that the brain can do. The brain issues is a book that the ever popular and ever wonderful Mr. Coleman reminded me to read. He recommended to me, called "The Man Whose Wife Thought She Was a Hat." Ron Coleman suggested that book, and what an amazing book that was! It tells you the amazing power that our brain has to really do things it's not supposed to do. Nathan C, we can call her Dr. Again, I'll take ums and uhs over likes any day of the week. But
Yeah,
I prefer they
was,
did neither.
I was constantly criticized as a child anytime I said the word or so God damn it, I said it. Okay, never mind.
There you go. Yeah, sorry, your arguments are invalid now.
I try not
AWOL Stingy. She saw him come in and went, "Hi, champ." That's an Australian
Stuff you,
thing.
Stingy.
The amateur iconoclast. Thank you so much for your super chat, gentlemen. Let Shad's sad face be a cautionary tale. Pegging, dog collars, crazy or drugs. Follow Lord Humongous sage advice. Just walk away. Whatever happened to Humongous anyway? Recall of Grandma Spiegel for rebuttal. No, they just missed her. She's gone.
I
That's
missed
it.
her
She's
this morning.
no, you
I
didn't.
heard
You didn't
things.
miss her. You didn't see her. You didn't miss her. You just didn't see her. Nobody would miss her.
I don't know what happened there, but apparently it was
The same thing that happened. The same thing that happened during the competency hearing, but worse. Josh with the $10. Could Taylor change her mind about remaining silent at this point and testify on rebuttal? It might help prove she's psycho if she sits there and clucks like a chicken for about 10 minutes. Well, clucking like a chicken 10 minutes now isn't going to help her, because this is all about what was her mindset at the time that the murder was committed. What she does now has zero relevance.
And let's be clear, people, that guy with the bald guy that was giving the testimony before was saying that she was faking so hard she was off the scale of the chart. I think sitting there and clucking like a chicken is going to do the exact same thing.
Yeah, pretty much.
And at this point, the defense is closed, so now she's done.
Dark Lotus for the lost sheep and lols. Oh, lost sleep. Yeah, for the lost sheep. Yeah. The prodigal son returns. For the lost sheep, I said it again, and lols. Dark Lotus. Let's just move on. Thank you. Tank Rat again with another 20. Hey, Joe. Glad you could join the law racks and token Aussie on the wild ride of a trial. Hi, Chandler. Good to see you. And the Jackals of Terra Argentum. Whose garbage truck is backing up?
Ain't mine.
Oh, it's Chandler's garbage truck. If she's really insane, she made herself insane via meth when she was sane. So to the cell block she goes. Hopefully with the unfriendly cellmates who prefer giving wackos the old Yeller treatment. The old Yeller treatment. I like that. The old Yeller treatment. Busy Mom 4KC has been a new member. Thank you so much. Thank you so much for that. Deeply appreciate it. And Sirkin, great book. This is Your Brain on Music. Okay, This is Your Brain on Music. I'll have to watch that. I originally, way back in the day, started my college after a music therapy major. Merms. Hey, Merms, welcome back. Another 20 pounds. Joe, you want to read this in a British accent? No, I knew you didn't. Thank you, at Tank Rat. Jeff, do you have an sensor? Please read this in a British accent. Too late. It ain't going to happen. Maybe Joe wants to take another stab.
What?
Take another stab at the English accent?
No, it's your super chat. You freaking read it in a British accent.
And Jacob's Proud Madre. Hey, it's been a while. Welcome back, Jacob's Proud Madre. Got the 4
good to see
hearts
you.
there. Awesome, awesome, awesome. Dread Pirate Wesley says, "Nice pipes, Legal Vices." Yeah, this is my Cthulhu pipe. It's actually a pretty damn cool pipe. So it's full on Cthulhu carving here.
That's
and
gorgeous.
actually, just today, the guy that carved my Cthulhu pipe, I've commissioned a Lorax pipe from him as of today. It'll be the
sweet.
cowboy hat, beard wearing Lorax pipe. I actually commissioned that earlier today from the same guy that made the Cthulhu pipe. So it'll be good. Jeff, back in the day when you first moved to Korea, how long did it take you to learn the language? 6 months to be able to function, about a year to be comfortable. And then the next 33 years were spent realizing that I don't really know anything.
I mean, you know
that's,
more Korean than
that's it.
the rest of us combined. So, you know, there's
Probably, yeah. Yeah, but it's like in learning any language. The more you know, the more you realize you don't have any idea. So anyone's like, "Oh, I've been here for a year, I'm fluent." You're like, nah, no, you're not.
No, I've tried to learn
Anyway,
French
that's
for
a-
like 15 years and I still don't know it very well. I can still speak at like maybe the level of a 6-year-old. So I can speak in the present tense. I can't speak in the future tense or the past tense. So I'm perpetually stuck in a state of
Stuck in the now.
in the now. Yeah, exactly. I am
Well-
being here now. So, you know.
So here we are. We're wrapping this thing up. Any comments, Joe? How it's going?
So-
The testimony here.
There's supposed to be one more witness after this, and that's it.
I think this is it.
This is the last
Did
one.
I think so.
She scuttled her own case in so many different ways. She and her. I mean, recognize you have to. She's 2 elements she's got to establish. She's got to establish that she had some sort of mental defect prior to the incident, and then you have to show an inability to determine between right and wrong, or an inability to control her own actions. And so many different ways in her confession, she actually showed that she understood the difference between right and wrong. Even starting with the phrase, I think I completely blacked out, which is like what someone would say when they're trying to cover up because they feel guilt about something. She says, I think I completely blacked out right before she starts giving details about everything that happened.
Yeah.
So she definitely did not black out. So why are you saying, I think I blacked out, unless you recognize internally there's some shame you should have here because you recognize internally you did something wrong. So over and over again, when she's afraid of someone coming downstairs, you're not afraid of someone coming downstairs if you think that everything you're doing is totally normal and totally okay.
Right. She also
Well,
said,
and
like,
then
tell
saying-
his sister I'm sorry. You know, that shows, you know, remorse. It shows, you know, a conscience. It shows an awareness, you know, that she harmed the victim, that she harmed his family, that she took him away from his family.
Yeah.
She knows what she did. She's aware of it. That statement, I thought, you know, like, tell his sister I'm sorry. I thought that was extremely, you know, telling of her conscientiousness of the crime.
Mm-hmm. Yeah. No, I
Well,
agree.
the problem also with that statement, I blacked out, was when she said, and then after I came to, he was still alive, so I decided to keep on doing it. That
Right.
makes it work. That just makes it a little-
Yeah, that's kind of the nail in the coffin.
And that she liked it, and that, you know, she enjoyed it.
yeah.
I thought I think he banked too much on the whole insanity defense rather than just saying she doesn't think like you. So it's very likely she's someone who admires Jeffrey Dahmer. I mean, so much so. And he should have leaned in on that. Once the Jeffrey Dahmer stuff was in, he could have really leaned in on that and said, look, you're asking yourself, you said, how do we know that this was not an accident? There's only one piece of evidence that tells us that was not an accident, and that piece of evidence is her confession. That she says, but the point is her confession. This is the confession of someone who admires Jeffrey Dahmer. So if it happened, as you have to know beyond a reasonable doubt that it was not an accident, that it was definitely intentional.
See this? I'm sorry, I thought you're done.
No, I'll let you. I'm just saying.
No, I thought you're done. But have you guys seen this picture? This is I found this somewhere on Twitter, and I can't find the original poster to give them credit for it. But this was allegedly showing how far down the I wanted Jeffrey Dahmer someone goes. Where did we go here? Yeah.
Damn.
Wow. Yeah, showing the comparison between
crazy.
Dahmer and the person that she deleted.
That is
Wow.
crazy.
I actually have never seen him. I don't know what he looks like up until
That's
now,
what he looks
but-
like.
Wow. I mean, I
Yeah.
didn't know what he looked like until now I do. But that's incredible.
Like, even the hair swept the same way in that photo. Far out.
Yeah.
I mean, I feel like
Yeah,
when he was talking about when defense was, sort of like, trying to get the Google searches taken out, he really could have just said, Your Honor, she's a white woman. Of course she's going to be interested in serial killers. There's not, that's normal.
Okay. Before we bring the jury out, just
Hi, Steve.
briefly,
And math.
And dogs.
Are you interested in serial killers? Oh my gosh.
had distributed to you
Why do you think I'm
a
here?
set of instructions and a proposed instructions and a proposed set of
Oh yay, jury instructions. I came in just in
as to how
time.
they should be given.
No,
There's
they still have to do
certainly
some finish up
other
cross
instructions
examination.
that could be given that were
This
given
is the dream
to the
team
jury
right
the
here. Look
first
at,
time.
look at who we got here. We got
regarding
Chandler,
objections of
Joe,
counsel,
Ozzy, and
improper
Bison.
questions, things of that nature. Although
Well,
they've
and you
gotten
complete
all
the
those
dream team,
instructions already, I'm not sure the need to do that. But I'm going
I'm
to start
just
with the
dreaming.
state. Mr. Saunders, do you have any feedback regarding the proposed instructions I laid out? Alternative suggestions?
No, and I have no additions. I'm fine with the ones the court selected. I guess our one quibble, our preference would be to do the instructions then closing, but that's the only change the state would have.
Mr. Freilich?
Your Honor, I agree with that. I'd ask that the court give the jury the instructions and then we can do the closings. When I look at 605B on question 1, it talks about at the time the crime was committed, did the defendant have a mental disease or defect? And then in question 2, it says, it uses the word mental disease or defect as well. I'm wondering if the court would consider mental disease or mental defect.
What?
So it's either a mental disease or a mental defect.
Sure. I'd certainly consider that. The other thing is you'll note, and I'll consider the issue that you've mentioned regarding when I give the instructions. And I want to just a brief conversation about that, but we can take that up when evidence is concluded. I gave you 605B. It was actually 605B, the version with the comments, because of the paragraph on the second page.
I was going to bring that up, yeah.
605B, the comment about the possibility of using the phrasing mental disease and defect, and then it's cited the case. I don't think that's appropriate to use and in this case, given how the evidence comes in. That case that cites phrasing it mental disease and defect apparently was in a situation wherein the assertion was that there was a combination that went into the events. A mental disease and defect were co-occurring, and so counsel asked that the word be changed. I don't think that's what's going on in this case. The evidence seems to come in this case that either there is a mental disease or a mental defect, and there's one or the other, and the jury can look at it and decide. They can choose either one, but it's not a case where we're driving at a specific argument that there's a combination of the two and therefore changing the word to and. Nonetheless, I wanted to call it to your attention. I don't have any problem with your request, Mr. Freilich, to change that question 2 to as a result of the mental disease or mental defect. Any problem with that, Mr. Saunders?
No.
Any concern with leaving it as an or, Mr. Freilich, versus an and?
I've always thought that it was an or, Your Honor.
And that's the pattern instruction. I only provided that one case note to indicate that there is a situation in which it was changed to and that's permissible. I don't think it's appropriate for how the evidence is coming in this case, but I'm going to leave it as or. You're not asking for anything else. You don't have any objection to or, do you, Mr. Saunders?
No.
Okay. Very good. I'll add that one word in, and then we'll discuss the order of the instructions versus your closings at the conclusion of the evidence, and we'll actually have an official instruction conference at that time. Okay, then anything else before the jury comes in, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
All right.
And while we're waiting for the jury to come in, I just wanted to take a quick second to wish a super special happy birthday to one of our channel OGs, one of my mods, channel of her own. It's Flux's birthday today. Everybody give Flux a super birthday shout out. Cheers to you, Flux. You rock. Thank you for being here. Thank you for being such a good supporter. And thank you.
Happy birthday,
Thank you
Flux.
most of all for being a super friend. Happy birthday.
We love
Happy
it.
birthday, Flux.
There you go. Happy birthday.
At least her shock girdle, kind of keeps her little trim there.
It's like Spanx, but for convicts.
Hey, be seated. All right. Then
New from Bonds.
We're
Shocks.
back on the record, and we're up for cross-examination. Mr. Freilich, do you have cross-examination?
Yes, I do, Your Honor. Thank you very much. Dr. Engine, good afternoon.
Hello.
Hi. So you work for Behavioral Consultants, is that correct?
Yes.
That's in Milwaukee.
Yes.
Is that part of the Wisconsin Forensic Unit?
Wisconsin Forensic Unit is a division of behavioral consultants.
How long of a commute do
And
you have
with
every
regards
day?
to this case, you did not do a competency evaluation. You did an NGI evaluation.
Correct.
You met with Taylor SCHABUSINESS, correct?
Yes,
You recognize her here?
I do.
And ma'am, you met with her at the Brown County Jail.
Bitch, please. I
October
know who she is.
12th and October 21st of 2022.
Yes.
Have you met with her since?
No.
So is it fair to say that it's been about 9 months since you've seen her, correct?
Yes.
The first time that you tried to see her, there was some sort of a security issue going on and you were not allowed to see her. Is that correct?
I was allowed to see her, but only cell side, and I thought that would be inappropriate to conduct an interview cell side.
As far as the things that you did to, put your report together, you relied on the 2 clinical contacts on October 12th and October 21st of 2022, correct?
Yes.
You administered the MMPI, the Minnesota Multiphasic Personality Inventory 3, correct?
Yes.
I see that number changes oftentimes. Has it changed?
It actually, I can't recall how long it was the MMPI-2, but it was that edition for several decades. And the MMPI-3 was based on 2017 population estimate. So it's a relatively recent addition.
And it gets updated and upgraded every few years. Is that fair?
No, it was many decades before it was updated.
Okay. And it's essentially a true-false test?
That's the response format. It's more complicated than that.
Okay. What kind of questions are on this MMPI?
Better ones than you're asking.
So I provided, an example that I made up, but there's various statements, and the respondent is asked to respond true or false if they agree or mostly agree with the statement, or disagree or mostly disagree with the statement.
Strongly disagree?
I can't recall the test instructions, but
fair?
something to that effect.
Do people that have, education issues or lack of education, do they struggle with the MMPI?
There is a reading level that's required to administer the MMPI. I don't recall it off the top of my head.
How many questions are on the MMPI?
About 335.
Okay. How long does it take to get through the test?
In the case of Ms. SCHABUSINESS, I believe it was completed within about 90 minutes, maybe an hour and 45 minutes.
Sometimes longer if you have difficulty reading.
Could be.
Okay, so you've just testified that your
done.
client has no problem reading. Thank you.
You reviewed some police reports in this case?
Yes.
A criminal complaint and some video footage, is that fair?
Yes.
Photographs?
Yes.
How did you get that information?
It was provided as part of the entire file. That's standard. It comes along when we receive a referral for an NGI evaluation.
Was it sent to you by the district attorney's office?
My office would have taken care of that. I received it from my office.
Okay. And then you looked up some information on CCAP, the Circuit Court Access Program?
Yes.
Basically a search on the internet of her background?
Correct.
Specifically her prior record?
Yes.
And then you looked at some Brown County Human Services records?
Yes.
Would that be the Nicolay Psychiatric Center records?
Yes.
Okay. So you looked at those?
Yes.
And then you looked at some jail records?
I did not. I requested the jail records, but they had not been received.
And was there a request to see some Purveya health records?
Yes.
Did you get to see those?
No.
Okay. Did you review any Bellin health records?
No.
Was it your understanding that Taylor SCHABUSINESS had some treatment stays at Bellin Health in the past?
Yes, I understood that she attempted suicide at age 14, resulting in the admission to Bellin.
And what about at Purveya? Was it your understanding that she had gone there for some mental health treatment as well?
Yes, outpatient treatment.
Okay. So you were missing the Bellin records and the Purveya records, correct?
Correct.
Now,
wow, Mike Morrison bringing the heat.
got some relevant history, some
super
background
chat.
information about my
Thanks
client.
for providing
correct?
so much
Yes.
entertainment this week for
You
all of us. It's
found
really
out
been
that, she was
appreciated.
born in
Wife
Chicago.
and I bought our anime Matsuri tickets
Correct.
last night to
She was
meet everyone
raised
and
in
hang out.
Lindenhurst, Illinois. Is that
Cheers
fair?
to you, brother.
Yes.
Thank you so
And
much
she
for
moved to
that.
Green Bay
Cheers.
in
You're a
2009
great man. Thank you. for
at
the
maybe
support.
age 11.
Appreciate it.
Yes.
And that same year, her mother passed away.
Yes.
Was it your understanding that her mother
Thank you.
died in the house when she was there?
I don't know those details.
Was it your understanding then that she was raised by her father, Arturo Coronado?
Yes.
And then did she also relate to you that she moved to Cotulla, Texas when she was 16 to live with her grandparents?
Yes.
And that she had a series of moves. She lived in Cotulla and Alice, Texas, and Jackson,
Lived in
Mississippi.
Cthulhu, Texas.
Yes.
Then came
Cthulhu,
back to Green
Texas,
Bay.
right there.
Yes.
That's kind of the progression. Is that fair?
Correct.
Oh, you should visit there, Jeff.
You found out that she was also married in February of 2020.
Yes.
And when you were involved, had she given birth to her child?
Yes, that was October 2021.
Ultimately, the child went to live with the grandparents, correct?
Her child was
In
4
Texas.
months old when she committed the
Yes.
murders. Jesus. Ugh.
Did you garner information that she was in an abusive marriage with her husband?
What I gathered was that she was married. There was discord within the marital relationship, which led Ms. SCHABUSINESS to rekindle her friendship and romance with the victim in this case, and that would have been in 2020. I can't speculate beyond that, the nature of the relationship.
So she started a romance with the victim, had a baby with someone else in the meantime.
Objection asked and
Gosh.
answered. Just no.
No, that's a different question.
Y'all need Jesus, or depending on whatever religious creator you have. Don't want to exclude anyone else.
So you got some background regarding her life, correct?
Yes.
Did you find out that she went to middle school in Green Bay and went to Bayport High School as well?
I don't recall that specific detail. I know that she graduated high school in Texas.
As part of the educational, assessment, as part of your report, did she report a history of some learning disabilities or difficulties?
She did. She attributed them to a diagnosis of attention deficit hyperactivity disorder.
And was it such that she had some issues with school, suspensions, ultimate expulsion?
Yes, she was expelled, the result of fighting.
Solid. Yeah, it's all the weed. Reefer madness. Reefer madness. That's what does it.
The information that you have as far as your November 14th, 2022 report, it's somewhat stale. Is that fair?
I would disagree with that.
It is from last year, though, correct?
Correct.
Nobody gave you any reports from Bellin Health to review, correct?
Correct.
You could have, doctor, upgraded your report by looking at additional records, Bellin.
She wasn't asked to.
Health and the Purveyor records. Is that fair?
Where I left my report, as indicated on the last page, is that I would be happy to receive any additional records that I was unable to obtain. And I would update my report once received if it changed my opinion. I received no additional records after submission of this report.
Right.
Your colleague in the field is Dr. Matthew Seipel, correct?
Yes.
And did you confer with him with regards to, your opinions, your assessment, your evaluation?
No.
Did you share any information with him?
I did provide him a copy of my records that I obtained from Brown County at his request, and that's a common practice among evaluators.
Sure. But fair to say that he did not he didn't reciprocate by sending you the Bellin Health records that he had?
No, he did not.
Okay. That is something that could have been done, correct?
If I was not alerted that those were part of our practice, I wouldn't have known to request those. And it's not clear to me that Dr. Seipel would know that I was looking for those. Typically, what will happen is that I will receive additional records from one of the court principals with an indication that they would like a second review of the issue.
Does it surprise you that, as far as Dr. Seipel is concerned, I provided the Bellin Health records to him for his evaluation and that he didn't send them to you?
Can you repeat the question, please?
Does it surprise you that, I sent the Bellin Health records to Dr. Seipel and he didn't send them to you?
That would not surprise me because unless he had instruction to provide them to me, that would not be common practice.
Okay. You don't share information then, correct?
Only upon request, if it's appropriate.
This isn't helping.
If it would be appropriate and permissible and specifically requested, but we don't, as a general practice, pass records between doctors.
Okay. If you had received these records, you could have done a supplemental report. Is that fair?
If it changed my opinion, if I felt that it was relevant and added meaningfully to this evaluation, I would have, yes.
Now, as it relates to the Nicolay Psychiatric Center, you had a chance to look at all those records, correct?
Yes.
And was it your understanding that Taylor SCHABUSINESS was committed and she was sent to that facility for, mental health treatment, correct?
Yes.
And you were aware, tell me if you were you aware of an order for civil commitment for her?
I was not.
Okay. Had you ever been made aware that she was under an order to take psychotropic medications?
No.
If I told you that she was civilly committed in April of 2021, where a court of law, determined that she was mentally ill, would that cause you to have any concerns?
It would certainly be relevant, but it does fit with the information I already had, that Ms. SCHABUSINESS was discharged from that facility to outpatient treatment with the goal of receiving substance use treatment.
And did you know when she was at the Nicolay Psychiatric Center that she was under an order to take medication?
No.
Did you know that she was required to take antipsychotic medication?
Yes, I was aware that she was prescribed Abilify, an antipsychotic.
Injectable antipsychotic?
Initially oral, later injectable.
Now, during your 2 contacts with her in October of 2022, did you get a sense that she was suffering from any kind of auditory or other hallucinations?
She reported that to me, but her behavioral presentation to me was inconsistent with her self-report. And the quality of her self-report was not consistent with genuine psychosis.
Did you gain any information that she was suffering from a mood disorder when you met with her?
Her emotional expression was odd when I met with her, but I would, she did not present as acutely depressed or hypomanic, let alone manic. So I wasn't seeing significant indication of a major mood disorder.
You did see in the Nicolay records that there was a diagnosis for her of bipolar 1,
yes.
Correct?
Yes.
With psychotic features, is that correct?
It is horrible.
I don't recall that qualifier, but certainly the record does indicate that she was experiencing psychotic symptoms at that time.
And that is a qualifiable mental disease or mental defect, correct?
Yes.
Do you agree that if someone has an underlying mental health disorder, that using or abusing drugs can exacerbate that mental health disease or defect or condition?
I would agree with that statement.
Don't exacerbate, you'll go blind. That's what my mom told me.
Did you notice that Miss SCHABUSINESS was a poor historian when you asked her questions and asked her to expound on whatever topics of discussion?
A poor historian?
Where I found that she provided a sufficiently detailed history. Where she was lacking was when I asked her to describe her recollection of the underlying offenses.
Did you note her to have memory loss or memory impairment?
I did not, aside from that self-reported amnesia, I did not detect memory loss.
How much time did you spend with her on October 12th of 2022? Do you know?
I would estimate about 15 minutes.
15?
Yes.
Okay. And then, doctor, on October 21st, 2022, how much time did you spend with her then?
I can't recall. My best estimate would be about 3 hours, but again, that's 9 months old.
Long time ago, right?
9 months, yes.
Okay. Do you agree that methamphetamine use does cause brain damage?
It does have that potential.
And how about adolescent long-term marijuana use.
He doesn't
Same
even
thing?
sound interested in his own
I am
argument.
less certain about that.
Certainly, if you're using heroin or cocaine or drugs like that, that can cause brain damage as well.
Yes.
When you met with her, you did find that she exhibited some psychotic symptoms. Is that fair?
No.
In some of the records that you reviewed through Nicolay, did you recall reading anything about a recommendation for her to be on Haldol?
No. And then to be clear with your last question, I did not personally observe psychotic symptoms during the moments
Dude,
of my
objection, there's no
evaluation
question
of the
pending.
business, but I did see in the record indication of past psychotic symptoms, to be clear.
Okay, yeah, thank you.
Don't
Did
help
you
him.
see in the records there was a recommendation for her to be on
He needs all
Haldol?
the help he can get.
No, I don't recall that.
You were asked to opine on the NGI issue, correct?
Yes.
Dr. Seipel was asked to opine on the competency issue, correct?
That is correct.
We're not talking about competency, we're talking about NGI. Is that fair?
Yes.
You had a chance to review Dr. Layton's report. Is that fair?
Yes.
You read through the entire report and you're familiar with Dr. Layton's opinions, correct?
Yes.
And do you agree with her findings?
No.
Of course she doesn't agree with.
You would agree that Dr. Layton's report is more current than yours. Is that fair?
Well, it was authored more recently, but the authoring of the report has little to do with its relevancy because we were both doing an evaluation that was retrospective. So if you're looking at it, my evaluation would be more current than Dr. Layton's because mine was in closer proximity to the alleged offenses. So that's another way to look at it.
But another way to look at it is your, with due respect, your report is lacking because you don't have you haven't reviewed the Bell and Health records, correct?
But that is all post-murder.
It is missing that piece of information, but I would like to point out that it's not common for me as an evaluator when I'm looking at an offense that occurred
This
in
is
2022
only about
to be
what was
requesting
her
records from
mindset
when one
at
was
the
a
time, at the
teenager.
instant she committed the
Those
murder.
would not be, they're certainly generally relevant, but they say little about what was going on in 2022.
Did Taylor Schabusiness tell you that she had no memory of the alleged offense?
She
tell
did.
you? When did she tell you that on both dates? October 12th and October 21st?
I did not ask her about the offenses on the first date. I only asked her on the second date, which is when she reported the amnesia.
That was
More
on
to the point,
October
why is he asking
21st
such
of
open-ended
2022.
questions?
Yes.
Jesus Christ.
And in reviewing those Nicolay records, it's true that she was hospitalized, correct?
Yes.
For about a month, right?
A
A couple weeks.
Somewhere between a couple of weeks and a month.
Okay. And that she was prescribed some medication for nightmares?
I believe that she was prescribed Abilify.
You may have nightmares after
Refresh
murdering
my
somebody.
recollection.
Page 3.
Thank you. Okay, sure. She did say Prazosin for nightmares.
Okay. And it was such that when you talked with Taylor Schabusiness that she was actively hearing voices, those were the comments that she made to you?
Yes.
Did she indicate to you that she was hearing voices in her cell?
Yes.
Who were they of?
I think she was less clear. They were very vague. She may have suggested that she was hearing voices of her coworkers, pejorative in nature. She also said that she was hearing a voice saying, "I love you." I don't know who she said was saying, "I love you."
Can you help me with this? What is a manic symptom?
That would be extreme mood elevation, increased goal-directed activity, decreased need for sleep, decreased risk appraisal. Those are some primary characteristics.
Extreme mood, like throwing a chair at a doctor?
What I gather that you're referring to is the evaluation of Dr. Lighton of
Yes.
Ms. SCHABUSINESS. I'm hesitant to characterize that as a product of a manic episode.
As far as you understand, it happened out of the blue, correct?
Yes.
But physical violence could be a sign or a symptom of follow-up. Follow-up.
Did you have the occasion to review the report from Dr. Tracy Lucetta?
No.
This is a yes or no. You could
Then
have
ask
gone
it yes
back
or no.
to see Ms. SCHABUSINESS after October 21st of 2022. Is that correct? Correct.
If you're looking for a yes or no answer, I'm not able to answer that in a yes or no fashion.
Uh-oh, now what do I do?
The fact is you didn't, correct?
That is correct.
To be fair
Did you
to him,
see,
it's rough.
when you met with her in October, did you see her use odd or unusual facial expressions?
Yes, I believe there were instances of her smiling inappropriately.
It didn't track or it didn't follow, correct? It was out of context. Is that fair?
Yes.
Okay, I have nothing further. Thank you.
Redirect, Mr. Saunders.
Doctor, I want to pick up on questions towards the end there. You were asked to describe what a manic episode or manic symptoms are. Is that right?
Yes.
With respect to a bipolar 1 diagnosis, one of the requirements is a manic episode, right?
Yes.
And how long do those typically last?
They can last for quite a long time. And then that would be, based on my experience, that they can last as long as months, oftentimes until treatment is administered.
The diagnostic criteria sort of requires there to be a week of manic episodes. Is that fair?
I would need to look at the DSM, but that would make sense.
All right. So you said that you were hesitant to say the instance of chair throwing was a manic episode. Is that what you said?
Yes.
And can you explain why?
There are many reasons for a person to throw a chair. One of them could be due to a manic episode. But before I would make that conclusion, I would want to have compelling evidence that such a diagnosis is appropriate. And that would need to include objective evidence, meaning observation over time when a person is not being, thinking that they're being viewed, things of that nature.
So I guess then would some of that objective evidence be to consider time periods both before and subsequent to the manic episode that you're observing?
Yes.
Why would that be helpful to know?
It would speak to consistency of behavior. There's a lot of information that can be gathered by looking at behavior over time. When is the onset? Does it happen? I mentioned this earlier. Does it happen when people are not being, when they do not know that they're being observed? Things like that. And then there's more, the more objective evidence there is, the more credible that diagnosis can be.
So I guess in general, if you're attempting to determine whether somebody is actively having a legitimate manic episode, you sort of look at the time frame both before and after.
Yes.
You were asked some questions about your interactions with Ms. Shabusiness, about her reporting or endorsing that she was hearing voices. You remember those questions?
Yes.
And you indicated sort of her response to those were sort of vague in terms of what she was experiencing.
Correct.
In your opinion, did that appear to be consistent with genuine psychosis?
No.
Why is that?
To me, my take on them was that they were represented some social anxiety, some rumination, her thinking about her circumstances. They seemed like more of an internal dialogue versus an actual auditory hallucination, which can tend to be more bizarre. You also will see behavioral indication that a person is responding to internal stimuli or the auditory hallucination. So you'll see indication. Maybe the person won't even say that they are experiencing these voices, but they'll be distracted, have a difficult time completing their thoughts. It's a lot more subtle of an expression than simply saying, I'm hearing voices.
And none of the sort of other things you are trained to look for you observed in Ms. Shabusiness?
Correct.
And in addition, you've already testified to concerns about exaggerating of symptoms.
Yes.
You were asked questions about review of certain records, particularly the Bellin Health records. You were aware that there was a prior attempt of self-harm previous in Ms. Shabusiness's history?
Yes, at age 14.
Okay. And records from that age, 10 years or so from prior to the date of the offense that you're attempting to determine here, do you believe anything in those records would substantially change the opinions you're testifying here to today?
As I know it, there's not anything that would speak specifically to the issue of the NGI plea. But as I indicated, I would have been happy to receive those records if they had been made available to me. I felt, though, that for me, one of the main issues was Ms. Shabusiness's use of methamphetamine at the time of these offenses. And I don't think that information generated 10 years prior would change that. So in sum, no, I do not believe those records would change my opinion.
Okay. And then I'll sort of pick up on the methamphetamine you brought up because you were asked some questions about that, about psychotic symptoms that you had observed in Ms. Shabusiness's records in the past. Is that fair?
Yes.
And are you aware of any of those symptoms that were reported absent the context of methamphetamine use?
No, I am not.
And so like concepts like, psychosis or meth-induced psychosis, I think you mentioned, those are as a result of methamphetamine use.
Yes, my review of the record indicates that all of the psychosis observed objectively occurred in the context of methamphetamine use.
And then finally, you were asked some questions about the MMPI. I think there was a question about like lack of education and if that can impact that. Is that you remember that question?
Yes.
All right. Is there any information you're aware of any cognitive deficit for the defendant?
No, my understanding was that she attributed her learning difficulties to ADHD. She did not have an individual education program or IEP that would signify learning deficits, and she has a high school diploma, which indicates she had sufficient reading level to take the MMPI 3.
Thank you, doctor. Nothing further.
Anything on those topics, Mr. Fraley?
Did she say that she had concentration issues?
I don't recall that.
When you talked to her, she was very quiet, correct?
She was soft-spoken.
Didn't give a lot of information, correct?
I disagree with that.
Sounds crazy to me.
Obtained a reasonable history from her.
It wasn't like she gave one-word answers,
No,
but the responses were short. Is that fair?
no.
Nothing further.
Like what I just did.
No.
Like what I just did.
You're right.
Hey, Joe.
Yeah, so what? I think that's it.
I was surprised they called 2 witnesses. I thought they weren't going to call any.
Wasn't
Well,
exactly a strong question to close on, was it?
No.
To be fair, this guy hasn't had a strong case to close on, so.
No,
What's
I'm
Will
with you.
Wheaton doing behind the
No,
defender?
Your Honor, the state rests.
Any rebuttal
State
testimony, Mr. Fraley?
Steve, make
No.
a valid argument for this defendant.
Ladies and gentlemen of the jury, the
In a
evidentiary
minute.
portion of this case is now closed. So to give you a sense of what's next, it's similar to the process.
I don't know what she
we've
had to
already,
lose by taking the
experienced,
stand.
and that is
Nothing.
to instruct you
The only time they ever heard from her was when she's confessing for 6 hours.
Let's hear what they're doing here.
I need a few minutes to work with the attorneys. The instructions are much shorter this time, so I won't need as much time to work with them on it. But I do need a few minutes to finish those up.
Okay, then it'll just be instructions, and then they're off to deliberate for 5 or 10 minutes and come back and send her to prison for life. That's the plan. All right. Well, this judge just looks like he's done. He's just done. Like, meh, I'm out of here. All right, folks. Comments. Oh, first, we just have a few super chats here before we get into the comments, so we don't have to break it up. Hemplin, Texas says, no one is objecting to anything. Everyone just wants to be done. And happy birthday to Flux. Always happy birthday to Flux.
Well, there's really nothing to object to.
Yeah. And Mike Morrison again. Well, this is worth a double read. Thanks for providing us so much entertainment this week, all of us. It's really been appreciated. Wife and I bought our anime Matsuri tickets last night to meet everyone and hang out. Can't wait to see you 2 weeks from now. That'll be awesome. Literally 2 weeks from today. Jeez, that's where I'm leaving. Ozzy's leaving in 5 days.
Oh, thanks for the reminder. Hang on, what is it?
You're welcome.
It is 5 days.
How long of a flight is that?
19 hours.
It's about the same for me, yeah.
A whole day on the plane.
I gain a day going and I lose one coming back. I skip from the 14th to the 16th on the way back.
Yeah. I land an hour before I take off when I go. It's from door to door, from Busan to Utah is about 24 hours. Rusty, thank you so much for the Canada bucks. I think the Google search of Jeffrey Dahmer walking into the court all sexy was the most solid evidence in this case.
No, it was not. That was I'm not kidding. That was the potential turning point for the defense. The defense could have won the case on that. I'm not being facetious. I'm not being sarcastic. I'm saying their best shot at winning was leaning in on that whole thing, leaning into it. Forget about the whole stupid, crazy thing, which was never going to fly. They could have just leaned in that you only know anything about what her mindset is from her confession. And this is the confession of someone who idolizes Jeffrey Dahmer. She's a liar. You don't believe her. Nobody believes her about anything. She didn't take the stand because we knew no one would believe her. I don't believe her half the time when she's talking to me. But so now the only reason we think that this was not some accident by two kinky, bizarre, sexually fetishized chokers that he accidentally drops dead, the only reason you think she did it on purpose is because some woman who thinks that Jeffrey Dahmer is a role model, someone she should hold admiringly over her shoulder and take selfies as if she's laying in bed with him. That person now, after she accidentally kills someone, then goes ahead and pretends that she did it on purpose so she can sound cool like her idol Jeffrey Dahmer. and you're sitting here believing her, even though you don't believe her on anything, because she's such a ridiculous liar. Because she's that weird person. She's different from me, different from you, different from us. So that you want to know why she's lying? It's because she fetishizes Jeffrey Dahmer and wishes she was Jeffrey Dahmer, even though she never killed anyone before, never had the guts to do it. So now when she has an accident, she jumped on that opportunity to step into his shoes. That's how you take it, and you take that Jeffrey Dahmer stuff and flip it on its head. So you say you have no one has any way of knowing that this was on purpose. No one should think it was.
Well, here to tell you you're absolutely out of your mind is potentially criminal Sean.
Joe, you are 100% wrong. You couldn't be more wrong. Oh my God, Joe.
Give it to me. Give it to me. How
no,
am I
I
wrong?
actually agree.
Tell me.
I didn't hear anything you said.
That's okay. Neither did we. That's okay.
Well, no, I just want to tell you, this
I'll
is
just
the
role
kind
play
of
as Mrs.
value
Logic
rant,
today.
that you get out of Joe on Good Logic at Good Logic streams. You know, this is what we all pay for when we go over to his stream. You know.
Well, and that's an important thing to do.
No one pays when they come to my stream.
Everyone, Aussie Overlord, Good Logic Joe, MLS Lajo David, Steve Gosney, Chandler Remington, potentially criminal Sean. Everybody needs to go over. We had 1,100 people here watching. Every one of you needs to go over, and I just saved knocking a bottle of whiskey off my desk with my cat-like reflexes. Everybody needs to go over to every one of these people's, because I talk with my hands. Go over to their chat, go over to their channels, do everything, subscribe to them, like their videos, and like me and subscribe to me too. We've picked up 300 subscribers since we started. That is awesome. 300 subscribers today. That's pretty damn awesome, and I appreciate all of that support.
Well, I do agree with the legal mindset conclusion that the law racks. You have owned this trial. You've had the best guests. And you've really done great.
Well, I've got Joe.
Other than Joe, can I just say that?
I have Joe, so therefore I have the best. That's what I meant, Steve.
Oh, okay, all right. No. I want to really defend the public defender's office here. Okay, and here's what I have to say. I don't know if anybody else who's ranting on this stuff is a public defender. Okay, and what you guys, all you private defense lawyers, don't comprehend is that we are given the cases that we cannot withdraw from. We are given cases that have no defenses. You know, there are cases which you are sitting there and your job is to object when something's objectionable, but you're there to sit and lose. And those cases occur. And this is one of those cases. That defense attorney has nothing to work with. Now, I'm not giving him the complete A+. Okay, I'm not saying that. I'm just saying that sometimes the role of that defense lawyer is to sit there and make sure the trial goes smoothly with admissible evidence. And you take the loss. You know, you don't get to choose your client. You don't get to choose your facts. You don't get to choose your experts, your expert testimony, other than what people may think. They may think, I'll just wave money out there and they'll say what I want. No, the woman there, she's going to say what they want.
Oh, sorry. We're back. Sorry.
Okay. I'll just give.
It's just jury instructions.
Yeah.
Keep pronouncing her name differently. I've heard it pronounced both ways. Is it engine, like an engine, or is it Engen? I thought I heard her say Engen.
It's the latter.
Engen, I think.
That's how I'm going to pronounce it.
Did you just say, I got nothing?
To 605, there are some options that we need to address.
Oh god, that's his catchphrase for the trial.
Are we in the jury instruction part? Because I literally just got done working.
Yeah.
I have some thoughts about which ones seem appropriate given the evidence, but let's just run through them. The first option is, because it indicates that in that particular portion, add the following if supported by the evidence. First, temporary passion or frenzy prompted by revenge, hatred, jealousy, envy. That just doesn't seem to apply. I don't think it should be inserted. Agree with that, Mr. Saunders?
Yes.
Mr. Freilich?
Yes, I do.
That'll be out. The next one, an abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. Mr. Saunders?
I think that should be included. Particularly there was testimony about the criminal conduct, but antisocial, I think that kind of fits into a lot of the jail conduct reports, other behavioral things that the defense has raised.
Mr. Freilich?
I disagree. I didn't hear any doctor or professional say anything about antisocial conduct. So I would object to that.
I'm going to give that instruction for this reason. There was a lot of testimony about conduct that the average person could characterize as antisocial. And I think that's an important piece of information for them to have.
See, that is exactly the way a judge should rule. This is a great judge. He overrules, and then he gives the reason why he is
voluntarily induced state of
That's
intoxication
great.
by drugs or alcohol or both does not constitute a mental disease or defect. I note that the parties stipulated at the last phase that that should come in. I'm assuming that's where we're at now. But Mr. Saunders, you're asking for that?
Yes.
Mr. Freilich?
I'll agree.
Okay. The next one is a temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Mr. Saunders, you're asking for that?
Yes.
Any objection, Mr. Freilich?
Yes, I would argue that it's duplicitous. It's, it's doubling up. The paragraph before is, I think, says enough. It's mentioning it twice, basically.
So as you said before, it's duplicitous. Is that what you're saying?
Well, I think the difference is,
or is it diabolically opposed to the other
voluntarily induced
stuff?
state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. The other one is a temporary mental state. The other one referenced temporary mental state versus voluntary intoxication. Temporary mental state, which is brought into existence by the voluntary taking. And I think that's consistent with some of the testimony that has been offered here. So I understand the argument, Mr. Freilich. I'm going to include that option. I think it's appropriate in light of the evidence that's come into this case.
Your Honor?
Yes.
One more argument, and I respect the court's ruling, but just to make sure I'm doing my part, is that just saying it a different way? I would make that argument too.
Well, a voluntarily induced state of intoxication by drugs or alcohol does not constitute a mental disease or defect.
Yes, we're joking because he misspeaks a lot. Instead of diametrically, he says diabolically. Instead of duplicitous, he says duplicitous. Poor guy.
Mr. Saunders, any response to that?
Yes, I think they're pretty clearly different. A voluntary induced state of intoxication refers to using methamphetamine, using alcohol, using some other illicit substance. A temporary mental state brought into existence, I think, refers to the circumstances that Dr. Engen testified to about meth-induced psychosis or symptoms that are brought about by use of substances, because that speaks to the mental state. Induced is basically the same thing as which is brought into existence. So I think they're different.
Okay, I think the difference, Mr. Freilich, in response to your objection is for someone to be in a voluntary induced state of intoxication, the jury couldn't find that that's a mental disease or defect. The next option is if a mental state exists, if there's a potentially a diagnosable mental state that exists on a temporary basis. So not just the intoxication, the mental state, which was brought into existence by the use of drugs, that does not constitute a mental disease or defect. I think they're different. So I note your objections and your amendment to your objections, but I'm going to give both of those because I think they're different.
Thank you, Your Honor.
The next then is chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. Mr. Saunders?
I don't think this one should be given. We didn't hear testimony about the latter part of that there is some permanent, and we talked about this with Dr. O'Donnell, that there is some permanent condition that the defendant has. So I don't think it's an appropriate instruction to include.
Mr. Freilich?
I strongly disagree with the state on this. I think this language should come in. The court should consider it. I asked, I believe, Dr. Engen and Dr. Seipel, and I believe Dr. Leighton, that, using drugs over time can cause brain damage. And so I'd ask that you allow that as part of the jury instruction, Your Honor.
Anything else?
Well, yes, it can, but there's been no evidence that if the condition has become permanent, that is something the defendant's afflicted by. So I don't think it's proper to instruct the jury on something that can be out there if there's no evidence that this actually is in existence. I think it invites speculation. I think it kind of is confusing to some extent as well. If counsel wanted to have an expert to testify about a permanent condition the defendant has, they could have done that.
Your Honor?
Yes.
It's crystal clear to me that this should absolutely come in. This young lady, Taylor Denise SCHABUSINESS, was under a court order for involuntary medication and an order for civil commitment, which it doesn't happen very often.
Years ago.
She was found by a court of law, by Judge Lee Joyce, to be mentally ill. And she was at the Nicolay Psychiatric Center for approximately a few weeks, where she was receiving injectable Abilify antipsychotic. She was getting treatment. And it was clear, the records replete with the fact that she had a chronic problem with meth, methamphetamine, marijuana. So I think it's totally on point, and that should be something that the court should consider. The operative word, in my humble opinion, is can. That word can. I think that makes it such that it would be applicable in this particular case.
I think the focus is if the condition has become permanent, and whether that's supported by the evidence. There's no doubt that chronic use of drugs or alcohol has come into this case.
Let the instruction in, Judge. Let it in. That's a fact question for the jury. That's an appellate issue. Let it in, baby.
Satisfied in light of the state of the record that it ultimately comes down to what the jurors heard. There has been a great deal of testimony regarding the use of drugs or alcohol. There were some questions placed to the defense expert about impacts on a person long-term using various drugs. I'm satisfied the jury can assess that. I'm going to give that instruction. Certainly the parties can argue that they don't believe the evidence supports that particular aspect, but I'm going to give that piece. So I'm going to include that. And then
notice how that
action
defense
that has to
attorney
be
fought on the battle that he
I'm going
needed
make
to
these
fight on.
revisions then, and then I will give you a final copy of them, and then we will move. We'll bring the jury back in, and we'll move to instructions and closings. All right, we are in recess.
Thank you.
That was a good one. See, I have more respect for this defense attorney than if he's getting credit for. I recognize he's not exciting. We're just I'm rolling in here.
Yeah, I don't know why people. I don't think he's doing a bad job. The only thing I didn't like that he did do was during the when the PhD psychiatrist came in and let us know she had a PhD 55 times. He didn't have her explain what the mental illness that she was diagnosed with, what Taylor diagnosed with, what does that actually do? And like, what could that cause? And what would be a result of that? Instead, it's just like, oh yeah, she's got bipolar and, you know, she's manic. And that was kind of it. And I thought that was an issue that it didn't allow the jury to hear why what she did makes sense. It seems like they were kind of left hanging for that.
Well, let me say what I think, and Steve will tell me why I'm wrong. I think he did a good job of ticking off the ineffective assistance of counsel boxes, going through the motions, asking questions on cross-examination. I think most of his cross-examination was like twice or three times as long as it needed to be. He was unfocused. I think he's a terrible questioner.
Yeah, the questions could have been far better framed. That was the one thing that rankled me, is that
I think he was okay up until closing arguments, and I think he just got his keister handed to him during closing arguments for the first, and he's just kind of given up at this point. I think he's like, the passion's not there, the questions are getting worse, and he's doing more to help the prosecution's case. I think I just think he's given up. I don't know.
Well, number one, I don't think he ever really had passion, and I don't know if that's really what is the theory by which she's not guilty, or it's insanity, right? So he's got to focus on that. I agree. There's a lot of meandering. There was a lot of there were questions he was asking he didn't know the answers to. He was unfocused. So I think there is some value to that. But the problem is when you have nothing, what do? Do you not say anything? Do you not question anybody? Or do you kind of do what he's doing, which is put up the appearance of asking questions, right? Now, whether there's, I don't think that there's really a clear logical pathway to not guilty or by insanity.
I think you need to, if you have nothing, you have to pound the table and make it seem like you have something, because we're thinking about it from the lawyer's point of view. We have to think about how the jury is hearing. The jury is hearing the defense for someone who's trying to fight for their life. Just going, yeah, okay, so.
Yeah, but I don't know. First of all, I don't think this judge would put up with a lot of dramas. I think that this courtroom has been trained by this judge to give him what he wants, which is this kind of sedate, mail it in kind of thing. I think he's doing the public defender thing, which you've got somebody. I see that he doesn't have a big co-counsel table, so he drew the short straw. He's probably the old experienced attorney who is objecting and making sure the state's on their best behavior. He knows what's in the documents. He knows what the evidence is. He's objecting specifically. He's fighting for the jury instructions he wants. I recognize he's not Mr. Enthusiastic, but there's not a logical pathway. There's no magical pathway to not guilty.
No, there's not. But at the same time, Steve, when you don't have anything, you still expect. So as bad as it sounds, for me, I'm looking at this guy knowing he's got nothing. Okay, I fully understand that. But as a result of that, I'm still expecting him to get the basics done, to do them properly. Right. I'm not expecting him to be giving away free throws in the questioning of that PhD, which I feel like he did when he at least didn't. He could have handled her a lot better, is what I'm saying. So because he didn't have anything to go on, I feel like he should have been far better on the defensive rather than going offensive.
Well, and I think there's two ways of asking the question. You can say, did you look at the report? Or you say, did you even look at the report? There's two ways you can ask that question, and one of them, no to one of them goes, yeah, okay, and the other one makes her sound worse. I just think he could have delivered.
His personal style, like over time, I have seen him get, more and more monotone, and he does not seem like he is even pretending to advocate for his client. He does not seem, when I have never been in the position of having to defend somebody in court, obviously, but the idea is, you at least act as though you give a shit. You act as though this is a person who, you want them to have the positive results of, having the best possible charges or having the least, time. Yeah. He's not even pretending at this point. He's really phoning it in. He really does not seem like he cares.
What do you think, Steve? You're his defender.
I wanted to hear from MLS because he had something to say there.
Okay.
No, I was just going to say that, any case, whatever it is essentially a stack of dominoes, right? If you can knock one out, you can do substantial damage. And if you just pick those one or two little things to focus on that you potentially do have an avenue of attack and focus entirely on that, but you don't just spray it everywhere, laser focused and be, and advocate in that one direction, that would have been better than what he brought.
Well, and
like intent, and I'm just for example, intent. Like there was enough there. I think he could have argued intent strongly. Would it have worked? No, but at least it would have been an argument, right?
Right. No, and I got you, and I'm with you on that. And I'm just trying to give the public defender a little bit of credit because you don't know what all's behind the scenes here. And I will say that, he's really defending the indefensible. I don't see a strategy that's be effective. He operates much differently than I would in trial. What
would you do differently?
Yeah.
Well, I'm very theatrical. I get very dramatic. I get very focused. And one of the neat things about being in appeals, I will tell you, because I do appeals, but I'm really a trial attorney, is that I get to pick the cases I get to go on to, right? So I get to pick the ones where there's a good strategy, where my strategy, my way of doing things, the true to myself strategy works. So when I see a case in our trial division that I can actually help on, then I can parachute in and do that case and not handle the docket. But this is not one of those cases, right? This is not one that I'd be volunteering for because there's no coherent strategy. So then what do? Well, you should be true to yourself. I mean, we have a trial attorney who's directly opposite to me, and she's true to herself, and she provides what I call the chaos theory, and she throws everything up in the air and lets it, and lets the jury create doubt. But I just don't see a coherent strategy for victory here. So I don't know. I'm just trying to tell you that. So what do you do in that situation? He's making sure the state's checked. He's fighting for his jury instructions that he thinks he's got, which he's all right. I understand the enthusiasm, but there's also she's probably a very difficult client, if I would expect.
Mm-hmm.
So you don't know how much dislike and hatred he's got towards her.
Well, I mean, don't misunderstand.
Yeah.
I mean, I'm not saying he's incompetent. I'm not saying he's not doing his job. I mean, he's not presenting it well to the jury. I'm not writing. I'm just disappointed with him. It's just there could be so much better, and he's not doing it.
Let's take it. I want to put.
Okay. All right. Okay.
What evidence that came out in this trial should he be hammering on and making a big deal out of that provides a pathway to some sort of escape for his client?
I don't think there is an escape, but the points I would make, I guess the two main points I would make is she said right there in her testimony, in her interrogation by the police, she said, I didn't mean to do this. I didn't want this to happen. It was a mistake. Tell the sister I'm sorry. She said, amongst everything she said, she didn't mean for this to happen. I would harp on that every possible way I could. And also the only thing that ties her to this is the van. The van was there. It's not her van. No eyewitness saw her commit this. Her van, it wasn't her van. Her roommate's van was parked out there. No one knows where it was.
My prosecutor hackles I'm sorry. My
prosecutor? I was just saying, like, if she said, I'm sorry, I didn't mean to do it, like that's a bigger statement than any other piece of evidence.
No, she said, I didn't want this to happen.
Yeah.
That's what she said. I didn't want this to happen. She didn't intend to kill him.
That would have been outlined and circled on every one of my notepads because I wouldn't have forgotten that. I would have said it verbatim over and over.
Except
and he didn't. Yeah.
The rebuttal from the state would just completely crush you.
Yeah.
So the fact
I didn't intend to kill him. Did you intend to cut off his head? Did you intend to fuck his corpse?
Right.
That's all. Okay, send me to jail for mutilation of a corpse for 6 years.
That's
right?
a state of mind thing. Like, I get you guys want him to be out there screaming and flipping tables and throwing grenades, but this also might be that guy's style. Some attorneys are kind of like the, Droopy the dog, but like they are able to work with things and they're able to work methodically. They're able to get it done. I mean, yes, I've dealt with absolute lunatics of people. Like, people have had to go to the nut hut for a while. There are multiple things you have to do. This guy's probably walking through a minefield every time he starts talking. Because he's like, if I say something, Jesus Christ, she's going to lose her shit. And if she does that, she's really screwed.
Well, it's not just that. It's also the fact that you're fighting a battle that you're laying. Okay, so here's the battle. And this plays to the way I like to try a case. I like to find the battle, lay the groundwork, and then attack on that one point and just pound it. But all those grounds that you are pushing on, as far as he needs to follow this pathway, the state would just crush you on that because there's so much evidence contrary to it. They'd say the defense's issue, they want to bring up this. Well, let's talk about this and this and this and this. So it just doesn't work. That's what I'm saying. He has nothing to work with. So what do you do when you got a case with nothing to work with?
I would say concede. Okay. Yes, she cut up the corpse. Yes, she panicked. She accidentally killed the guy. She told you in her own words that she didn't mean to do this. She didn't want this result to occur, but it did. She panicked. That's when she lost her mind and she cut it up. She tried to hide it, send her to jail for 18 years for the mutilation of a corpse and whatever else she did to it. But she did not mean to kill him.
But
so that's your Hail Mary.
I understand that, but that's where if I'm the prosecutor, look at her sitting there every day. Does she look like somebody I really didn't mean to do it? Does that look like somebody who didn't mean to do it when she's got the
then you can that's a better Hail Mary than doing nothing.
But you can
well,
harp on the face thing with the expert because her expert specifically mentioned her weird little smiles when she's confronted with stuff. You can explain that away a little bit. And we're not
she's
saying
nervous,
this is
she's
going to win.
uncomfortable, she's, you know, she expresses that inappropriately.
I understand that, but the point is, you're dealing. And I say this, like I said this with the dumpster defenders. Your jury is normies. They're literally normal people. You are not going to bullshit these people like that. They're going to sit there and like, there's, you know, like, okay, great. I didn't mean to do it. Okay. You know,
but is it better to try that Hail Mary than to try really nothing at all?
Okay, here, I'm the prosecutor. You say that she didn't intend to kill him. I bring out that confession and everything that she says when she says, you know, that she says the guy was spitting up blood and his tongue, and she says she decided to go all the way, and that she braces something. You ever wanted to kill something that you love? And all those statements in that confession that she made that contradict that narrative. She can say that the defendant, in her own words, contradicts what the defense is trying to sell you.
But is it better to try that Hail Mary than nothing at all?
Because
why is it better to try nothing at all?
Because they're going for the insanity defense. You got to maintain credibility, and if you lose your credibility with the jury, they're not going to listen to you on the insanity defense.
Can we talk about the insanity defense for a second?
Well, I just kind of want to let me preface this way, Jeff. Let's say Hayden's on camera walking into a 7-Eleven with a 12-gauge shotgun, and he forgot to put his mask down, which is something I had a client do once. Except in this case, you know, Hayden does it, and hey, you know, it's clearly him, and it's 4K video, and like the police put on Facebook, and 500 people say that's Hayden. Everybody says it's Hayden. Hayden's prince, like it's clearly him. Am I going to be like, hey guys, you know, it could be somebody else. Hayden says he didn't do it, therefore, hey, I mean, he couldn't. He might not have done. No, the jury's not going to like you can't if you go up there and literally treat them like you guys are a bunch of fucking morons. I dare you to believe this story. Yeah, you completely destroyed everything you might try to do going forward, because are you going to listen to somebody who tries to do that to you? He tries to bullshit you. He says, "Oh, the next day, listen, she really is crazy. Believe me now," because of like. You've got nothing at that point, because nobody's going to listen to you. No one's going to believe you. And the better thing for her is to get the NGRI. I mean, he doesn't want her going away for life. The NGRI, she stands a chance of getting out at some point.
Well, and the conditions of a mental hospital are much better than the conditions of a prison.
Depends on your mental hospital.
Yeah, well, that's true.
Yeah. Sorry, and I wasn't trying to yell at anybody. I'm just... Sorry,
no, I'm with Sean. I'm with Sean. You're right, Sean, and I agree with that. And you got to maintain your credibility. If you've got a shot at NGI, which, and that one expert that the defense had, the only thing I have to say is that she did conclude that it was mental illness. So now he can argue it, right? So he has facts in evidence that he can argue. Believe the older lady witness who's kind of doesn't like computers, She did give him the conclusion that allows him to make that argument to the jury.
So what I was going to say about the insanity defense in this particular expert, and it's not so much, showmanship on the defense side. He's got to be able to tell a story, all right? Steve, you write books. You have to establish the setting. And he failed to establish the setting. He talks about, well, she, what did you review? I reviewed all these documents. I saw that she was in the hospital. At one point, she was diagnosed with bipolar 1 and mania and all this stuff. But he never said, okay, what does that look like? Paint us a picture so we know what is happening. That never happened. All we heard is that some abstract idea of this name and that she has it. And that was about it. He wasn't really explaining, to the witness, and I agree with what that looks like.
I'm not disagreeing with the presentation could have been better and more focused. I'm not disagreeing with that. I'm just saying that some of these alternative theories that people are pushing are not what we're dealing with in this case. So, but you make a good point. I mean, I'm definitely with you. I'm grading off on this defense attorney for some of his presentation skills. It's not what I advocate. Like what I think it was Chandler, which I love kind of listening to what people think about this stuff, because I've heard this kind of expert testimony so much that I'm like interested in what they're saying, and I'm not so much reflecting on the stylistic points of it. But what Chandler was saying was that he doesn't seem like he believes in her client, And that's one thing that I think I've always had is when I go into court, I believe my client. And that's what Sean was talking about credibility. I also can't lie to the jury. And if he's saying that, it's really kind of a lie. And I wouldn't believe it if I was saying it. Whereas if I'm saying she's crazy as nutcase freight, I believe that all the way. So I could sell that to a jury with a passion. So I do believe what you're saying, that the jury senses whether or not you're committed to your client. And I think maybe this defense attorney is failing in that regards too.
Yeah, I wanted to say a little more about that, if I may, just for a moment. I just feel like, if I were on the jury and I was watching that, I would ask myself, considering the horrific things that she's done, and considering like the way that he is just he seems to be sort of phoning it in, at least in his intonation, which I think intonation makes a really big difference when you are delivering, your questions, your cross-examination, like his style is just, I would be asking myself, if I was a member of that jury, is he just so horrified by the things that she's done that he has, because lawyers are only human, he's been, he's doing a job, but like, I'm trying to imagine what it would be like to represent somebody who did things like that, and I just can't, it must be very difficult to sit next to a person who decapitated somebody.
Well, if you can't do that, you gotta give up. You gotta turn it over to someone else.
I'm sure, but it's an extreme case. It's a horrific case, and I'm not sure, if he has represented people like this or not. But there might be a difficulty there for him personally.
I'm sure he's represented like child molesters, had kiddie porn cases, which those are. I'd rather deal with a pile of severed heads all day long. Those are far.
I agree with Sean.
But I guess Chandler, the other thing is too.
Oh, the judge is coming back here.
You are.
Okay. You see
spirited debate. I love it. We're a great group of people.
Now a copy of the instructions that I
not one of us hates the others. That's awesome.
The jury, and again, I will give
I get it.
I'll start with
Taylor's
modified
she actually can
100.
read. It's like, what is this stuff?
Somebody in chat, Hey Joe, says he was tried to be removed and was denied. Is that true?
No.
No, the guy who got attacked got removed.
Yeah. I just want to know why Will Wheaton is sitting behind Taylor Shabusiness.
See, I think those are cops that are there to wrangle her.
That first guy too.
He does have the posture, doesn't he?
There's been a different guy behind her every day. And I think
she has a history, so
I'll get to that in a minute.
Yeah, but they got
give
stunned.
315.
I think she's got stunned.
I'll give 640, the mental disease or defect expert.
Yeah, but he's got the button, the stun button.
605, instruction on the issue of the defendant's criminal responsibility.
I just want to hear the judge go, "Shut up, Wesley."
And
he's got to do something now. The Big
I'll
Bang
give
Theory's up here.
160 closing arguments of counsel. Then you can do closing arguments, and then the closing instruction 460 after you've completed your closing arguments. I've added the verdict form, and the verdict form actually needs to have the heading on it. And
So
I'll
to
make sure
speak.
that gets corrected before it goes into the jury. But
Only
I did
the victim
fix the
had his
request
heading
you
on
had,
him.
Mr. Freilich. So the question one is, at the
Instruction
time
sheet
the
was
crime was
beheaded.
committed, did the defendant have a mental disease or
What's in the
mental
header of this
defect?
document? Nothing.
And I did that for question two as well.
Been
And
removed.
the instructions, when I indicate you're going to be getting this verdict form, I made that correction there as well.
Thank you.
I got to squeeze in some of these super chats here in lulls. Colonel Coffee 98 says, "Why does she always have the WTF face on?"
Because she's all
Because she's
lunatic.
Taylor Shabusiness.
Yeah. So did I hear this right? She changed her name. That's not like her real name.
Yeah, no, she was Taylor Denise Coronado until 2007. So her and her husband changed their name.
And she thought Shabusiness was a cool name.
Yeah,
Apparently.
How old was she when she changed it?
It's better than calling herself
2017,
Max
so-
Power.
like 18, 19. Yeah. Aaron says the judge looks like Beaker from the Muppets.
I can see that.
Pretty harsh, but yeah. Wolfram, $5 super chat. Wouldn't that be interesting if she ends up in the same cell as Letitia Stasha's Maria, the Russian trained Mexican assassin? Talk about a cage match.
No, that case is in Colorado, but it would be funny.
I don't think it is missing. I was thinking 602 needed to be inserted in 100, but That's true, but in the first phase of the trial. And so I think that's where.
Is he saying they forgot to include something in the first set of jury instructions?
I think I
That
was
doesn't sound
thinking
good.
of 602 and 602.
Sounds like a
doesn't need to be
retrial.
Inserted in 100 at this phase.
I hope so.
We'll see you all back here in
You
another
guys
year.
are saying you guys are wrong. He looks like Kyle MacLachlan.
Okay.
That's what I was thinking. I was like Quentin Tarantino or Kyle
He's like
MacLachlan.
the mayor of Portlandia.
Love child of the two, in my opinion. Also, a little bit of a Will Forte from SNL.
Will Forte, there you go.
Just on the verdict form,
Right.
question 1, I think it should read at the time the crimes were committed, plural, instead of the singular.
Right. Because we're dealing with 3, so that can be corrected. And then when I give 605 question.
This judge is allergic to microphones.
He had no problem yelling at defense counsel for it, though.
Any objection to that, Mr. Fairley?
No, that makes sense. Crimes were, that's what we're talking about.
Anything else, Mr. Saunders?
Oh, there's one more instance. In the top of 605, the defendant's mental condition at the time of the offenses.
Sure. Makes sense as well. Mr. Fairley, any disagreement with that?
Your Honor, are we talking 605, the number 1?
605, the very first sentence says, you have just heard testimony about the defendant's mental condition at the time of the offense, and they're suggesting it should say offenses.
I agree.
Anything else, Mr. Saunders?
I guess it's also on the next page, the first question heading.
What's on that same page, number 1? At the time the crimes were committed.
Dex Luther here says, if she loses, then we have to put her on the first boat to Australia.
Nope. I'm doing my best to keep Amber Heard out. She's not coming in either.
He's trying.
Let her go kill all the alligators or the crocodiles.
Actually, to be fair, we could let her loose on the emu population.
Colonel Coffee 98 says, do you think she wanted to testify but was advised not to? I don't know. I hope not.
I doubt it.
Those are fixed.
Ann Serkin, reckless homicide, kinky corner gone wrong.
I don't think it appears any other place.
I take no responsibility for any beheadings.
Anything else, Mr. Saunders?
No.
All right. Mr. Freilich, anything concerns about the
Good God, I might have to put that as a disclaimer from now on.
Yeah.
Your Honor, I see what Mr. Saunders was talking about on that second page, where it's in writing. The first question is, and then it should say at the time the crimes were committed.
We've caught that already.
Okay, but on the first page, what I was talking about, we corrected that first paragraph with an S for offenses.
Yes.
But then if we look down, it says 2 questions, and then it's got question 1 and question 2. Was that changed to at the time the crimes were committed?
Yes.
Okay, I just wanted to make sure. Thank you.
And just so everyone knows, I'm not intending to go back and get that corrected now. I will make sure my judicial assistant corrects that as I'm listening to closings, and so that this is delivered to the jury.
Emu says you can keep her.
Thank you.
In addition, as I've indicated,
Can we super
Fuck,
chat?
chat moves fast.
Can we super chat the judge to say to ask him if he'll give a shout out to Flux on her birthday?
comes from, it'll have the heading in this case. If there's nothing else, then I'm going to use the same time limits as we had yesterday. But
30 minutes each.
So
Yeah.
yesterday I gave the state a half hour.
That's a lot for
and 10 minutes
what
for
little
rebuttal.
evidence was
That's what
presented.
you'll get, Mr. Freilich.
They only go 10 or 15 minutes
I was
anyway.
gonna say, yeah.
Which I think is appropriate. Well, maybe not that short, but
Everyone each time they haven't used. but
30
I
minutes max.
this time. Anything else before we bring the jury in, Mr. Saunders?
No.
Mr. Freilich?
No, thank you, Judge.
All right. While we're waiting for the jury to come in, let me quickly clear off the 3 super chats here. Well, not to be dismissive of them. I mean, get them before the jury comes in, and then we'll bring in our final guest of the day, who's been catching up at the very end of every day. Kitchen Knife Rescue. Thank you so much for the super chat. Says, as a sharpener, should businesses' abuse of innocent kitchen knives is criminal? One of the main reasons for deep nicks, chips, and gouges is because someone accidentally hit a bone.
That's what I was saying. She needed to have a knife sharpener with her. It's very dangerous. You have to
I gotta get through the super chats. Chandler, I gotta get through these super chats. Hang on, everybody. Keep your comments. Tourette's Majestic went in thinking NGI, exiting with guilty as hell. And finally, we have Sonia Chris. The defense PhD was clearly giving the story she was paid to tell. From a 15-year paramedic, zero medical credibility. All right, that takes us to now. You were saying, Chandler?
Sharpen your knives. It's dangerous. Be careful.
Sharp knives cut better. Yes, dull knives are dangerous.
Yeah.
Yep.
That's all.
Pants or
It's
prison.
your duty to follow all of these instructions.
And bras.
Regardless of any opinion you may have about what the law is or ought to.
And Nick is here.
Hey,
Nick.
Hey, Nick.
Hey,
folks.
Viking in the house.
All right, here's the instructions.
So can you give me a quick these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has any impression of my opinion as to the issues in this phase of the trial, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the judges, are the sole judges of the facts, and the court is the judge of the law only. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify but must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. In resolving conflicts in opinion testimony, weigh the different opinions against each other. Also consider the qualifications and credibility of the witnesses and the facts supporting their opinions. The court has appointed Dr. Christina Engen to examine the defendant and to testify at trial. You should weigh the testimony of Dr. Christina Engen as you would weigh any other opinion testimony. You have just heard testimony about the defendant's mental condition at the time of the offenses. You will now be asked to determine whether the defendant is not responsible by reason of mental disease or defect. This issue will be presented to you in the form of 2 questions. First, at the time the crimes were committed, did the defendant have a mental disease or mental defect? Second, as a result of the mental disease or mental defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? You will be asked to answer the second question only if you answer the first question yes. Before you may answer a question yes, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence that the answer to that question should be yes. Evidence has a greater weight when it has more convincing power than the evidence opposed to it. Credible evidence is evidence which, in the light of reason and common sense, is worthy of belief. The first question is, at the time the crimes were committed, did the defendant have a mental disease or mental defect? Mental disease or defect is an abnormal condition of the mind which substantially affects mental or emotional processes. The term mental disease or defect identifies a legal standard that may not exactly match the medical terms used by mental health professionals. You are not bound by medical labels, definitions, or conclusions as to what is or is not a mental disease or defect to which the witnesses may have referred. You should not find that a person is suffering from a mental disease or defect merely because the person committed a criminal act, or because the unnaturalness or enormity of the act, or because a motive for the act may be lacking. An abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. A voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. A temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. If you answer the first question yes, you must go on to answer the second question. If you answer the first question no, you should not consider the second question. The second question is, as a result of the mental disease or mental defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? If you answer both of these questions yes, the defendant will be found to be not responsible for the offense and will be committed to the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to herself or to others if released under conditions ordered by the court. In deciding whether the defendant is responsible for the criminal conduct, you are to consider only the issue of the defendant's mental condition at the time the offenses were committed. Agreement by 10 or more jurors is sufficient to become the verdict of the jury. Jurors have a duty to consult with one another and to deliberate for the purposes of reaching agreement. At least the same 10 jurors should agree in all the answers made. I ask you to be unanimous if you can. At the bottom of the verdict, you will find a place provided where dissenting jurors, if any, will sign their names and state the answer or answers with which they do not agree. Either the blank lines or the space below them may be used for that purpose. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. Now, ladies and gentlemen, the attorneys will make their closing arguments. And
that was short.
As indicated, because the different burden of proof in this case, Mr. Freilich will start.
I think I'm going to try to drive home, and I'll probably be back for the verdict. I'm not sure. I'm way late. Okay.
Okay, Steve.
All right. Get home safely.
Bye, Steve.
Happy birthday, Flux.
I think they'll have the deliberations tomorrow. It's already 4:30. Who knows?
Your Honor, may it please the court.
They kept them late
Ladies and
yesterday.
gentlemen of the jury.
Yeah.
Mr. Saunders, Mr. Lissay. I want to thank you again for your attention. I know that you've been thinking and analyzing and listening very attentively to the testimony from these experts in phase 2 of this trial. Now, the question is whether or not Taylor D. SCHABUSINESS is legally responsible for the crimes that she's been convicted of. And in this case, Taylor SCHABUSINESS has elected not to testify. That's her right. You are not to use that against her in any way, shape, or form. This case is a battle of the experts. We have Dr. Seipel, we have Dr. Engine, and we have Dr. Lighton. The case started off by my client's father, Arturo Coronado, who came in and he testified that his daughter had some problems, some mental health problems growing up as an adolescent, that he got her some treatment, some counseling, some professional help, that he helped her at Nicolay Psychiatric Center, and that my client lived with him for a period of time. So he provided the framework and the background for some of the issues that this young lady has. And we heard about the fact that her mother died in the home, and she was there. And that was I would submit that was a pivotal event in her life because she loved her mother. Then we moved on to Dr. Diane Lighton, PhD, a doctor, forensic psychologist. And she provided testimony as to her extensive background, her training and experience. And she provided testimony that she worked at UW-Madison as a scientist, that she completed over 3,000 hours of post-doctoral training at Mendota Mental Health Institution, a well-known institution that treats people with mental health problems, and that she became a licensed psychologist in 1993. She worked there doing competency evaluations, NGI evaluations, many other evaluations. And then in 1997, she went and became an independent forensic psychologist, where she conducted hundreds of forensic evaluations, including competency, NGI, not guilty by reason of insanity or not guilty by reason of mental disease or defect. We call it NGI. Evidence-based sentencings and guardianship. And so she testified about her background and her resume. Lawyers call it a curriculum vitae, her CV, bores out all of the experience that she has working in this field, technical field. And she went on to testify about the fact that she met with Taylor SCHABUSINESS in February of 2023 at the Brown County Jail. And Mrs. SCHABUSINESS was nonverbal, non-responsive, apparently threw a chair. She tried another approach where Dr. Lighton met with her behind glass and didn't really get any response. Then we heard about the fact that she did meet with Ms. SCHABUSINESS in June of this year, and she was able to conduct her interview and glean and garner information with regards to her mental status and this report that she was tasked with. And I submit that Dr. Lighton testified that she didn't have to do an MMPI, a Minnesota Multiphasic Personality Inventory. She was able to gather enough information from reviewing all of the other materials and information that she had. Interviews, consults with the prior attorney, with me, reviewing all of the other doctors' reports, Dr. Lucetta, Dr. Seipel, Dr. Collins, and other doctors that have been involved in this case. She reviewed police reports, looked at interviews, looked at the criminal complaint, looked at Brown County Jail records, looked at Nicolay Psychiatric Center records when my client was inpatient there, looked at her school records, looked at the Bellin Health records, looked at a lot of information. Basically, what we have here is Dr. Lighton, who's very experienced. She did the NGI evaluation. You heard from Dr. Seipel, Matthew Seipel, that he did a competency evaluation. He did not do the NGI evaluation. Dr. Christina Engine, she's the one that did the NGI evaluation. Now, as it relates to Dr. Lighton, she is of the opinion, to a reasonable degree of psychological certainty, she testified that Ms. SCHABUSINESS, Taylor SCHABUSINESS, qualifies for the NGI plea based on her diagnosis of a serious mental disorder. she opines, she concludes that the serious mental disorder affected Taylor Schabusis's ability to know right from wrong at the time of the alleged offense, dating back to February of 2022, and affected her ability to control her behaviors. And she finds and opines that Taylor has been diagnosed with bipolar disorder for at least several years. And that was confirmed in the records from Bellin Health. She also says and opines that Ms. Schabusis continues to have prominent psychotic symptoms and has not used substances for at least 1 year. There was some talk about the feigning, the faking, the malingering. Feigning means faking. About that topic. And Dr. Lighton indicated that it was her opinion that my client was psychotic at the time of the alleged offense, and it wasn't simply due to drug use. It's clear that Taylor Schabusis had a problem with methamphetamine, with drugs, marijuana, other drugs maybe. Dr. Lighton says that Ms. Schabusis had a very strange presentation, had facial expressions that can appear inconsistent with the context. If you're talking to her about something, she might smile or grin, and it may not be the appropriate time for that. But she opines that her assessment finds that Taylor Schabusis has a genuine mental disorder of a psychotic nature, which is most likely bipolar 1 disorder. Now, in this case, you heard that Dr. Engine, with respect to her, she didn't know that my client was under a civil commitment order for Brown County by Judge Lee Joyce. Taylor Schabusis was found by the court to be the subject of a civil commitment, and that's why she went to Nicolay Psychiatric Center. My client was also the subject of an order for involuntary medication. She had to take medications ordered by the court. No ifs, ands, or buts. Why? Because she was deemed to be having a mental illness. So that's something, ladies and gentlemen, that you should really strongly, seriously take into account, that in April of 2021, for a 6-month period, she was under a civil commitment order because she was mentally ill. When you look at, the report from Dr. Seipel, or you heard about his testimony, I would argue that, his focus is on competency, and competency and NGI are two legal theories, two legal issues that have to be determined separately. But his focus is on competency, and that I would argue that his testimony is not relevant, not germane to the issues that you are tasked with, and that is to determine if my client is NGI, if she meets that criteria. Dr. Seipel, although he's a PhD, his training and experience is much less than Dr. Lighton's. But his focus was competency, and that's not why we're here. Dr. Engen, she testified, and she met with my client on October 12th, 2022, and then again on October 21st, 2022. It appeared that on October 12th of 2022, there was some security issues, so she wasn't necessarily able to meet with my client. But she did meet with my client on October 21st of 2022 and had a 3-hour interview with my client. That's 9 months ago. It's a long time ago. I would argue and submit to you that her report is stale. She didn't receive the Bellin records. She didn't look at those records. Someone else could have given her the records. Maybe Dr. Seipel, he's on the same letterhead. And Dr. Seipel knew that he was doing his evaluation. There was a disconnect. There was no communication between the two doctors, which is something you should consider. There was no connectivity there. Also, with due respect, Dr. Engine, didn't trek from Milwaukee to the Brown County Jail to meet with Ms. SCHABUSINESS to do further assessments or supplements. Didn't do anything to supplement the report. So that's something you should take into account as well.
Your own witness only watched 1.5 hours of a 5-hour video.
He needs to pound in harder that the state's expert did not review all the records with actual emotion.
There's an instruction, I believe the judge already gave it to you, but it indicates chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. Something to take into account here. We believe that Dr. Layton was very clear that Taylor SCHABUSINESS has bipolar 1 disorder, that she has psychiatric symptoms, she has mental health problems. And she made that clear.
Just take it as problems.
The fact that Taylor SCHABUSINESS heard the train, heard the whistle, that Miss SCHABUSINESS lacked volitional control, lacked the ability to control herself, that she is a psychotic person off the scale. That she has a very unusual
scale is a
presentation.
bad thing, sir. It's a bad thing if you're off that particular scale.
And she testified that Taylor SCHABUSINESS, when she interacted with Dr. Litton, that Taylor tried really hard to answer her questions. But Miss SCHABUSINESS was distracted by internal stimuli, the clock, the cord, voices telling her to hang herself, the train with the whistle that got louder and louder. Talked about 007 and James Bond when she was asked about her mood. Dr. Litton talked about hypersexuality, and that was a concern for Dr. Litton. And about OCD, obsessive compulsive disorder, where Ms. SCHABUSINESS was washing her hands 30 to 40 times or touching her hair, things that were a cause for concern. Wisconsin law, we all have to follow the law, and Wisconsin law is such that the defense and a defendant must satisfy you jurors to a reasonable certainty by the greater weight of the credible evidence that at the time the crime was committed, that Ms. SCHABUSINESS had a mental disease or mental defect, and that as a result, she lacked the substantial capacity to either appreciate the wrongfulness of the conduct or conform her conduct to the requirements of the law. And you're going to be given some jury verdicts, basically questions. Not many, just 2, I believe. One is, at the time the crime was committed, did the defendant have a mental disease or mental defect? I would submit that the answer would be yes. That's my argument. That's my request, that you consider that, and that it was bipolar 1 disorder based on the testimony from Dr. Litton. Then number 2, you'll have to consider, as a result of the mental disease or mental defect, did Taylor Schabusiness lack the substantial capacity either to appreciate the wrongfulness of her conduct or conform her conduct to the requirements of the law? And you'll have to consider that as well. I would submit that that would be a yes. And I know you know this, but I want to make sure the only issue at this hearing, at this phase 2, the second phase of the trial, is Taylor Schabusiness's mental condition at the time of the offense. So take that into account. It's a difficult case. It's a very complex case. Deals with law, deals with psychology, deals with mental health. A lot of things going on. But I would ask that you take all of this into account when rendering your decision. Thank you very much.
That was energetic, wasn't it?
Saunders, okay, go ahead.
Muted, Jeff. Muted.
I think it was the dope. I think it was the dope.
Yeah, we'll talk about it later.
I blame it on being on drugs and the come down. I barely do drugs, then months go by, then I do drugs. Admitting on multiple occasions, both to evaluators and to law enforcement, about consuming a significant amount of methamphetamine for these offenses, admitting that she and Chad were toking methamphetamine beforehand. She even talks about how she was still tweaking on meth during the dismemberment process. Ultimately, that's what this case comes down to, right? Because as we heard from, I think, every doctor, it's difficult to parse out psychotic symptoms versus drug use. So when we're talking about whether somebody has a mental disease or defect and they're voluntarily ingesting methamphetamine, it's really hard to say that that's due to some other underlying mental health issue, right? And that kind of makes sense in our common sense. But ultimately, that's what this case comes down to. It's the defendant's own words that this was fueled by meth. And now it's, well, no, it's bipolar. It's something else, some diagnosis from way before this offense. And that's not the standard you are to apply. Okay, so first, 2 questions you'll have. Was Ms. Schabusiness suffering from a mental disease or defect at the time of the offense? Not in 2012, not in 2014, not in April of 2021, not in June of 2023 when she's meeting with Dr. Litton, or in July with the other doctor, Dr. Seipel. The relevant question is at the time of the offense. Okay? And I disagree with counsel. And you all sat through Dr. Litton's testimony. I don't think it's clear at all that she's diagnosing the defendant with bipolar 1. She said most likely, seemingly based on the prior diagnosis. There's never a firm diagnosis, and we heard Dr. Seipel comment on that as well. You also heard about what bipolar entails, right? What's required? What are some diagnostic criteria, right? We heard about these manic episodes that last a week or thereabout, or even longer, where there's this heightened and manic state followed by a depressive state. You've heard none of that. What part of the interview the defendant gave to law enforcement on February 23rd indicates that she's still going through some manic episode? What part of all of the witnesses and evidence you've heard about the time in the night of February 21st indicates that she's going through some manic episode? You've heard none of that. So this idea that this manic episode arose and dissipated in a flash just happened.
This guy has
to be around the 5
personality,
minutes
damn it.
where she's actually strangling him, and then the day that she dismembers Shad. It's utter farce. There's no basis for that. Instead, we're relying on a bipolar
I like him,
1
he wins.
diagnosis from April of 2021. It's a year before the offense. And you heard from Dr. Seipel and Dr. Engen, both of whom are court appointed. State didn't hire them to come. They're the court's appointed experts. Both of them have issues with that initial diagnosis. You heard why, about the concurrent methamphetamine use around the time of the Nicolay admission. And that's the same story we're seeing now, right? It's the same thing. Methamphetamine use, exhibiting psychosis, and that's unfortunately what led to Shad's death in this case. It's the same thing. So this concept of a civil commitment and the judge ordered voluntary medication, it's not relevant. It's not consistent with the other evidence you saw in this case. What did you see that led you to think the defendant was going through a manic episode, to have bipolar 1 at the time of the offense? That's what's relevant. You're told what a mental disease or defect is. It's something that substantially affects the mental process. That's something else you heard nothing about, right? People can have bipolar 1 and not have their mental state substantially affected. You heard nothing from Dr. Litton to tie that diagnosis, even if we'll give the benefit of the doubt and say she did diagnose bipolar 1, despite the testimony. You heard nothing to tie that into it being a mental disease or a defect. You're instructed that, as we talked about in opening, it's not just because somebody does something really abhorrent and really awful, unnatural. That's not a mental disease or defect. That would be a perverse incentive to sort of reward people to do more deranged things, right? That's not enough. It's not a voluntarily induced intoxicated state. That's what we have here. Mental disease or defect is not a mental state brought about by the ingestion of a controlled substance. So when we heard about meth-induced psychosis, right? Again, that's something that's being brought about by a controlled substance. Those aren't mental diseases or defects. You're responsible in this state for anything you do because you choose to ingest methamphetamine. That's the law. You heard nothing in this case about there being some permanent condition. None of the doctors diagnosed the defendant from suffering from any brain disease because of methamphetamine use or some other substance. Not even her doctors will say that. So when the defense argues that chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect, if the condition has become permanent, nobody is testifying to that in this case. That's not any evidence that you heard. You heard and saw the defendant in the time almost immediately before and immediately after this offense, right? We heard from Dr. Seipel about that, and I think the defense fundamentally misunderstands why the state called Dr. Seipel. Obviously, he didn't do an NGI evaluation. We asked him about that. The relevance is because he highlights flaws in Dr. Litton's report, in her opinion, and that's the sole opinion the defendant's relying on to meet her burden.
Ooh, that's not good.
We heard about why, when you're considering, a bipolar diagnosis, particularly in the NGI context, it's really important to look as close as you can to the proximity of the offense, right? And that makes sense, right? It helps validate this is actually some manic episode or something that would be throwing a chair randomly at a person, right? But there's a difference between those two things. And we heard none of that. We heard none of that from Dr. Litton, did we? We heard a lot about mental diseases and illnesses that she thinks happened way before, way after. And yeah, she reviewed a lot of material, but Dr. Litton tied none of it into February 22nd of 2022, did she? No testimony about, well, okay, so if somebody has bipolar 1, how is that manifesting? How is that utterly inhibiting the defendant from her awareness of what's going on, or her ability to conform conduct, right? We heard none of that. We heard a statement at the end that, well, I think she's NGI. I would support the plea. You heard no analysis, right? No analysis of, well, I considered the defendant's actions the night of the incident, and this raised this concern for me. That would support my opinion. We heard none of that, right? And it's their burden to do so. You heard none of that from Dr. Litton. She's, yes, qualified, experienced. We heard about that. But there are real issues with her methodology in this case. Based largely, her opinion is, on her interactions with Ms. SCHABUSINESS on June 19th of 2023. And we heard ample reason why that should be a red flag. People who actually administered personality tests to kind of determine feigning and over-exaggerating of symptoms, including experts hired by the defense, have raised that concern for the defendant that she over-reports symptoms, that she exaggerates symptoms. And Dr. Seipel is exactly right. And you heard the testimony from Dr. Litton. Most of her opinions based on her interactions with the defendant and this bizarre behavior that she's observing. Incidentally, bizarre behavior you haven't observed for 1 second during this trial. For the last 4 days, there's no throwing chairs, there's no outbursts, there's no staring or off.
See, she should have done it.
So this idea that Dr. Litton's opinion based on her interactions with the defendant and some old bipolar diagnosis, there's nothing tying it together. There's nothing showing you that would allow you to agree with her opinion
over time
that the defendant had a mental disease or defect on the date of the offense, which is the relevant question you have to answer. You have reported behaviors by Dr. Litton that aren't in any other reports that are observed by doctors. Dr. Seipel meets with her really close proximity, isn't reporting any of these behaviors. And again, one of the questions you have is capacity, right? Substantial capacity to do things. And there's a big difference between capacity and desire to do so, with volition, with choice, right? The capacity to go skydiving. I don't have the volition to go skydiving. I have the volition to dunk a basketball. I probably don't have the capacity to dunk a basketball. Right? Those are different concepts. And the information you heard about in the records from the testimony is that it's something that the defendant can control to some extent, right? There's no outbursts or any of the behavior Dr. Litton's talking about that Dr. Seipel observes, that the court-appointed expert, Dr. Engen, observes. None of that, right? To the contrary, you have Dr. Engen doing scientific tests to determine about the validity of some of the observations and determining the opposite, right? And sure, Dr. Litton was under no requirement to do that sort of testing. But when she says she just looked at the prior results and relied on those, well, what she should have been relying on is that the information the defendant's telling her isn't accurate. That's the only prior analysis that we heard about. So again, there's real methodological issues with Dr. Litton's report. Most importantly, none of it ties together with the date of the offense. Her testimony for the better part of this morning, maybe 2 or 3 questions dealt with the date of the offense, tying it together. Dr. Litton, how are you able to tell this jury that Ms. SCHABUSINESS was unable to conform her conduct, was not aware of what's going on? You heard none of that. She didn't even review the entire video, the recorded interview that you observed, to see firsthand, really close proximity to the date of this offense, what the defendant's behaviors were. She reviewed a transcript. I think she said she may have reviewed 90 minutes of it or something like that. didn't review the second interview, which incidentally, as you observed, and you heard from Detective Graff, the same behavior, same mannerisms, same lack of outbursts or anything like that throughout this time. Again, this manic episode that is allegedly occurring. You observed that over several days and didn't observe any of that. So that's the concern with Dr. Litton's testimony, and that's the relevance of Dr. Seipel's testimonies. He points out some of these issues. As he interacted with the defendant as well. Didn't observe any of that on multiple occasions as a court-appointed expert. Again, not hired by the state to come in and say that, report that. So you have the report from Dr. Engen, the court's expert, and you heard the testimony. And if you review the report, it jives with common sense, right? There's no mental disease or defect that she talks about. The mental illnesses, which there seem to be, are all substance abuse related. And again, the law of this state says that's not enough. That's not a mental disease or defect. So sure, there's, I think, amphetamine disorders and methamphetamine intoxication. She says, yeah, I would support these illnesses. Those aren't mental diseases or defect. She considered a bipolar 1 disorder and rejected it for the reasons we talked about. Given the concurrent use of methamphetamine, it seems like the doctors that the court appointed agree that you're using meth. You're not psychotic. Any psychotic symptoms you're exhibiting are because you took meth, not because you have some diagnosis or have a mental disease or defect. So when you're asked the first question, when you see the verdict form, that question should be answered no. You've heard insufficient evidence that the defendant suffered from a mental disease or defect on February 22nd, 2022. Okay. If you answer that question yes, and only if you answer that question yes, you get to the second question. Second question asks sort of a compound question. As a result of that mental disease or defect, did the defendant lack substantial capacity, again, capacity, to understand the seriousness of her conduct or to conform her conduct to the requirements of law, right? So understanding and conformity are kind of the two things there. So let's talk about that. You obviously heard from Dr. Engen about that, about how she does not support that. She does not believe that she lacked substantial capacity to have either of those two things, right? And her reasoning makes sense. And really, it's kind of reasoning you probably would have gotten to without her testifying in some respects. It helps that this expert that the court appointed comes in and tells you that too. But it jives with common sense, right? Because you heard all this evidence for Monday, Tuesday, Wednesday, and today about the defendant's conduct on February 22nd, 21st, and into the 23rd. She's aware of the wrongfulness of her conduct, and she's telling you as much, right? She tells law enforcement, I took these Clorox wipes and I was wiping up, right? Specifically, even accurately remembering it's Clorox wipes, where she put them in the bags. Detective Scanlon on February 28th asks her, hey, we saw some wiping pattern on the floor. I mean, what was going on with that? And she was like, yeah, I was cleaning up. And they're like, well, did you move the bed over it? She said, yes. And why did she say it? Why did she say she did that? She was covering it up, right? And that's why we ask those questions about the blood that we saw on the floor under the mattress isn't seeping through the mattress. It's coming because the defendant moved the bed over it because she's trying to cover up her crime. And now they want you to believe that she's not aware of the wrongfulness of her conduct. She's telling law enforcement, how am I going to get away with this? That was her motivation for dismembering his body for a lengthy period of time after the fact. Hearing footsteps upstairs, worrying mom was going to find him. She's telling you she's aware of the wrongfulness of her conduct, and she's exhibiting action and volition to clean up. Everything you're objectively seeing evidence-wise in this case shows you that she knows exactly what's going on. She even remembers details about this night. And now we hear this professed amnesia in her comments to Dr. Engen about this offense. And you saw the interview. She had every detail down to the T. She could have drawn that entire basement for you from memory. Everything was located. She's telling you where the meth is located, where the dildo is located, what color the dildo was. She's aware of what's going on, even with the meth use. You have her memory of the incident. You're hearing about how she's describing, you could probably infer from the nature of the offense how blood was going everywhere in the course of the conduct, yet you heard about the condition of that basement, right? It was pretty spotless, pretty clean, especially considering what happened down there. Because she cleaned up, because she was aware of the wrongfulness of what she did. She didn't just massacre somebody, dismember him, and leave a war zone down in that basement. No, she cleaned up because she knew what was going on. Then you get to the second part, right? If she's able to conform her conduct to the requirements of law. And again, you heard nothing from Dr. Litton to kind of help you with that, right? Like, okay, if I'll accept she has this bipolar diagnosis, well, tell me, Dr. Litton, how is she unable, because of that diagnosis, to conform her conduct on February 22nd? And you heard none of that. To the contrary, as Dr. Engen points out, you have a lot of information to tell you she's able to conform her conduct pretty well, right? She's employed. We heard about court cases that she was dealing with. We heard about paternity things she was arranging in the time leading up to the offense. We heard about after the fact, we saw the contact with law enforcement, right? She's ordered to take her hands out of her pockets for officers. She does that. Order to put her hands behind her back. She does that. Complying with orders, complying with commands, complying with questions. She's conforming her conduct pretty well, right? She's following the law enforcement's commands. In her interview with law enforcement for a lengthy period of time, she's conforming her conduct. She's not exhibiting any manic symptoms. She's not exhibiting any psychosis in that you heard about. There's just nothing in this case to show that she's not able to conform her conduct. To the contrary, you heard a lot of evidence that not only did she not lack that ability to conform her conduct, that what she did to Shad was volitional, was a choice. She liked it. She was aroused by it, right? She told law enforcement that. She wanted to do this. She did. Because that was a volitional choice. It's not because she lacked substantial capacity to not do so. It's because she wanted to do so, and she did. You heard about her saying, well, yeah, I knew I was killing him, but quote, I did it anyway, right? Because that's what she wanted to do. And again, a mental disease or defect is not because you may not have a clear understanding of a motive. I would say you should, but that's not a mental disease or defect. Just because what she ultimately did is in some respects quite disturbing, it's not a mental disease or defect. You have insufficient evidence to support that. And again, it's not the state's burden to disprove an NGI plea. I think we have, but it's the defendant's burden to convince you of the NGI plea, and they've utterly failed in that respect.
Go to a tailor and get a jacket that fits, kid.
We heard about the burden of proof, that it's a reasonable certainty by the greater weight of the credible evidence. And you should be, even though it's not a burden, I would say you should be reasonably certain the defendant's not suffering from a mental disease or defect. Again, it's their burden to convince you that you should be reasonably certain by the greater weight of the credible evidence that she does. It's their burden. If they wanted the court's expert to review documents from 10 years prior, they could have done so. They could have provided those materials. If they wanted, hey, please interview my client again, they could have done so. It's their burden. And they chose not to. There was additional jail records. They could have produced those. And actually, Dr. Engen's comments about that make sense. You know, her findings and all the objective evidence you have is this is a meth-induced crime, that whether she had a civil commitment a year prior, had, I think, a mood disorder 10 years prior as a 14-year-old, that's not relevant. It wouldn't change anything. I don't understand these arguments about the reports being stale. As Dr. Engen told you, it's a retrospective review, right? We don't really care. You're not asked to decide, does she have mental disease or defect today? That's not important. The proximity to today isn't relevant. It's the proximity to the offense. You should actually be entirely convinced Dr. Engen's report is the more relevant report. It's closer in time to the actual mental state the defendant had on February 22nd. It's obviously a complex case in some respects, right? It's a serious offense that the defendant was convicted of. It's obviously it's an important case, right? And the defendant has had experiences in her personal life that nobody should have. Losing a parent at a young age, it's something many of us deal with, and it's awful to hear about. It really is. But that doesn't change the law. That doesn't change the standard in this state, because there's simply no evidence to support she had a mental disease or defect on February 22nd, 2022. Not only did she not have a mental disease or defect on that day, you have no evidence to say that that mental disease or defect rendered her substantially incapable of conforming her conduct or appreciating the wrongfulness of her conduct. You simply don't have that evidence here. You have ample evidence to the contrary.
She was one of the first witnesses.
The defendant is telling you that meth made her do this. She's repeatedly told that to law enforcement. Every objective piece of evidence you have in this case supports that finding. And it's simply the case that that is not enough in this state. That's not a mental disease or defect. So don't let her now try to come in and say this was some other thing. Now the meth really didn't have anything to do with it. It's important to note, a meth-induced psychotic state is also not a mental disease or defect, as you'll read in the instruction. There's no mental disease or defect. There's no lack of awareness. There's no inability to conform your conduct. You have ample evidence to the contrary. And that leads to one inevitable result, is that she's responsible for what she did to Shad on February 22nd.
Oh my God, it's just 30 minutes up.
Questions no, or answer the first question no, and don't get to the second question. Thank you.
Oh, okay. Whew.
Yes, I do, Your Honor. Thank you.
Just because you have 30 minutes doesn't mean you need to use 30 minutes. It was great, but it was repetitive and overly long.
Your Honor, again, may it please the
15
court,
minutes in, you could
ladies
stop.
and gentlemen, Mr. Saunders, Mr. Lissay. You know, this case illustrates that this young lady, Taylor SCHABUSINESS, has a lifetime of mental health issues. She has bipolar 1 disorder. That is a mental disease or mental defect. You know, who is the state fooling? We have a young lady that was under a civil commitment order and a medication order by the Brown County Circuit Court in 2021. So she already had a mental health disorder, a mental defect, I submit a mental disease that predated the incident that has brought us here to court on February 22nd of 2022. It's clear in this record that Ms. SCHABUSINESS was at the Nicolay Psychiatric Center for 3 weeks or so, maybe a month in 2021. You got to see in phase 1 of this trial, Green Bay police officer Garth Russell, who parked his squad down quite a ways, and he walked in the dark of night across the snowy parking lot up to the Eastman Avenue apartment at 2353 Eastman Avenue. And Ms. SCHABUSINESS met, or Officer Russell met her at the door, out on the porch. And you could see on the video her face. You could see her eyes. You could see her demeanor. She didn't look right. I submit to you, she didn't look right. Something was going on.
Yeah, marijuana, meth, and trazodone.
Did this happen when she was in a manic state or a psychotic state? I submit that, you know, once you have a mental health issue, mental health diagnosis, a mental health issue like bipolar 1 disorder, it's not going away. It follows you for the rest of your life. What we have here is someone who has a very serious mental health issue, mental health disorder. And you pile drugs on top of that, it can constitute a mental disease or defect if the condition has become permanent. I would submit that Taylor has had mental health issues dating back to her early years. She went to Purveya, she went to Bellin, she went to Nicolay, she was under a court order where she had to have injectable antipsychotic medications. She apparently was psychotic when she was at the Nicolay Psychiatric Center. I would submit that it wasn't necessarily from drugs. She's got this underlying issue here. She has ongoing mental health issues. She's only 25 years old, and they've been going on since her youth. I would argue that the mental health issues that she has caused this whole situation, and that'll be something you have to think about. Is she able to appreciate, or was she able to appreciate the wrongfulness of her conduct on February 22nd of 2022? Was she able to conform her conduct to the requirements of the law at that particular time? And you saw the video. We all saw it. It was very bizarre, very unusual, very odd, her demeanor. You know, in this case, there are a lot of doctors, but Dr. Engine, you know, she never knew about the civil commitment order. Come on. You didn't know about a court order? And she's a PhD and she deserves respect, but something happened here where it fell through the cracks that she didn't know about this civil commitment order or this medication order. And then we have Dr. Seipel, you know, he got the Bellin records, got them from me. And, you know, he does a report for this case, and I find it incredible. It's incredible that he doesn't send, with due respect to him, he doesn't send the Bellin records over to Dr. Engine, knowing that she's going to come in here and testify in a court of law in front of you jurors. I find that unbelievable. I don't make the law. But the law, you know the law because the judge read it to you. You have to consider whether she's responsible because of a mental disease or defect. So you've got to think about all of that. The defense didn't fail. There is a plethora of evidence to show her mental health history. Was her bipolar 1 condition permanent? I submit to you that it was.
Of evidence.
Did it cause a crazed situation for her on the date of this fatal incident? You heard Detective Groff, who's a very seasoned detective with the Green Bay Police Department. You heard him go through very methodically questions. He was patient. He asked Taylor Shabazz lots of questions about what was going on. And he testified that the police detectives and the officers, it was an ongoing investigation and they didn't have all the facts. They didn't know all the things that were going on. It was evolving. Detective Scanlon was over on Stony Brook and Detective Groff was at the police department. She told Detective Groff, I didn't intend to do this. Me and Shad were buddies. Words to that effect. So I submit that she did not want to do this. At the time, was she in a state of psychosis? Who knows? That's for you jurors to decide. But we've presented the lawyers, Mr. Saunders, Mr. Lassay, and I have given you the information, the evidence for you to wrangle with and think about and analyze and assess. I would ask that you consider the fact that Ms. Shabazz was taking the antipsychotic meds, the injectable meds, when she was at Nicolay Psychiatric. And then once she was released, didn't take it anymore. We all know if you don't take your medications, you're going to have problems, especially if it's a mental health condition. If you don't take your high blood pressure medication, what's going to happen? Your blood pressure is going to go up to the sky and you could have a heart attack or stroke. Same thing rings true for other medications. And in this particular case, Ms. Shabazz did not take these medications. So I would submit, her mental health problems, her bipolar 1, got worse and worse and worse and worse to the point where it went off the cliff. I would submit that based on everything that's been presented, I'd ask that you consider returning a verdict that she is not responsible for these crimes by reason of mental disease or mental defect as applied with the jury instruction. Thank you very much.
That was
Now,
nothing.
Jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law, which should govern you in your deliberations. The time has now come when the great burden of reaching a fair, just, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. Do not be swayed by sympathy, passion, or prejudice. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. As with the case in the prior phase, you will be getting a copy of these instructions with you during your deliberations. With that, I'd ask the bailiffs to step forward to be sworn.
They're going to send them straight into deliberation?
Oh my God. I got to go to work. Don't do this to me. Just send them home for the night. Bring them back fresh tomorrow.
You will, to the utmost of your ability, keep all jurors sworn on this trial in some private and convenient place, subject to the direction of the court, until they have agreed upon their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon. So help you God.
All rise for the jury.
They're going to a verdict, or they'll go back, they'll deliberate, they'll do a verdict, they'll come out, they'll announce it all within the next hour, I say.
Yeah.
His rebuttal, it was better than his closing, at least, but that's from a very low
Anything to bring
standard.
up before we recess, Mr. Saunders?
Oh, good. Wow.
Mr. Fraley?
No, Your Honor.
Right. Now I'd ask, as with the situation the other day, I'd ask if everyone remain around for 30 minutes until 6 o'clock or so. After that point, if you want to leave, if you could just leave a cell phone number where we could reach you. And with that, we are in recess. Thank you.
Jeff needs to go to work so he can sleep.
Wow. Let's see here. All right, we can mute that and remove it. Let me remove the cuck cage here. Overlay. Overlay. There we go. I have a few super chats here to get through before we just throw open the doors to mayhem and madness. I'm to the point now where like, my reflexes have really slowed down and I have to really think about what I'm clicking before I click things. All right. Tank Rat with the 100 Durs. Thank you so much. Bets on the time to deliberate in phase 2. 42 minutes like the guilty verdict or longer. God, I hope it's shorter. I really do. The instructions were shorter, so it's not going to take them as long to read through them. Anybody say longer than 42 minutes?
No.
No. Shorter.
Good. Good. Because I gotta go to work.
Sure.
Oh, don't be so contrary. Megals with the 10 Australian dollars. Jeff, question. If jurors are released at the end of the day to deliberate after both sides closing, who can I follow on Twitter for an update? We're sticking with it. We're sticking with it until they go home for the day. So just stay here. Don't go anywhere. Appreciate advice and great trial coverage. Well, thank you. For better or worse, we're sticking with it. Hey, Ron, can we draw and quarter her yet? Yeah, sure. Why not? I don't care. Matthew Self, Taylor Shabusiness and Chandler Halderson Demon Child, produced through satanic pegging, would be the best leader of the free world. A Nephilim, if you will. Wow, that was
well,
harsh.
he's currently running Florida, so
I both love and hate that I share a name with that guy.
Samwise is doing great on close, but his voice is so annoying. Pick an octave and stay there, my guy. I had the same complaint. It's a little too inflection-y. Pitchy, as Simon Cowell would say. He was pitchy. And Buddhaberry is Judge Meme's dad has seen some shit this week and is ready to go home. Yeah. Just kind of look like Meme's dad, I guess.
We're all ready to go to sleep.
Right.
Just move on from this.
And finally, Unhung Hero. Bipolar doesn't check out. If they were arguing schizophrenia, then maybe I'd take them seriously, but rarely does bipolar disorder cause a psychotic break. And Calco coming in under the wire here. Can you read her husband's statement? Yeah, we can read the husband's statement here. We've got some time to kill, but first let's talk to the panel. And by the way, let me bring up everybody's names. Boom, there we go. Please, guys, do me a big favor. Go to each and every one of these people and subscribe to their channels. They're absolutely just hanging here to keep me company, to provide some insight. They're absolute just diehards. I love them deeply and appreciate them for being here, and you should all give them a good subscribe. Aussie Overlord, Chandler Remington, and Remy_legal, MLS Law Show, Michigan Law Show, Potentially Criminal, under Potentially Criminal, Nick Staroff's Trial Watch, under Nick Staroff Trial Watch, maybe.
also on Rumble.
And our like and subscribe poll. We have 1,000 people here and 890 likes. Stick with us for the jury here. So far, we've had 1,365 people vote in the poll. 78% said not insane and going to prison. 22% said insane and going to the nut house. All right, that's where we stand. Is it 78% say she's going to jail? What do you guys think?
I think
start
she's
with
going
you,
to jail.
Ozzy. Okay, we'll start with you, MLS Law Show.
No, I
now
just
we'll go to
shot it out
Ozzy.
there. I think she's going to jail. I don't think the I mean, they don't have much of a case. They could have presented a better, perhaps a better, more dynamic presentation of the defense's insanity case, but it is what it is. I think she's going to jail.
Ozzy.
Who is muted? Still
When did
muted.
that happen? She's definitely going to jail. And look, I was ragging on the defense counsel pretty bad, and I just need to say very specifically that he's doing a job that nobody would have wanted. And while I do think he could have done it better, he does still serve a very vital part of our justice system, both here in Australia and in America, because we're all based on the same system, which is great, makes my life a lot easier. He still fulfilled a function, even if I do think he could have done it better. Because having someone there is still better than having no one. But, yeah, she going to jail.
Handler?
I agree. I don't think that defense counsel had a very compelling argument. There was a point where he said something about her having bipolar disorder and how that, stays with you for the rest of your life. And, I've known a lot of people with bipolar disorder. There are a lot of people with bipolar disorder who live in Los Angeles, weirdly, which I learned from my psychiatrist. And the thing is that if you take medication for that, if it's diagnosed properly by a psychiatrist, you can live a normal life. I don't believe or buy that that was what caused her to kill this guy. I think she just wanted to do it for fun. I think she was obsessed with Jeffrey Dahmer. Maybe she wanted to keep the head and do something with it afterwards. Who knows? But she didn't get that far. She got lazy. So, yeah, she's going to jail. I don't think that the jury's going to be compelled by the defense's argument. It wasn't very passionate. It wasn't very convincing.
Yeah, well, at least he
Sean fall asleep.
Yeah. At least the defense counsel showed some emotions during the rebuttal, but yeah, she's going to jail. But that's more because of the judicial system. Me coming from our civil system, the judges in our courts, they do decide the penalties, but it is by advice after months long of people being submitted into mental health care to determine what do they have, did they have it, not by a jury, because juries are laymen in this. So
potentially sorry, I thought you were done. Continue.
No, I'm done. Mostly because I'm sleepy.
Potentially criminal Sean, what do you think? What say you? You're muted, by the way.
I'm not sure Sean is hearing us necessarily.
Yeah, like I said, I think he fell asleep.
He might be otherwise occupied.
All right. Well, come back, Sean Manier. MLS Law Show. You've already given shit. Me, I think she's I think she was sane. She may have had whatever it was, bipolar, whatever it is she may have had. I think she made the conscious choice to commit murder.
I have a question though, and I don't know if it's been answered. How many jurors need to find her insane?
10 out of 12.
10 out of 12. So there's a couple.
Where have you seen that? I was not aware of 10 out of 12.
I just know the judge said it didn't have to be unanimous.
Yeah, but 10 out of 12, I believe the judge said.
Okay. Yeah, I was just wondering because he said it didn't have to be unanimous. He said, I would ask that you all come to an understanding or an agreement, be on the same page, but you don't have to. And the whole chat's lighting up with 10 out of 12. So
yeah, I missed the 10 out of 12 thing. I just heard that it doesn't have to be unanimous.
Yeah, so I was just wondering. Okay, so they can have a couple of holdouts on the not insane thing, but I don't think they're going to get there. But what if they're at 5 out of 5? Then she's guilty without the insanity. Is that what it is?
Well, one way or the other, we'll find out. Whatever scenario they come back with, we'll
I'm
find
just
out
curious.
how it works out.
I believe if it's less than 10, if it's less than 10, then she's just going to jail. Right?
Yeah,
it's bifurcated. The burden is on the defense. They don't have to be unanimous. Like, all of this is weird to me. I'm not a big fan of any of this.
See, I'm thinking if it's less than 10 out of 12, she goes to jail.
Yeah.
Yeah.
Simple enough.
Because it is the defense's burden to prove.
And then I believe the sentencing would be carried out by the judge. Then they would do the scoring or whatever at another date.
Well, I don't think there is a scoring. I think it's just you go to jail for the rest of your life, or you go. Oh, wait a minute. We have someone else popping in. It's Danny on direct. I was going to say what she texted me, but we'll let her say it. Hi, Danny.
Hi, Danny.
Hey, so I'm here at work and I'm listening to you guys, so I apologize if my audio is crap. I put a hard stop on my timer, so in case my clients are listening in, please be aware I am not billing you for this time. I, though, have been watching the sentencing portion of this all day, and since the beginning, my initial inclination was this woman definitely has probably in the past been diagnosed with a bipolar disorder. My guess is that bipolar disorder was exacerbated by all of the drugs that she was taking, and it may have developed some schizophrenic or schizoaffective type disorder on top of that, just based on her mannerisms, the way she's presenting, some of the things that other people are saying about her, and her proclivity to the types of drugs that she's been taking, her own testimony, all of that kind of fits in line. Now, people can disagree with me all they want. I'm just an armchair psychologist. However, I think that the presentation of that and her diagnosis and the way that it affected her at the time leads me to believe that she's going to go to jail today. Because I just don't think that the defense understands all of the nuances of those various disorders and that they are also on a spectrum. You can have bipolar disorder and treat it effectively and never have any type of issue. It doesn't need to escalate. Lots of people are misdiagnosed with bipolar disorder when they actually have schizophrenia or BPD or another diagnosis that would have better fit. But it's really hard to do a post-diagnosis when she's on trial for, murdering and then chopping up her boyfriend. So I don't think that I guess what I'm trying to say is even if she is crazy, it is so difficult to prove at this point in time, post hoc, that there's no way that you could even credibly raise the defense, if that makes sense. So those are my thoughts. No one has to agree with me. I've just been around a lot of people who have both bipolar disorder and schizoaffective and full-on schizophrenia. And I can just say, being around them, this is all stuff that I've seen before in terms of mannerisms, certain testimony, the way that she describes her life, and dad is a creep. That's all I wanted to say. Love you guys.
Okay. Well, but don't run away, Danny. The deal here is, it's not what she has today. It's not how she's presenting today. It's not how she was presenting 2 years ago or 10 years ago or 12 years ago. It's what her state of mind was at the moment she committed the murders.
Yeah,
and there was no evidence.
Right. Without a prior diagnosis, that's what I'm saying. Without a prior diagnosis, I'm not sure how a psychologist or other mental health professional would be able to speculate as to whether or not schizoaffective disorder had an impact on her behavior at the time, in addition to all the drugs she was taking.
And all we had was the arrest video where she seemed to be very, very lucid. The police interrogation where she seemed to be very, very lucid and cooperative and articulate. I don't think it looked good for her. Plus, hiding the body sort of seems to indicate that she knew what she was doing was wrong. Chopping it up and trying to hide the bits and pieces. But, that's my
So
thought.
is the legal standard there that she needs to just know that what she was doing was wrong?
Did she have the mental capacity to appreciate what she was doing wrong at the time? And I guess that's it. What is it? It's knowing that what she did was wrong at the time, I guess, is basically it.
Interesting. So, well, then, yeah, she's screwed either way. Like I said, she's going to jail. I think that there could have been a better argument. I just feel like it's going to be so hard to prove regardless. Let's say she does hide the body, and let's say she hid the body because she, believed that that was what she should do because the voices were telling her. Anyway, she didn't testify to any of that. And it doesn't sound like they did. I mean, did she admit that she hid the body because she knew it was wrong?
Well, when she was telling the police that she wanted to take it all to her house, and then she says, "Oh damn, I forgot the head," things like that, and she, that's kind of where that.
I got
that
the
is.
notion that she was hiding it from the parents. Hide it so she could go get back and get it. Not that she was hiding it from the law.
Right. So she could have hid it from the parents because she just wanted to keep the body to herself.
But it wasn't obvious that way. So
yeah, and that's kind of a stretch again. That's
no, it is.
I think
that's
that's
my
a bit
point.
of a stretch.
That's my point. Is without that really thorough analysis at the time that she was full on in that manic state of mind, right? In that manic mind frame, and you can experience mania and be lucid. Now, you can generally tell when someone is in a state of mania because they're saying things that just don't make sense, even though they are putting together a stream of consciousness. So it's a really tough diagnosis to A, diagnose, and B, it's even harder to prove that she was in a state of mania and in that state of mind at the time. And if she didn't admit to knowing that what she was doing was wrong, I guess my question is why did no one ask her what her intentions were? Why did she hide the body? Why did she do this and that? Did the psychologist testify to that at all?
No.
Well, the police during the interrogation asked her, "Did you know what you were doing was wrong?" And she said yes.
Okay, then there you go. She goes to jail. That's it. I mean, if that's the element to prove, that's the element to prove. It doesn't matter if she has schizoaffective or not.
And that was what the argument from the defense was. She was drugged out of her mind to the point where her confession should be thrown out.
Well, that's not
the jury didn't buy that. Yeah.
So anyway, those are my thoughts. Thank you for rebutting them, and thanks for letting me say my piece. Love you guys. Bye.
Thanks, Danny. Talk to you soon. And we picked up one more super chat there. Jeff, you are the GOAT. Thank you for your commitment to this trial. Special KL. Well, we better get moving here because it's getting 8 a.m. my time.
Yeah. And if you want to know more about Jeffrey Dahmer, and I will do a bit of a comparison between Jeffrey Dahmer and SCHABUSINESS on Sunday, Rumble only on Serial Killer Sunday. And this is the channel. So, because I see in the chat, it's all about but Dahmer, he ate his victims. Not necessarily. He tested the blood of one of his victims, but he didn't like it, so it never happened again. He had prepared from 2 victims the bicep muscle, but only ate from one of them. That's it. So that he ate from everybody? No. Did he do some cannibalism? Yes, but not to the extent that people seem to believe.
We're coming up on the 20-minute mark for the deliberations. We're almost halfway to where we were yesterday. 3 minutes from now, we'll be halfway there. Whoa, living on a prayer.
And no, Eric, he didn't feed his victims to his neighbors.
All right.
An actual
comment away, people.
On Sundays on Rumble on my Serial Killer Sunday. Just a little bit of cannibalism, yes.
Anybody have anything else to go ahead? Keep contributing here. We're just we got what we got here.
Do we? I don't know. Is there a situation where we could have gotten a better expert, a better defense that this could have turned out differently? I guess now that we've seen all the evidence that's been presented, I think the worst thing is her own statements, right? So she admitted to doing it, but is there any situation that we could conceive that this could have come out different for SCHABUSINESS besides the whole, maybe not killing her boyfriend thing?
That was kind of it. That's what I was going to say.
Well,
I mean, don't do drugs.
Don't do drugs. No, but like, okay, so the passion in the prosecutor, right, during the first 15 minutes of the closing argument, I wouldn't go with the last 15, but the passion was there. You know, he walked around, he was animated, he was making arguments, he was compelling. I liked him. I agree with him. I don't know if that would have done anything.
Well, and on a random note, I just got a tweet with the very first actual verified sighting of the Legal Vices Law Racks merch.
Nice.
A shirt with my little Law Racks logo on it has been sighted in the wild. Thank you, Swan Lake Lady, for sending me that picture. There is a merch link down there if you want some Law Racks gear. I'm still waiting for mine. But anyway, sorry for that little shameless plug in the midst of that. I'm just going through. There's a letter that Mr. SCHABUSINESS wrote in weirdly really good handwriting. I believe it was. I'm not sure who. I think he wrote it. That's what I'm led to understand and led to believe. But I'm going back through my Twitter messages to find it. So continue to talk amongst yourselves.
Yeah, I was a bit annoyed about the prosecutor and his jacket being 2 sizes too small. I mean, yeah, you see me now in civilian clothes, but if I need to be in or around court, which is rare, I make sure to dress appropriately. So that was a bit annoying. And then when he argued that they brought a sole expert, one expert, well, that's really not up to the public defender. He gets the funds from appointed to him that he can spend. Then he can ask for more money if he needs more experts, but generally that's it. He gets the money for one expert. So to hold that against the defense, I really didn't like. Any opinions?
No. I mean, yeah. Isn't there a jury? I mean, in Michigan, there's a jury instruction that specifically addresses that issue, like the number of witnesses. You can't, give more deference to a police officer witness as opposed to anyone else. I didn't hear those jury instructions here, though. And again, it kind of maybe goes more towards the Wisconsin courts are weird sort of situation. But did we hear anything like that? I mean, because that was a specific argument made by the prosecution, right? You're not allowed to make that argument in Michigan.
I'm not sure, but nobody objected to it, and the judge didn't react to it. So apparently it's allowed.
Lack of objections, too. I think Chandler had kind of the right idea. Like, this guy has no faith in his client. He has no faith in the case. And that was read throughout the entirety of the trial. You could see that.
Chandler?
Chandler has a headache.
Chandler's disappeared.
Well, if I may, for tomorrow.
Oh, yeah, grift. I got to go start rice.
Tomorrow at 5 p.m. Eastern, my Chat-Faced for Charity stream. We are trying to get money to Zachariah Anderson's defense fund. And my contribution to that is to invite guests, have a little fun, check out new exculpatory or old exculpatory evidence while I'm getting shit-faced. So,
okay.
Yeah. And I will try to hold on as long as possible. The goal is to get from $27,000 to $30,000, and that will get me extremely shit-faced, because as I've said, $150 to Zach and a contribution to me, and I will take a shot. So that would mean that to get there, that would take 20 contributions at $150 each, will get us to $30,000. That means at least 20 shots in my body if you also contribute a bit to my channel. And I really need to restock on this because I've been drinking a lot for the Zachariah Anderson case. Last time I did this, it got $1,300 in an hour and 20 minutes. And then I only did a shot per $100 to Zachariah Anderson's fund. So that was 13 shots. That's a shot in less than every 10 minutes. Then I went to bed.
Well, I'm going to read this letter from her husband that has been sent around the Twitterverse. Let me see here. Got to share a screen. Where are we at? Okay, just stop the cord screen. I hate this. Wish you could like open up 2 windows at once. That would be nice.
Yeah, I know. That's it's like so easy to use, but limited at the same time.
That's why it's so easy to use. It's the lowest common denominator platform. All right, here we go. And this is from her husband. This is weirdly good handwriting for a man.
Ooh, yeah, that's not from her husband.
Especially a man in
I'm going to
prison.
object to that.
Pictures to upload to Facebook because he's also in prison. Post for Facebook, babe. Unless I'm thinking this was dictated by phone, perhaps. I don't know, because that does not look like a man's handwriting. And if it does, it's weirdly, weirdly nice. But that's just me. Babe, I look at our pictures every day. This is the husband. Now, this is after the murders have been committed, etc., etc. They keep me motivated, take my bitterness away, plus keep a smile on my face. The world don't know us for who we are. They don't know our struggles we struggle with. Mental illness, postpartum, bipolar, and addiction play a big part in our choices. Our choices we've made. People probably want to know what happened February 23rd, 2022. Scroll. Drugs were given to Taylor SCHABUSINESS from Shade? Shad, I believe that is. So drugs were given to Taylor SCHABUSINESS from Shad while at his house. Yes, he is dead now, which I am sorry for him and his family. Well, she said that anyway, we're not going to critique. We're just going to read. I'm sorry for him and his family. The truth is, though, drugs should have never been given to my wife because it's the drugs that caused her to do what she did. That doesn't help. But yet, Shad isn't at fault here, and he's the one who provided her the illegal drugs. I just hope one day my wife will make it home because she doesn't deserve to be locked up forever. She's still the mother of our son, Mateo. We don't care about her son's name. King SCHABUSINESS. Oh, that's his middle name is King. Great. King SCHABUSINESS. She's still my beautiful wife, and I want the world to know she's not who the news makes her out to be. With this being said, please don't judge because... Scroll up some more here. There's always 2 sides to every story. And I promise you, if you knew my wife like I know my wife, you wouldn't think or believe she could ever do what has been done. But at the end of the day, she's still got a son and a husband who loves and cares about her more than anything in this world. Baby Boo and I pray for you every day. We think about you nonstop, and we promise you we will always be here for you no matter what, because that's the SCHABUSINESS way. Stay strong and get better soon. We need you, Mommy Boo. We love and miss you so much. Everything is going to be okay. Mwah, mwah, mwah. Hashtag free Taylor SCHABUSINESS. Love always and forever. The SCHABUSINESS. That's the letter from her.
Hashtag free Taylor SCHABUSINESS. I wonder how much traction that got.
I don't think then what was in the news that was the problem, because I think the news downplayed what happened.
Yeah.
After reading that, they should have called her husband to the stand for her case in chief.
Oh, that would have been really bad because he said the drugs made her do it, not the mental illness.
Well, but the drugs messed with her mind, and that's what made her do it. Right? It was after the fact.
But well, he is in jail, and the kid is at the grandparents, so no happy family for a while.
Yes.
Yeah, well,
forever.
Most likely. Gosh, well, we are 28 minutes and 47 seconds into jury deliberation. The judge was mentioning hanging around for 30 minutes, but I think he's going to continue with the deliberations.
Yeah, he's just going to send the lawyers home after half an hour.
He's hoping that they walk in, fill out the paperwork, and walk out again. Well, how long did it take them yesterday? Was it 42 minutes?
42 minutes from the time they left to the time they came back.
That
And
seems
we're at
almost too long.
29:15 now.
29:15. We've been.
Yep.
It's been 29:15 since they left. Okay.
Yep.
Mm.
The jury's taking a while.
Can I say this though? I don't care who you are, what you cook. A rice cooker is an essential component to any kitchen. I love my rice cooker.
Absolutely.
Absolutely. I just ran upstairs. I throw a bunch of rice in, throw a bunch of water in. It's going to do its thing, and when I'm done, I can go eat rice. It's amazing.
Welcome to the Asian way of living. Rice cookers are an absolute godsend.
My Korean associate got it for me one year, I think for Christmas or something, and
he's a good man.
I love it. Yeah, very good.
We do have a couple of super chats here. Move the microphone closer here. Heather Sparrow says, "Grab yourself a coffee, Jeff. Thanks for keeping us entertained in a diabolical, duplicitous way." Oh, I wish you would stop using those words. That always just annoyed me.
Yeah.
Delisandor, thank you so much for your super chat. Don't have much. Don't worry about this. You don't have to super chat if you don't. But thank you so much. Don't have much dollars, but appreciate you. Thanks for hanging on. Well, I appreciate that. That's why every super chat I respect gratefully. Doesn't matter if it's not that I've ever gotten a $500, but $500 super chat and a $1 super chat are the same to me because it represents people parting with hard-earned money to support me. It's we only super grift one day a month. Otherwise, it's just we just do our thing. And deeply, deeply appreciate that. Thank you. Never take it for granted. And Magician Sapphire, hey, what's up? Thank you so much. His Looney Tune of a wife yeets a man she cheated on him with. And he is still standing by her. The husband is a cuck. Now, that's like several times I've seen cuck spelled CVCK. Are we saying that YouTube has blocked that word?
Yes.
What did I try to? I tried to super chat something, and ass. I had to do like A33 or something. It blocked it. It wouldn't let me do that.
Yeah, you can't do AS, $, A3. It's getting to be a bit of a joke.
Oh, A33 went through. So that.
A33 went through? Okay.
Yeah, A33 went through. But yeah, no, I was just like, really ass. That's God forbid.
Yeah.
I wonder if arse works.
Arse.
Arse. Oh, we could do arse.
We can try. Well, see, it'll let things through in regular chat that don't go through in super chat, which I just don't get.
You know what? That's true because I was trying to do a super chat of it. And that's where it blocked me. But I feel like I've used ass before. Yeah, see, ass is going through.
Yeah.
Everyone's going to type ass in the chat now.
Yeah.
Yeah.
If
Maybe
you're
it's
out
because
there,
it gets
say
promoted.
ass.
And Sonny or Chris says, rice pot jambalaya was a lifesaver when I was deployed.
Rice pot
X-Comer says, nope, cuck works.
Thank you, X-Comer.
All right. So solve that question. All right.
Oh, that's great.
We're at 32 minutes now. We're 10 minutes away from beating the record for jury deliberations in this group. Keeping us. See, and this is what I was saying while we were watching the deliberation for the phase 1 part. There's not a lot to talk about because we've talked about everything already.
We talked about it as it was happening.
Yeah, that's kind of why I'm pretty silent, is that we've already gone over everything, and I don't think we want to talk about anything else, because this is literally the SCHABUSINESS stream, so...
Yeah.
I'm just going to sit here and look pretty.
We are going to be sniped, apparently, by Flux here in a few minutes, just so you know.
Yeah, Flux said when she starts, she'll do this. Well, I guess we can all just kind of talk about what's coming up in our lives. SCHABUSINESS trial's over. I have no idea what I'm doing with my life after this point.
Can I just say, I'm surprised how short it was. I thought it was going to be a lot longer. I anticipate, like, Sarah Boone being a lot longer. That was supposed to start simultaneously with this, and I thought it was going to go at least, a couple 3 weeks.
Well, the judge estimated 1 month for Sarah Boone. But,
yeah,
SCHABUSINESS has kind of always been, and I think that it was why. I mean, we're finishing early, with SCHABUSINESS. So I think there's not a lot to argue.
Well, like I said, when I was watching her interrogation videos, this is the first time I've seen them. I don't know if they snuck out at all, but you know, it was kind of an easy case for the police. She gave them everything, absolutely everything.
Yeah.
And so obviously this is going to be a cut and dry case, but I thought they were going to argue a lot. I was concerned at the beginning when the state first started bringing up the, you know, the first officer on the scene, then the next officer on the scene, then the third officer on the scene. I'm like, oh, they're just going to like, you know, drill. But then it went really quick. So I was surprised. But yeah, anyway, so I'm looking for another trial to stream. I don't know what I personally have coming up. I've got some videos that I'm working on with Valhalla and Chandler doing, Chandler and I doing some Sarah Boone stuff, some updates. Valhalla, we're doing some Stolen Valor and some things like that. And then looking for a trial to stream. I'm not sure what's happening right now since we have the Idaho and Boone are all pushed to October. The case that got me onto YouTube to start streaming, period, which is James and Jennifer Crumbly. That I was originally thinking was going to be November. It looks like it might be pushed off to January. So, but we got some cases going. We'll figure it out. We've got always content. Oh, and then of course, Nicholas and I every Tuesday and Saturday at noon Eastern and 6 p.m. Swedish time are rewatching the Jodi Arias trial. So that's a lot of fun. That's all kinds of crazy. And we got a few more days until Jodi takes the stand. So that's exciting.
Yeah. We are into the part where, in the appellate court's opinion, it was riddled with misconduct, but not enough to overturn the conviction. So that will be interesting to see what exactly is all of these misconducts. But then Jodi will take the stand, and she will remain on the stand for 13 days.
Ozzy, what you got going on?
This evening, my time, I've got the after party. So we've got game 2 of the Lingerie Football League that we're watching the second hour. I've got. I'm going to try and see if I can find a day this weekend to finally finish the Rittenhouse rewatch party as well. But beyond that, I'm sort of up in the air, at least until Wednesday, when I'm literally up in the air. So. And just so people are aware, while I am in the US, I will be trying to stream as much as possible, but it's going to depend on my access to internet. Because let's face it, we know that hotel Wi-Fi is not great, so I'm thinking whether or not I can get like a mobile dongle or whatever it is so I can have actual internet while I'm there. So,
can I answer a question in chat real quick? Hey Joe asks about the Ethan Crumbly trial today. So it wasn't a trial. So, and just for everybody knows, Oxford school shooter Ethan Crumbly is a minor. His parents have been charged with involuntary manslaughter. And that's the case that I was talking about that I'm covering. However, their son Ethan, who's the actual school shooter, had what's called a Miller hearing today. And in Michigan, before you can sentence a juvenile to life without the possibility of parole, you need to have what's called a Miller hearing. It's actually kind of new. It's a new thing that the Supreme Court kind of overturned a bunch of life sentences on children last couple of years. And so now we have this new Miller thing where they got to go through a bunch of factors. That happened today. I am going to stream that. Obviously, I wasn't doing it live, but I did capture that, and we're gonna cover that too, because there's going to be some parts in there that are going to affect James and Jennifer, I believe. So, but that's what happened today with Ethan. I don't know the results yet, though.
I guess Sean and Chandler are still MIA, so it's my turn. Cool. Like I said, I don't know what I'm doing now because I've been doing trials now for about the last 6 weeks, I think, with the YNW Melly trial and this. I'm lost. We'll get back to some point. Let me finish my grift here. Hang on.
Yes.
Let me finish my grift here. Monday we'll be doing the Maritime Monday. We'll get back to that. Frankly, we're just going to watch some clips of people on boats doing dumb things. No major serious cases. I need a palate cleanser. Tuesday and Wednesday, I don't know. It'll be fun to see what I decide to do on Tuesday and Wednesday. And Thursday, Chandler and I will be doing our OJ Simpson, our weekly OJ Simpson thing. And Friday evening, I don't know. Again, we'll probably just do a Friday chill stream. And that would take us up to the 4th, then the 5th and the 6th, then Monday and Tuesday, another Maritime Monday, something on Tuesday, and then I'm gone for 2 weeks.
I have the
few
YouTube
days,
to myself, and you guys are all
yeah,
gone.
well, have a few days in Texas for Anime Matsuri, and then hang out with the family for a week, 8 days. And unlike Ozzy, I plan to stream as little as possible. I will do something just to say hi, whatnot, and upload some things to be released while we're gone. That's kind of what I did last year. We did some of the premieres where we just watched stuff that I have preloaded together, and then we'll be doing guests in the meantime, guest shots on Meme Copium here in a few hours, and then later when I get a chance, we'll be hanging over with Nick doing our thing for a little bit. So yeah, it's just going to be kind of a chill stream for the next 8-10 days, and then it's vacation, and then we'll do something. We'll pick right up where we left off around the end of August. It'll be fun. It'll be a fun month to see what happens.
And fingers crossed we all survive it without a criminal record.
Yeah. And we are now at the 40-minute mark.
Well, tomorrow, Jeff, I'm hoping that you will show up on my fundraiser stream.
Just mentioned you, so I'll be on Meme Copium and you.
Okay, yeah. Sorry.
You're sleepy, sir.
Yeah.
I've been there. I'm there now, but it doesn't show. I'm fueled by caffeine and nicotine right now. That's that's where we are. And I'm going to get to my office, and I'm going to crash hard. That's what's going to happen.
Next Monday, my vacation starts. For everybody else, it's 5 weeks paid vacation.
Nice.
Yeah.
Ridiculous.
I'm going to stream the ever-living frick because it's just me and Dave on LawTube. The rest is trying to avoid jail time in Texas.
Did you plan that on purpose, Nicholas?
My vacation.
Your vacation coincide with everyone going to Texas?
No,
and not streaming.
No. My vacation is always late in the summer because I'm going to spend a couple of weeks up in the cottage. But I do have a broadband internet there, so I can stream from there. So yeah.
Nice.
And the late vacation is just because all the tourists have left. So I don't have to chase them off the lake.
Nice.
Well, Barnabas Wizard Spook, who's been a member for 1 month, said, "Counsel, please cough straight into the microphone. Thank you." Yeah. And Joe coughed directly into the microphone, too. Kind of went deaf there. And Volpe Fox says, "I imagine this will be fairly quick." She's been a member of he or she, I assume it's a she because it's kind of a female-looking fox. Member for 2 months of the Clean and Sober Cruise. I imagine this will be fairly quick. Jury probably doesn't want to come back tomorrow to decide on the flavor of banana that SCHABUSINESS is.
All right.
And that takes care of our monthly membership chats there. Yeah, there.
I am going to jump over and say happy birthday to Flux real quick because that works for my schedule at the moment. And then if we get a verdict, you're going to keep going, right? I'll come back.
I can do probably another 30-35 minutes, and then I do have to get ready and go to work.
Okay. All right. Well, you guys take care. Thanks very much for having me. I'm going to go say say happy birthday to Flux, and then I'll come back and join you. All right. See you guys.
See ya. And Lisa Franceschi has upgraded her membership to the Bent Halos and Broken Wings level. Thank you so much for doing that. I am a female-looking fox, Jeff. Well, good. I didn't want to misgender anyone, especially now that they want to make it a crime. Wow, Lisa going all the way for Jeff. No, the Fallen Angels is going all the way for Jeff. She only went halfway. She only went to second base. So Chandler checked out. Bye, Chand. See you Thursday, or somewhere in between.
Well,
let's see. We have now hit 43 minutes. We've now set a record for this particular stream. We've set the record. We broke the 42-minute record.
I mean, it shouldn't surprise me, but it's slightly ironic that it's taking longer to work out whether or not she was insane or not, compared to whether or not she actually committed the crimes. Like, I know that it was fully... Like, there was no doubt that she did what she did. Yeah, I don't know. And Eliza, yes, I'm a little bit nervous. This is the first time I've left my firm in 4 years. Also the first time I've travelled without the family, so... Yeah. But yeah, it's just like, why are they taking so long? I don't understand it, especially if it's not majority. I mean, sorry, if it's not unanimous.
Yeah.
Did they get someone... Oh, maybe they've rotated the foreman and the new one is writing right slower than the other one.
Could be. That could be it. We're just sitting here, just us and 888 other people, wondering what's happening here.
Yeah. And the 2 or 3 that are interested, the Andrew Tate trial is at least 2 months away, and because I'm covering that, and the Young Thug trial probably won't happen until October at the earliest.
And we've got 894 people here concurrently, 947 likes, 52 more likes gets us to 1,000. Come on, peeps. 52 of you, just reach down there and smash that like button like you should, just to get us to 1,000. Because why not? That'd be fun. And we have 2 super chats. One from Inya Mers. Where are we? Oh, we have a few in here. Okay, Inya Mers just says Ars. Fiery Red Podcast says Ars Slancha. All right, Slancha to you too. It is now 8:13 a.m. I cannot drink because I'm working. And Mario Marsro, however you want me to pronounce Mar3ro. You're just great, Legal Vices. Well, thank you, Tony the Tiger. And that catches us up. Tiger Shark says Jeff looks like Saul Berenson from Homeland. Well, okay, being compared to Mandy Patinkin, it could be worse. I'll take that. New Jacoby Davis coming in with a $2 super chat. Any plans to cover the Billy Mitchell trial? I have no idea who Billy Mitchell is. So that answers the question for me. Billy Mitchell, anyone?
No. Might have to have a look.
Billy Mitchell. He's a whisper thin feller with long hair and a beard. He's a gamer. He achieved fame through the 1880s and 90s. Yep. Oh, the near perfect. Oh, the near perfect guy. Is this the guy that cheated on Pac-Man and he cheated on Donkey Kong?
That one.
Yeah.
Sorry.
Not going anywhere near that because he's litigious about anyone that comments on it.
Yep. I think that Alida.
Well, she's not here to talk about it.
Legal Bites have done a few episodes about that. So she might be covering that.
Yep. None of us apparently. So.
No.
Yeah. We don't talk about him a lot. I even forgot he existed. Not because he did anything wrong or he's a bad guy. He just went off my radar. Did you read up on the UK Lucy Letby trial? Nope.
Yes, I specifically haven't done an update recently because, frankly, that case is completely heartbreaking, and I'm not sure anyone should be able to make it through that in one hit. That's the nurse that basically murdered a bunch of babies within weeks of being born. Yeah, that one's rough.
Jury has been deliberating for 9 days. Gee, the Melly guys, they gave up after 2.5.
Well, I mean, there's something like, I can't remember whether or not they removed some of the charges, but it was something like 24 different charges involving each of the kids. So it's
murdering 7 babies and attempting to murder 10 more.
Mm-hmm.
Yank. Yeah, that's unsavory.
Yeah.
What's her face? The teenager who was convicted of ending her father with what was her name? Well, it was sentencing the other day, and apparently she only got a year with a lot of years probation. What was her name now again? Chat, help me.
The one person that was sentenced the other day that got probation? I don't know what that means.
No, but she was convicted of murder. And all of a sudden, after half an hour of begging the judge, she got off with a year. I watched that with Dave, and we didn't think there was enough evidence to convict her. So, yeah, I might fling in a stream about that this weekend. But Megan, thank you. Killed Dad with Lie. And she was convicted.
Yeah, okay.
So that was the other day, the sentencing, and she apparently got a very light sentence for that crime.
OMG, WTF really says the Melly jurors are Florida jurors. They're lazy. And in Florida, everybody works for the weekend. I can say this because I lived in Florida for over 15 years. All right, fair enough. Yeah, everybody's like mentioning Megan, whatever her last name is. Don't yell at me. I don't know. I haven't been following it.
Yeah.
Starkey, I would really hope so. Honestly, I really do. There was enough there when I looked that I was fairly confident. It's just whether or not she tries for... I mean, I haven't looked at it recently, so I don't know what they're specifically deliberating on. But I think there was enough there for what her colleagues said and saw and that sort of thing as to what she did to those children that I would fully expect her to get quite a bit of time. Sorry.
And Marrero says it's pronounced Marrero, and Ozzy is great too.
Oh, thank you.
I concur. I think Ozzy's a pretty great guy.
Porcelain Thunder has a question right above the super chat. Oh, the guy who got arrested for indecent exposure for jogging. That
sounds like a Hayden story.
Overly sized black gentleman. Didn't you cover that?
Oh yeah, one for each titty.
Yeah.
Jeff's like, what the hell are they talking about? He supposedly got forced outside while he was jogging, and he had his shirt off, and the cops arrested him for indecent exposure, and he received 2 different court dates, and he goes, I can't believe they gave me two different court dates, one for each titty.
So a guy had his shirt off and it was indecent exposure?
Because of how obese he was.
Yeah.
Oh no.
Very large man with who would make
Wow.
many women larger moves than many women have boobs.
Lisa Franceschi just gifted 5 Legal Vices memberships, and Shelly Sincolo, OMG, WTF Really, Page M, Fiery Red Podcast, and Labman34 are the lucky recipients of those. Give her a thanks. Thank you so much for that.
Thank you.
It's very nice of you to do that for people. Problems?
Check my
update. Right. Jury's deliberating for 52 minutes now. I hope the judge pulls the plug after the hour mark. Because I know that the minute that I end my stream is when they'll come back.
Well, look, if they're still deliberating when you go, I'll start up a stream and I will bombard you if they come back.
Well, I won't be. I'll be at work, so it won't matter. I'll just be able to watch.
Well, you'll be there in spirit. I'll start up a second camera and just have your icon there for you.
Where
are we?
Well, we are literally just killing time right now. And there's still 865 people watching us flounder for something to talk about while the jurors take a long time to decide if she's nuts.
Well, I mean, speaking of dismembering, I'm just trying to pull up the latest on the Brian Walsh case, because I will be following that later this year. The gentleman that allegedly dismembered his wife, and so we'll be covering that as well. So that's going to be interesting. Just trying to pull it up. I'm not quite sure
And
where it's going.
trans community is still mad at Dee Snider for not agreeing with them 100%. Yeah, he has been
Can I need a
very
little more on
vocal.
that? What?
Yeah, Dee Snyder from Twisted Sister has been very vocally supportive of the trans movement until this in the south of the United States, and he said something about just stay off the children of sorts, and they went ballistic. So now he's a
Yep.
transphobe and everything, and that is apparently still ongoing. And yeah.
Spotha, a long time ago, like 4 hours ago. I'm sure you're not even here anymore, but I had it starred, so I wanted to go. When you commission your pipes, do you get to choose the material? Can your dude do meerschaum? No, it's just Briar. But if you want, I mean, all the meerschaum people, you want to get them there, like in Turkey and Albania and places like that. That's where all the great meerschaum carvers are.
Mm.
Turkey, Albania.
Yeah.
Siv asks, she says, I'm glad us rational people can opine on what an insane person would and wouldn't do. Well, that's exactly what the jurors are doing.
Thank you for calling us rational.
Yeah. That's what the jurors do. They opine on whether she's insane and what she would do. Get out of what? She's already been found guilty. Get out of life in prison without the possibility of parole by getting sent to the some psych ward somewhere for pretty much the rest of her life as well. So it's, where is she going to spend the rest of her life is essentially what we're looking at here. Volpe Fox says, husband's going to get me Legal Vice's pint glass for Christmas. Hooray. Booze at family gatherings.
Lovely.
You have the merch down there. I'm still waiting for my merch, and it looks like it's probably going to arrive after I leave for Texas. So I'm hoping at least one of my shirts gets here so I can wear that while I'm there.
Yeah, I only have this print-on-demand Teespring as merch, and I have the mug also as a T-shirt.
I've really got to work on my merch. I think I've had 3 or 4 things sold in the last year. One of which a very avid fan happens to wear the swimsuit as a billboard when she goes on other people's streams.
Oh, I remember that. Yeah.
Yep. We love her for that.
Okay. Yep. Yep.
Okay.
So, but anyway. I'm trying to access the Massachusetts court system, and for some reason it's not letting me in. I may have to turn on my VPN, which means I'll drop out for a second.
Yeah. And we are at the 56-minute and 37-second mark. Just killing some time. Yeah, I'm dang it. See, I know I have to pull the plug at the hour mark, but I know 61 minutes is when they're going to come back, and that really annoys me. I'm pre-annoyed because I know it's going to happen.
Okay, this was on Twitter, and this was posted today. Some guy with almost 1 million followers on Twitter or X, Mario Naval, is suing a YouTuber.
Huh.
Okay.
I'll send it in the private, and you can decide if you want to read it.
Okay.
Legal Vice says, will judge rule tonight if jurors come back tonight? Oh yeah, if they come back with a verdict, I'll read it. I'm just hoping he sends them home so I can go to work and have a peaceful day, not worrying about it. And then he picks up early in the morning, and it takes him about 5 minutes to give their verdict tomorrow, and then I can go to sleep early. That's my little fantasy world I live in. Jeff, in that Megan case, are the days over 1 year taken off her time on? I have no idea what the Megan case is, so I have no idea.
Yeah, apparently I saw the answer to that in the chat, and she got 586 days, but time served gone from that, so it's about a year, and then probation after that.
Enchiladas. Jeff, you have a fever. Might be the coof. I don't have a fever. Weird. That's a weird thing to say, but yeah. Robin Noel says verdict reached. That's what the law and crime says.
Oh.
Law and crime says verdict reached. Oh, and they are back in court. Sweet Jesus, thank you very much. Let's bring it on up.
All right.
Present camera. Wheel. All right, we're waiting for the peeps to come in. Woohoo! And then they're gonna go. Oh God, I'm so happy. The verdict is coming back. So here it is. Does anybody think she's not going to prison for the rest of her life? We all think she's going to prison for the rest of her life. All right. All right, they're standing up for the jury. No audio, so there we go.
Quick, get the cut cage up for when this gets clipped.
We're good. I'm typing on Twitter.
Oh, Flux is sniping you. I think, when they read back the jury verdict yesterday, I counted to 8 women and 4 men. Just as a side note.
Taylor has not been brought into the room yet. Here she comes.
Cock cage.
We're not doing that typing right now.
And happy birthday, Flux.
Anything to bring up before the jury comes back, Mr. Saunders?
No.
Mr. Freilich?
No, you are.
All right.
Jury's coming in.
I should have had the party popper handy for this.
Yeah. Bailiff ready.
Counsel needs to take one step to the right.
All right, jury's coming in, obviously. They're all standing for the jury.
No, bailiff doesn't look scared. And
Steve Gosney joining us for the verdict.
Okay, be seated. You are the foreperson, is that correct? Yeah. If you could hand your verdict to the bailiff. Okay. The verdict seems to be in order, and I will read it as follows. Question 1. At the time the crimes were committed, did the defendant have a mental disease or mental defect? Answer, no.
Wow.
There's no answer then for question 2. It is dated July 27, 2023, signed by the foreperson. There were no dissenting jurors.
Unanimous.
Jail for you.
Is there a request by either of the parties to have the jury polled? Mr. Saunders?
No.
Mr. Freilich?
Yes.
All right.
Of course.
We did this the last time, ladies and gentlemen. I'm going
That's
to
it.
poll you again. I'm going to start in the back. Ma'am, are these your verdicts?
Yes.
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 Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Start down here. Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Unanimous.
Ladies and gentlemen of the jury, your service in this case is now completed. Many jurors ask if they are allowed to discuss the case with others after receipt of the verdict. Because your role in this case is over, you are not prohibited from discussing the case with anyone. However, you should know that you do not have to discuss the case with anyone or answer any questions about it from anyone other than from the court. This includes the parties, lawyers, the media, or anyone else. If you do decide to discuss this case with anyone, I would suggest you treat any discussion with a degree of solemnity, such that whatever you do say, you would be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of the parties. It is in the public interest that there be the utmost freedom of debate in the jury room, and that jurors be permitted to express their views without fear of incurring the anger of any litigants or criticism of any person. Please respect the privacy of the views of your fellow jurors. Finally, I'd like to address you before you leave, so if you could just wait in the jury room for a few minutes, I'd appreciate that. And you may confer with me at any time before answering any questions from anyone. I wanted you to know that as well. And with that, we excuse the jury. All rise for the jury.
So question
That's
is, when does she get sentenced? I mean, I think, is it a min-man life?
Yeah.
I think so. I think you're just going to say it right now, I guess. I don't know. I'm not sure how it works in Wisconsin.
He could show, I mean, in Florida, if it's like a min-man like this, or there's no discretion, he could
And
just
having
sentence her
received
right
this
now.
verdict as well as the prior two, does the state have a motion regarding the verdicts? Mr. Saunders.
I'd ask the court to accept the verdicts and enter a judgment of conviction. I do have a certified copy of a judgment of conviction, case 20 CF 998, as the basis of the repeater allegation in counts 1, 2, and 3.
Those will be received. Mr. Freilich, any response to that request?
Your Honor, I bring a motion for judgment notwithstanding the verdict.
Yeah, not going to happen.
I believe there's testimony,
Good luck,
ample testimony in the record that my client was suffering from a mental disease or defect at the time of these offenses, and that she lacked the substantial capacity to appreciate the wrongfulness of her conduct and conform her conduct to the requirements of the law. And ask that you consider all of the testimony from Dr. Lighton, who is a seasoned veteran in the field of psychology, and the record. Thank you.
Thank you. Well, I've listened to the entirety of the testimony over these last several days, and specifically regarding today's testimony with regard to the responsibility phase. I'm satisfied that the evidence is sufficient to support the jury's verdict, and I'm going to adjudge the defendant guilty on count 1 of first-degree intentional homicide as a repeater, count 2 of mutilating a corpse as a repeater, and count 3 third-degree sexual assault as a repeater. I'm going to revoke bond at this time then, and I'm going to order a pre-sentence investigation report be conducted. I'll
Okay,
order
so
that
no
at
sentencing.
no later
Yeah.
than 1 week in advance of sentencing, and I'm looking to schedule a sentencing date.
I guess the other two charges, he wants to appropriately sentence her on those, so he...
Yeah, I guess so.
Let's check that out here.
Either way, she's going away for life.
He's
Already
very
had
by
a
the
scheduled
book.
jury trial
Yeah.
on September 19th and 20th, Your Honor.
You son of a beach.
Do it in around 10, 12 days.
No.
Stuff you, Nick.
They're already into September. Let's see what they're saying here.
So I can stream it by myself.
I'm going to pre-record so much shit now that I know that.
Yeah.
So,
September
thoughts on how long people think she's going to last?
Hang on, wait. He just gave her the date.
Oh, fuck.
Back a little bit here. All right, now we're buffering. Dang it.
September 26th.
September 26th. Make a note.
I just have an inquiry. Would it be set for the whole day? For half a day? I've got hearings that day, but I could try to move some things around.
I understand, Mr. Gurley, and I appreciate it if you can do that. That's 2 months out. I have things on that day too, and you might be getting a phone call. You might be getting a phone call from my office asking if one of these cases can be moved, which will be easy to get permission for me to do that. But I would schedule it for 8:30 in the morning. I don't know how long it's going to take, but I would plan on the matter taking the entirety of the day.
Your Honor, I think I can move everything, but if it could could it start at 9:30?
Sure, I don't have a problem with that. 9:30 in the morning. Mr. Saunders, I see you checking in the back with, I'm assuming with the crime victim. Is that an acceptable date to schedule?
Yes, I believe it is.
Okay. September 26th, 9:30 in the morning. I'll have that scheduled for the balance of the day. 9:30. He asked for it to start at 9:30.
Yes.
All right. Very good. Anything else before we adjourn, Mr. Saunders?
No.
Mr. Freilich?
Your Honor, that pre-sentence report, if I only have a week, I can imagine this one's going to be long. Could I have a little bit more time, maybe get it 10 days before?
I will. Here's what I'm going to do. I'm going to order that it be released no later than 2 weeks in advance of sentencing. This hearing is about 2 months out. I didn't count the weeks, but I think we can get it done in that amount of time because they tell us they can get them done in 6 to 8 weeks. So that's what I'll order. Okay.
Thank you.
And with that, the matter is concluded. Thank you.
Thank you very much.
Well, now she's going away.
Yep.
For the rest of her life, plus a bunch more years.
Yeah. Now, how do you think she will handle jail or prison?
Well,
will she be the queen of it or the bitch of it?
Dana Loves Zumba says, Cash, to thank you for your efforts, Jeff. So thank you so much. I appreciate that. And John Gordon Boone, you're next. Thank you as well, John Gordon. And Unhung Hero. Thanks, Jeff, for covering this. You are very, very welcome, one and all. And that's it. That's the end. We finished a day early. So I'll just get a chill debrief stream tomorrow. I'll actually go to sleep at a normal human hour and sleep all weekend. So that'll be good. Guys, oh, wait a minute. Sorry, Steve. I thought we removed that. There we go. That's where we are. The end. Final comments. Let's go from bottom to top. Steve, final comments.
Interesting. It was an excellent taste. I'm going to do a live stream 8:00 p.m. Eastern Standard Time tomorrow on my Rumble channel where I'll grade the parties. And Nick and I had a fight, a dust up over the defense attorney performance and the grade. So I would ask you, my legal vice's friend, what would you give the defense attorney as a final grade?
I'd probably give him a C minus.
Okay. I will take your input into consideration. Anyway, so tomorrow,
you disagree with it clearly, but that's
you're much closer. Nick wanted to give him a D minus, and I disagree with that.
Yeah, I mean C plus B minus somewhere there because he had absolutely nothing to work with.
Well, Nick, thanks. So you get it because see, I'm a public defender, and sometimes you get those cases where there's just absolutely nothing. And, and so you have to understand that the lawyer is not the case. So how do they perform in the face of not having anything? So by what criteria do we judge them? By what standard, what measuring stick do we use? So we'll talk all about this tomorrow, 8:00 on my Rumble and YouTube. I guess I'm on YouTube now. So at 8:00 tomorrow.
Yeah. And
Nicholas
I have-
Starov, final words.
Well, I have those cases too sometimes, whether it's clearly the member did some really, really stupid thing and it was clearly that member's fault. I still have to be there to ensure that everything is according to law and regulations. Will I be happy about it? No. Maybe I can cover it up better than this guy does, but these cases are out there where you basically have absolutely nothing to go on, but you have to be there.
Aussie Overlord, final comments.
Look, I think we can honestly say that this was a foregone conclusion as to what we expected. It would have been to the level of what happened in other recent cases, if anything other than a full life sentence plus the years for whatever else she did to the corpse was going to result in anything else from her behind bars for the rest of her life. I do think that in terms of the parties, prosecutor did his job. I do think that the defense had a shocker of a case. I do think that he could have done it better. Personally, I would class him as being satisfactory, not excelling in any sort of way, shall we say. He did enough that I don't think that he's going to get any sort of malpractice claim made against him, basically, is what I'm saying. He did what he could with what he had, but again, I do think there were better ways for him to infuse a little bit of showmanship, for lack of a better term. But yeah, I think we got exactly what we expected, so hopefully it's lived up to your expectations too, Vices.
Well, it was a year waiting for this. We sort of started on this right after it happened. In March, April, 3 months after it happened is when he started following this. Pretty much day one from YouTube. I was waiting for this. This was the first real case that I've done from nearly the time of the act until the trial. It was good. It was interesting. Learned a lot. Learned more than I wanted to about some things and some people, but it wasn't a big stretch or a leap to figure out that we could all pretty much predict. We never want to predict what juries are going to do, but if you're ever going to do it, this was probably the safest case to determine and try to guess what a jury is going to do. Justice was served, I think. Everything was done absolutely properly. And that's it for the Taylor SCHABUSINESS trial. Join me tomorrow. Probably do a Friday morning. I could like a quick, maybe an hour. I don't know. I don't know if I'm going to do it Friday evening or Friday morning U.S. time. I just don't know. We'll find out. I'm going to play it by ear. Going to ride the waves for 10 more days, then go on my vacation, and we'll get back to regularly scheduled programs around the end of August. So we're going to have fun.
Hey, Jeff, can I say congratulations to you on conducting a great coverage of this trial, and you really hyped the trial and you delivered, and I want to thank you for having me on, and it was an honor, and you did a great job on the stream.
Always, and nobody expect me to do another trial anytime in the near future. And probably the Melly trial will be the next one when we redo that within 90 days. All righty. That's it. I'm going to work. I've got 15 minutes to shower, change my clothes, and be in my desk, so I'm going to be late. Great. Gentlemen, thank you for sticking through this to the bitter, bitter end. Thank you to all 750 people that are still here. Thank you to everyone who has supported me, who subscribed and liked all of my guests that we've had on this past week. We'll see you all in the near future. Mods, thank you so much for sticking through this and being mods this whole week, long drawn out days. Appreciate it. Support, thank you so much for the support. Vice Squad chat, awesome as always. Like, subscribe to everybody, do all the YouTubey stuff. I am out of here. Goodbye, everybody, until we meet again.